Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
This is an excerpt on February 28, 2020, 7:44 p.m. How, does the FBI find people, and people is misspelled P-E-O-O-P-L-E. Did the defendant find out how the FBI finds people in this case? Oh, she found out.
All right, I have a little bit of a confession for you guys, which I think once I tell you this, it will change all the intros from now on. A little confession for you. First of all, welcome to the Court of Public Opinion. I am the Recovery Addict. I'm feeling rather small today. Feeling small. We'll see if we can get that fixed. Where are we at? Right there. Good. I'm feeling better now. True confession here. As soon as I go live, as soon as the seat command starts working, the sound effects also start working. I'm just saying that. So it may be sitting there silently with just my logo. That may be your moment to get your sound effects played on air, because no one's done it yet. So there's no timeout, there's no timers winding down for a certain sound effect. Now you know. Once you know, right? That's love true confessions. When are we going to break for lunch, says Kim. Kim, I'm not sure if you missed it. We just barely had lunch. Just barely. I apologize if you missed it. We will have lunch. We'll have lunch tomorrow as well. That I can tell you. So I revealed the secret. Now you know. Now you know the sound effects work. As soon as the C command works, they're on the same software. I still don't have the judge's sound effect working right just yet, but here's what we're doing. We have two cases. We're sort of in the middle. We're jumping back and forth between Thurston County, Washington, which has a hearing that the judge does not, a court case the judge does not want to hear. She's literally advised everyone, she's like, can't you guys just come to an agreement and not come here to court with me? Can't you just figure this out and not charge him with something? And he's 16. It's not a DUI. I've seen you guys come to conclusions on DUIs. This isn't a DUI. Can't you do something? I'm going to give you 15 minutes to confer. She's back in court. We're going to pick up where we left off. I don't know how this ends. I don't know if it does end. I hope it does. I have not watched this, but I'll be watching this with you. So we're going to pick up right where she left off. When we did leave off, we had a little bit of an issue with the live stream where her delayed live stream was played back in court. Her own live stream, not mine this time, thankfully. Not mine. But it was her own live stream. And we were just... let's see, let's back up just a little bit. Get ready for camera 2. There we go. So yeah, we're picking that right up where we're at. So audio, we're good. Did we get the audio fixed? She's looking at the clerk. Are we good to go? Can we start over? Don't screw it up this time.
Back on now on Zoom, live streaming and recording. So hopefully I won't have to listen to myself again.
Yeah, that was awful.
All right, amended complaint is accepted. So it's going forward. Back on now on Zoom.
What? You've got one job. You've got one job.
There's something that's asking to play back. Well, looks like we've got technical difficulties, so we're just going to contact Blaine, see if he's got an idea. So we'll just take a break until we can get it figured out.
We're taking a break, apparently.
Is that where you're headed, Blaine? Okay. All right. Try and get that solved.
Yeah. Because we can't hear the judge twice. Well, it's
you
good.
You know where I'll be.
You'll be right there in that seat.
It's going to take that long. Who knows?
Down at the bar, where I have no clue, Judge. Honestly, I'm not insinuating anything.
So
where do you go on break?
Be a little while. We'll have our administrator or IT come over, so it's going to be a while. So if you have any exhibits, I know there was one from defense. Just make sure that gets marked and shared. If there are any stipulations to exhibits, we'll talk about that. But we're not on record, so we can't really do anything.
Oh, you're sort of on the record,
It'll
Judge.
be a while.
Judge Bales. This is a good time to say, Kim, Kim, congratulations. Thank you for being first in chat today. This afternoon, you were first in chat. You were first and second, I believe. Adam Nusky was a close third.
I think we're also going to bring in.
Ooh, she slammed that door.
Are they duplicates? I would assume so.
Mics are still on.
And nobody else is using the defensive exhibit of the map. Okay, so the map you don't have an objection to? No, we don't have an objection to the video. Has he given you the map? Yeah. Okay. And then we also have like a screenshot of like a Google Maps like road side thing that because our paralegal is out today, we haven't printed it. But Corey said we could do that in the afternoon. Okay.
Okay. Anything juicier than just printing an exhibit? We don't have any like hot mic courtroom confessions going on.
Flash drive.
Sorry, for marking.
Once it's marked, though, you can't take it back.
Right. Yeah, I have a.
So you're not going to be able to have the officer authenticate it if you give it to her.
Oh, not even for officer authentication. Okay, so
no,
wait.
Once exhibits are marked, they have to stay with the clerk. You cannot take them out of the courtroom.
Well, that's fine. I was going to see if the officer would just authenticate it in the courtroom before the jury is called in. But we can also wait. That's no problem.
Yeah, don't take evidence from the courtroom once it's marked.
Yeah, I know.
As smooth as possible to get that.
Kim, the internet's all yours. You know what to do. Congratulations, first in chat. Okay, we're gonna try to skip ahead. I want to see if something happens here. They're still on break. Oh wait, no, the judge is back. Hang on, I see her. She sat down. Okay, she comes in about right here. Okay.
Thanks. Please be seated. Try this again.
Wow, that used to be a lady there.
Like.
Now it's a guy.
So we're on record again and live streaming. I think we solved the problem. So we're back with Mr. Wakeman. All right. Let's see. I've got some defense and state motions in limine.
And Your Honor, I think my understanding is Mr. Wakeman does need to be arraigned still on the new amended charge. Or I'm sorry, amended complaint.
Okay. You can just simply accept that and waived arraignment. I misunderstood. All right. So.
And I'm sorry, and we'll just be asking the court to enter a plea of not guilty to the
okay. All right. We'll accept that, waive that arraignment, continue that plea of not guilty on the reckless driving charge, moved on to trial today.
There we go. Reckless driving. We finally found out what it was. Reckless driving. 16-year-old reckless driving. I think it's a repeat offense.
From the state, you got those marked if you have any?
We don't have them marked, Your Honor, but after we're done with this morning, we'll make sure we get stuff to the clerk for marking.
So we know what we're talking about, because frankly, if we're going to come up in motions in limine, we need them marked. So if they're going to come up.
The states review the motions in limine, and I'm sorry, Your Honor, Corey Thompson for the state. The states review the motions in limine from both sides, and our communication with defense counsel. I don't think there's going to be any issues related to motions limiting and marked exhibits.
Okay. Just so well, you've got one exhibit that you worked on getting marked.
Your Honor, the defense has 2 exhibits.
All right. And so you've shared those with the state and
yeah, those
the state would stipulate to those being admitted.
Okay, so the 2 defense exhibits are stipulated for admission.
And defense is well stipulating to the exhibit provided by the state.
For admission?
For admission.
Yeah. Okay, all right.
And then because ours aren't marked yet, I'll articulate that. That's, I believe, like about 55 seconds of the video, the dash cam video. So a few more seconds up to him walking to the car.
Okay.
And then a still Google Maps street view. And that was it.
So 2 for the state. So again, that's why we get things marked so that the record is clear what we're admitting. But right now we've paused for a moment for the issues there. We'll see. Sure.
We pause now for station identification. You're watching this on the Recovery Addict YouTube channel. IT's here. He's got the lanyard.
It's walking up to the car. Yeah. What time stamp is it walking up?
Got it. Okay, so you see that it's the previous case and none of the, I see what you're saying. Yep, okay, that's no objection.
You can hear yourself and you can hear them. Just that.
I think everything else is crap.
This is a very noisy courtroom today.
I think that there's no audio.
And the values. What's the
Of the audio there? Yeah, right. Yeah, agreed.
Well, the issue is that I couldn't speak because I was speaking again.
Yeah, I saw that.
So somebody has the output of YouTube connected to the input of the courtroom microphones or sound system. That's all it is. Might be a laptop that's monitoring that has the sound on. Just turn the sound off and you're good. The Brown Barn. This room, this is like a converted room. They started using it at the time of around COVID.
All right, let's see. We'll soldier on here and make sure we don't have any technical difficulties. Got Blaine to help us out. So again, let's get those exhibits over to my clerk, get them marked so we can get them, and I can sign off on admission, and then we can talk more sensibly about what numbers they are. So we've got some exhibits to mark.
Your Honor, we don't have the video
at
this. Yes, I'm sorry. I should have clarified. We'll have those marked before we begin this afternoon.
Right. So we're going to probably call them states 1 and 2.
Yes, Your Honor.
And one is dash cam video from your officer, and the other is
a Google Street Map view of, I guess, the area in question.
And those are admitted. And then defense, your exhibit.
Well, it sounds like, so defense exhibit 1 for the video, it was going to be the first 43 seconds of that same dash cam footage. It sounds like the state is offering the same footage, only just a bit longer. And if that's the case, it would include the first 43 seconds defense was going to offer. So I don't see that needing to be a separate exhibit at this point.
Okay.
And I do have the 43 seconds here on a USB flash drive. I don't have the any more of the video, so I can't provide the rest of the video.
Yeah, we have it.
Okay.
Sounds like we have an agreement here. Any other? You had another exhibit.
Yes, Your Honor. The other exhibit would be it's the poster board over here of the Google satellite image map of the road in question here.
Okay.
Which a copy of the image itself was provided beforehand, and I don't believe there's any objection to that, but the poster itself I'll be asking to be admitted.
And the state would stipulate.
Okay, so then what do you want to mark? You want to mark your just that?
Yeah, so I'll just mark the poster board.
Okay, so that'll be number 1.
Number 1.
In this Savannah Soto
All
Matthew
right, so all those
arrest, was that the mom that was arrested?
Before we start the afternoon, just so we can.
It'd be interesting if the mom and the dad were involved in that one.
As to motions in limine,
You're on.
I guess I'm Mr. Stillwell. Anything in particular?
Yes, Your Honor. The only state motion in limine that the defense will be objecting to is motion in limine number 10, prohibiting any reference to the defendant's age, as this may constitute an argument for jury nullification and relevancy issues. I believe defense is entitled to introduce some basic facts about my client to the jury. I don't believe me saying how old he is me tempting jury nullification. I think I have a right to introduce some basic facts about Mr. Wakeman.
Who's running this case? I mean, I have one lawyer on that side. You can consult with each other, but Ms. Mann, if she's the attorney, we're going to have Ms. Mann.
She will be, Your Honor.
Okay, so I'm not going to hear from you, Mr. Thompson.
Correct.
If you need a recess to talk to Mr. Thompson, I'll give you that if it doesn't get too crazy and we can't get anything done. But Ms. Mann.
Your Honor, age doesn't have any relevance to the crime at hand. It's clearly prejudicial, and it does encourage nullification. I think inherent in all of us is a desire to let younger teenagers kind of be teenagers, and I'm sure that'll speak to at least one member of the jury.
So how is it clearly prejudicial and fairly prejudicial?
Inherent in being a teenager is the thought that you're going to be a little reckless. You're going to maybe act thoughtlessly,
And I think all of us want to give teenagers that license to do that a little bit. And I'd rather not have the jury be thinking about that when we're thinking about the danger of reckless driving.
And so nullification you're concerned with in what way?
That it will be an excuse for the defendant's actions.
That you confer with counsel.
Is it prejudicial?
And just most importantly, that it's not relevant at all to the crime at hand.
So state's motion in limine number 10 is denied. I don't find it unfairly prejudicial. I don't find it leading to jury nullification any more so than
interesting because the judge
17-year-old,
had the same
18-year-old,
argument.
19-year-old, 20-year-old, and I think the defense is able to introduce their client as to who they are. I don't find either of those bases. So 10 is denied. And then there aren't any other objections.
Correct.
And then as to yours, anything in particular that we should be focusing in on?
Your Honor, if we could focus on defense motion in limine number 7, that's a motion in limine precluding reference to any prior bad acts under evidence rule 404B. Specific in this case, Your Honor, I believe there was allegations that Mr. Wakeman was driving without a license. And my request under motion limine 7 here is to preclude any testimony to that effect, as he has not been cited for driving without a license. I don't believe it's relevant to the charge of reckless driving. It doesn't go to any of the elements. Additionally, I do think that would be prejudicial, as it is a separate and distinct bad act that I think would suggest to the jury that if he was driving without a license, then it may be more likely that he was also driving recklessly. So I think it's unfairly prejudicial. Again, especially considering there hasn't been any evidence presented of him driving without a license. Just some officer comments from this case that was the case. So asking for exclusion of any testimony about him driving without a license.
This is interesting. Let's see if they win this. I think that's a valid.
Your Honor,
404B.
the officer testifying about it will be its own form of evidence. And furthermore, it speaks to the recklessness of the act if the defendant was driving without a license. It's part of his character, and it should be something that the jury can consider.
Part of his character.
Not character. Prejudicial.
Sorry, not character.
Yeah. Whoops.
His status, Your Honor. Similar to his age in this case.
I think this should
so
be
your intention is to have your officer testify to that issue.
Yes, Your Honor.
And then if I may be heard in response.
We're just in a moment here.
This court, we have a lot of brand new attorneys.
Thank you. I do think here that the counsel's comment that it speaks to his character, although corrected there, I think that does also kind of show that this is a propensity type argument, that it maybe speaks to bad character, a propensity to do wrong acts that's excluded under 404B. The elements of reckless driving have nothing to do with the status of someone's license, whether or not they have a license. That doesn't go to the elements of reckless driving. I think that would clearly just be used only to layer on something else that Mr. Wakeman did here that may have been wrong, but unrelated to the crime charged. And considering it is irrelevant to the elements of reckless driving, I think it can only be used to prejudice the jury against Mr. Wakeman. And that's the whole point of excluding evidence under 404B, evidence of prior bad acts.
Anything more, Ms. Mann?
Good argument. I think the judge should side with defense here.
So driving while suspended is not charged. Driving without a license is not charged. Those aren't part of the elements of reckless driving as to whether a person is licensed or not. It's whether they're willful or wanton disregard for the safety of persons or property. I would find that would be potentially seen as unfairly prejudicial to Mr. Wakeman to bring that in. I don't find it relevant. So your officer then should be instructed that you'll instruct him and make sure that he doesn't, and you don't ask questions that put your officer in a tough spot or a confusing spot, that he goes there, or he or she, we have, about licensing. All right.
Okay, so this can make or break a court case right here.
I jump to
these motions in limine.
Yes, Your Honor. One more, sticking with motion limine number 7. I believe the officer notes in his police report that he activated his emergency lights at a certain point here. And similarly, asking the court to exclude any testimony about when he activated his emergency lights. I think the implication of that being that Mr. Wakeman saw lights and disregarded them. I think that is an inference of another crime that's, again, not charged here, eluding or attempting to elude. I think if the officer testifies that he activated his lights and Mr. Wakeman continued to drive off, that's an inference of eluding. It's not a crime charged. Again, doesn't have any relevance to the elements of reckless driving and could only be used to prejudice the jury if they're thinking that an officer had his lights activated and Mr. Wakeman didn't yield to them. Then I think that is an inference of a different crime that is not being charged here and could therefore sort of be used to prejudice the jury that maybe another crime happened here that isn't charged. And so considering that the timing of an officer activating their lights doesn't go to the elements of reckless driving, I think testimony to that effect would be unfairly prejudicial.
Good argument. Not sure if he's going to win this one.
So
though.
just the
timing of the lights.
Testimony of I activated my emergency lights, and then what occurred thereafter, or just that phrase?
I think the phrase that any testimony about him activating his emergency lights, I think considering that the state is introducing the dash cam footage up until Mr. Wakeman is pulled over by the arresting officer. I think it's clear that at some point he does activate his lights. Mr. Russell does yield to him when the officer comes directly behind him. I think testimony about when those lights were activated may infer that some eluding may have occurred when that's not a crime charged and there's no real evidence to suggest there was eluding police officers here. But I think testimony that from the officer that he activated his lights, at one point and then continued to observe Mr. Wakeman driving, I think suggests a different crime of eluding a police officer. I don't think when he activates his lights is relevant to reckless driving, but I think any testimony about when he activated his lights could only be used to prejudice the jury, inferring that perhaps Mr. Wakeman was continued driving after emergency lights were activated. We're not disputing that he was ultimately pulled over. We're not disputing that he was the one driving the car or anything like that. So I don't think any testimony about when the officer activated his emergency lights for the purposes of pulling over Mr. Wakeman is relevant. Could only be used to prejudice the jury.
Sorry. All right. Ms. Mann?
Your Honor, the state's entitled to tell the factual events of what happened on that day, including when the police officer's lights were on. The officer isn't going to say that the defendant was attempting to elude him, just that he activated his lights. Furthermore, we're going to be discussing the dash cam video. Part of that is it turns on automatically when a police officer's car lights go on. I think that's important context to when the video started and what the jurors are going to see in the video. And furthermore, there's no case law to support Mr. Stillwell's position about excluding the lights.
So you're expecting that you will not be asking, nor will your witness be testifying that the defendant was trying to get away from them in any way like that?
To be clear, based upon we would expect. This is like.
To be clear,
the
officer will be testifying that the defendant continued to drive after he had activated his lights, but I can promise to instruct my officer not to say that he was eluding him.
Because he can't drive away.
But factually, he did drive away from the officer after the lights were activated.
So the idea is that kind of an offer of proof here is that there would be potentially you're going to want to get into testimony that I turned on my emergency lights and the other car continued to drive, but not making the opinion or conclusion that he was eluding or attempting to get away from the officer.
Yes, Your Honor.
Okay.
Well, I'm sorry, Your Honor.
That's what actually happened.
Maybe that's it.
We can all hear you. We can hear you whisper. You might as well just be a sock puppet, because this is funny. Now I realize a brand new attorney, first day. This is you don't know what questions are going to be asked. This is probably hugely nerve-wracking for her. This is probably her first court case. We've seen a couple first appearances here for counsel, and it's court class 101.
Counsel for the state is
PNW,
finished. If I could
this
just be
better
heard
than anybody.
in response.
Sure,
Thank you.
I'll turn to you.
Your Honor, factually what happened, according to our officer, is that the defendant did drive off after the lights were activated. That may imply that he saw the lights and drove off. Maybe he didn't see the lights. I believe our officer should be entitled to describe that to the jury, regardless of the kind of conclusions that they could draw from that description.
Mr. Stillwell?
Your Honor, that's an allegation of eluding. If the officer testifies that he activated his lights and then witnessed Mr. Wakeman pulling away from him, that's testimony of a different crime that is not charged here and doesn't go to the elements of reckless driving. And therefore, I believe that would be unfairly prejudicial to
good argument
to Mr. Wakeman here to have evidence from testimony from an officer that a different crime may have been committed that's not charged here, but that they should, that just gives the jury maybe a backdoor reason to find Mr. Wakeman guilty of something that's different than the crime charged. And I think that's unfairly prejudicial. If the state wanted to move forward with an eluding a police officer charge, they could have, but they didn't. And I think it's unfair to elicit testimony about a crime that's not charged here for the purpose of trying to build a case for reckless driving. It'd be one thing if eluding was lesser included or had similar elements here, but reckless driving is, it's willful or wanton disregard for the safety of persons or property. Have a testimony from the officer that Mr. Wakeman was pulling away after he activated his lights. That's a different incident that doesn't go to those elements of reckless, and I think it would just be used to be prejudicial.
So as to, kind of further defense 7, that's where we are still. I'm going to allow the state to talk to facts, to have their witness talk to facts, not to then opine or draw conclusions while testifying about what the facts were. Activated my emergency lights. The car kept driving away, whatever it was, but not to say, well, he's now eluding me, interfering with my ability to stop him, trying to get away from me. Any of that would be speculation, and that would be not allowed. I do find it goes to potentially, I think the jury can hear the facts and draw fair inferences and conclusions from those facts. Weighing this, the probative value, I believe, overcomes any unfair prejudice to Mr. Wakeman. But again, cautioning and being very clear, and I think this man is hearing me, a witness is supposed to give factual testimony, not, wrap it all up in a conclusion. And that would be improper. So just make sure that you talk to your witness beforehand and don't ask questions of your witness such that you'll be eliciting something where they would respond with a conclusion of eluding or conclusion of trying to get away from them, speculating. Anything else, Mr. Stillwell?
Your Honor, one more point on that. Yeah, I believe I heard counsel mention the phrase pulling away, that Mr. Wakeman was pulling away from the officer after he activated his lights. I wonder if we could get a ruling that specific phrase not be used, as that seems to infer that he was pulling away from the officer. That's testimony about Mr. Wakeman's intention as a driver. I think that's different than the officer saying, you know, at this point in time, I activated my lights and I observed the car, continuing to drive. I think is different than the officer saying, I activated my lights, but Mr. Wakeman pulled away from me. I think that specific phrase carries a certain degree of suggestion that this was.
I see what you're saying. I don't agree. I think it can be seen in many ways, and I think there can be lots of cross-examination. There can be lots of discussion and argument about how the jury
Good call by the
take
judge
that.
there.
I think that's parsing the English language a bit too much for anyone to deal with. So, I wouldn't allow the fact that was to start pining as to eluding, trying to get away from me, putting thoughts in the minds of the driver in front of them. All right, now anything else?
Your Honor, just one final point here. Mr. Wakeman, after being detained by the officer here, the officer did ask some questions of Mr. Wakeman, and there was a conversation there. This is when Mr. Wakeman was under arrest and prior to being Mirandized. There's been no 3-5 hearing in this case, so I'm also asking for a ruling here that there be no testimony elicited regarding Mr. Wakeman's statements to the officer.
Also, any admission of guilt.
Maybe I'll ask this man, are there statements from Mr. Wakeman that you're intending to try to introduce through the officer or in any other way?
Not at this time, Your Honor.
Well, this is the time.
Yeah.
Now or not?
Potentially in rebuttal.
I'd like to be able to reserve the ability to do that in rebuttal if it comes up during our examinations of the officer.
Well,
and
then
becomes
we're going to be
relevant.
set with a 3-5 motion, and we're in the midst of trial. These are things I really like to get done beforehand. So why don't you sit down and figure out if there's some statements that you would like to bring in of Mr. Wakeman right now, and then we can deal with it as best we can now.
Thank you, Your Honor.
To be clear, 3-5 is not applying if the defendant testifies. The state would only introduce the statements if testified.
I love this. Okay, so this is a welcome everybody who came over from Brandy's channel. Brandy is one of our favorite streamers. We love her. Thank you so much for joining us. Appreciate that. Hope the stream went well this morning with Brandy.
3.5 hearing isn't located if the defendant testifies.
Okay, I've got to see what this 3.5 hearing is. This has got to be like a Washington thing.
That's it.
Okay, gotcha.
They're no longer constitutionally protected then.
I'm not a cat.
Okay. A hearing to determine if any statement of guilt by the defendant can be used as evidence in trial.
Your Honor, the state's not intending to introduce any of these unless the defendant testifies and we bring it in as a prior inconsistent statement, in which case 305 wouldn't be implicated. 3.5.
All right. I think that kind of solves it if there's a rebuttal case, potentially. All right.
So now the defendant can't testify.
Anything else, Mr. Stillwell?
If the defendant testifies, it comes in.
Okay, and then jumping to Ms. McMahon, didn't know if there's anything in particular otherwise.
Yes, Your Honor. The state would like to object to number 3 and number 10 of the defense's motions eliminate as they're too broad.
Let's talk to one at a time. Number 3.
Any questions over whether or not a crime has occurred. That's a pretty key part of the officer's narrative of why he pursued the defendant, what he observed. And furthermore, there are, sections of what he observed, like speeding, that might constitute, breaking the law, but doesn't speak to the ultimate conclusion of reckless driving.
And so you expect your inquiry and testimony to be generally what in this arena?
I'm sorry, can you repeat the question?
What do you expect from your officer in this arena?
I expect the officer to recount what he saw that day, which is the defendant was speeding, he ran a stop sign, he was driving irresponsibly in other ways that are not in themselves a conclusion of reckless driving, but might constitute violations or crimes that I'd like him to be able to talk about.
And do you think he's going to be saying, I'm investigating whether there are crimes or other infractions committed? Is that what you're trying to get in, or?
Infractions, yes. Crimes, no.
So will you be asking questions that might elicit, often prosecutors ask, so why'd you pull him over? And then you get a factual dissertation, and you trying to, because really for this officer to say, well, I thought reckless driving was committed, and that's why I went about my business, or he did commit reckless driving. Where are we on that?
I understand that conclusory statements like that from a witness are not permitted, but I would like my officer to be able to describe what prompted him to pull over the defendant, what alerted his attention.
Okay, so I should start with Mr. Stillwell, but I wanted to see what statements in particular. Your response to number 3's objection.
No, Your Honor. Motion in limine number 3 gets at prohibiting the officer from concluding that he believes the crime of reckless driving has been committed, as that's a question for the jury. I understand that he's going to testify about the reasons why he felt it necessary to pull over Mr. Wakeman, and we're not going to be objecting to those. But we would be objecting to his testimony about the ultimate issue, which is that whether Mr. Wakeman committed reckless driving, which I don't believe he's allowed to testify about. And that's what motion in limine number 3 gets at.
Okay, and I think actually we sort of agree there. We do agree. And so in that way, that's how it works. So I wouldn't expect you to be asking questions of that witness to say, so what crime was committed here, or try to put that witness in a difficult spot there, or then you'll also talk to your witness about that. That it's factual for the jury to determine what crime, if any, is committed. But I'll give you pretty leeway on to talk about the facts and why, and so we don't get into a conclusion that's the purview of the jury. Number 10, the state is objecting to defense 10. How is this? So help me understand how this is different, Mr. Stillwell. Sound awfully familiar. 3 and 10. Let's kind of maybe fleshed it out a little bit more.
Your Honor, perhaps they could have been combined into a single motion. They're both 3 and 10 are getting at prohibiting the witness from opining as to the ultimate guilt of the defendant. It's essentially the same purpose notes, number 10.
Okay, I think probably could shorten.
Yes, future reference. Thank you.
Put them together, and then you have that's what you're thinking, Ms. Mann?
Yes, Your Honor.
Objection, and I would agree. So I think 3 and 10 are the same issue, and so we won't have them opining on that. And give direct or inference and opinion of the accused guilt.
Okay, we're done with the.
Ms. Mann, any other objections to 10?
Yes, Your Honor. For number 5, we're just concerned that it's overly broad. There are hundreds of exceptions to the hearsay rule. If it becomes relevant, we'd like to be able to use them.
I think what I understand, Mr. Stillwell, if I do, and tell me if I'm wrong, if there's a witness that's not being called and not present, and trying to get the witness who's on the stand to testify to, saying, well, I talked to them, and then I made this decision and so forth, in a sense, not allowing anyone to cross-examine that absent witness.
That's correct.
Do we expect there's going to be, is there another officer that was involved or something, or another witness that isn't being brought by the state, or somebody else?
The state isn't planning on calling any pedestrians who witnessed or the other passenger in the car, Your Honor.
But they didn't give statements?
No, Your Honor.
Okay, so do you know of anyone from the discovery that you're worried about there, Mr. Stillwell?
No, Your Honor. Number 5 was included in the event that the officer, because I believe some other people from the area ultimately did speak with the officer about what they observed. There's some on the dash cam footage. You can see some people in the park, and so the attempt there, when they were not listed as witnesses, and so number 5 was included to make sure that the officer doesn't try to testify about what other people who were there that day may have told him.
So the officer in this van did talk to folks in the area, apparently.
Yeah.
I don't believe there were any witness statements or nothing to that extent where it was that formal. It does appear that there were some other people in the area that day who may or may not have talked to the officer. And I just wanted to make sure that any statements made to the officer aren't coming in through him.
By other folks.
Yeah.
So, ma'am.
The state doesn't have a plan right now to introduce any of those statements. People were there, they witnessed it, they spoke to the officer afterwards, but we're basing this on what the officer himself observed.
Okay. All right. Expect an objection if need be on some of that. Anything else, Ms. Mann, on defense motions?
We would object to the phrasing of number 6 and ask that it apply to all parties and witnesses.
Yep. So, just the idea that testify from memory using refreshing recollection if you need to, if you can establish that. Both of you are looking at that on 6.
Yeah, Your Honor, number 6 is intended just to prohibit the officer from reading directly from his report in this case.
Always more credible anyway. They're not sitting there with a report in their lap. They're prepared to report. They have a memory that's independent. So I would expect that. And then, of course, if there's a need, if you can establish that there's a need to refresh recollection, we'll follow those procedures. 8.
These are the rules the court has to, the teams have to abide by.
Yes, Your Honor. Our last one is number 14, just as overly broad, rebuttal evidence.
There you go. Yeah. I'll hear about that, I'm sure, from both sides. All of a sudden, one of you brings up something that you didn't tell the other. We're going to hear about it loud and clear. So,
yep, should have been revealed in discovery.
And I suppose number 14 could be fleshed out more. That's if there's rebuttal evidence being offered, I understand that's under the rules that's allowed to be presented, if not in discovery. No objection there.
Right.
This is speaks more to direct evidence, not on.
Yep. These parties can make their objections appropriately. So, all right. And then as to your state's motions and limiting anything in particular, we already talked to Mr. Stillwell about one objection, but anything in particular that?
No, Your Honor.
Okay. All right. So we got a lot of things settled there. And stickies.
Judge needs a sticky note.
I left my note. So, when is our jury available this afternoon?
Jury this afternoon? 2:30?
Essentially.
Okay, so it's jury trial this afternoon. That's good. We're just a couple minutes late on this one. This happened during lunch, so we're just catching up. Maybe we might be able to jump ahead to the
All right,
trial.
so our jury will be available by 2. Jury pick, just give you both 20 minutes to do what you need to do, and that's in total. We're not going to jump back and forth, use it. And then opens 10 minutes, close, well, complex case, 15 for each side. That includes state's rebuttal if you decide to do that.
This is going to be the fastest case.
So I will pick an alternate juror.
I'm young. This is funny.
Always. And remember that as to an alternate jury, you each have a extra peremptory as to that one in particular. And if we get through it all and we don't have another person, then we will pick an alternate juror. But if we do, then that last one, each of you have a potential peremptory to exercise there. And then, so we'll have them seated behind you, and there'll be about 20 some people there. And how I do it is I'll give my introductories, ask several questions, who knows who and all that sort of thing, and then turn it over to the state to ask their 20 minutes, and then Mr. Stillwell in 20 minutes, or however much time you want to take. And then I'll have Mr. Stillwell as client, the state come up, and we'll go through first the whole group per cause, if there's any, the whole pool. And then we'll get rid of those causes if there are any. And then we'll concentrate on what's left. The first 6 that are left are your presumed jury. And within that crowd, we'll start with preemptories and see how it moves, if it does. And then you each have an opportunity for 3 preemptories, not necessarily 3 preemptories. So got 6 of them here. That's our presumed juror. And I say, man, you have a preemptory? Nope. Mr. Stillwell says, yep. And we move down. You've used your preemptory. Each of you have in that way. So 3 opportunities. So, and then once we get them picked, then we'll do
a little munch and mingle. Little
openings
lunch,
as soon
open
as
bar.
later this afternoon, depending on what the time is. And you'll tell me, Mr. Stillwell, at the time, if you want to do an opening then or reserve it later, I'll just ask. And you'll make that decision as you go, or unless you know right now. Absolutely. I don't hold you to it.
I'm prepared to give opening today, but I'm also perfectly happy to see where we're at.
After the case in chief of the state is what I meant.
Yeah. Oh, I'm sorry. Yes.
Reserving it.
Oh, I see what you're saying.
Yeah.
I'm sorry.
That's what I mean.
Yeah, okay. Yeah. At this time, Mr. Wakeman doesn't intend to testify, and defense doesn't have any other witnesses absent any need for rebuttal or for inconsistencies. But when the state rests, defense will be prepared to move forward at closing at that point.
Okay. I always once the state rests, I always just try and take a 10, 15-minute break and give you a chance to talk to your client about what to do next. You may already know what to do next, okay. But I always like to take that break and just remind me that I said this, that I will say we're going to take a break, and then that gives you that time to kind of cogitate, figure out what steps next. Right. And then you'll let us know, and then we'll bring the jury in and let them know, and we'll go from there. But just remind me, because I want to be sure to give you that opportunity. Let's see. I've got proposed instructions from everybody. That was great. Thank you. Make sure I've got all the witness names down right. So Deputy Dustin Leishman, it is?
Leishman.
Leishman.
This is going to be like a one-day trial. It's going to be quick. Jury comes in at 2:00. They get picked at 2:00. We get to watch the jury selection. Those chairs there in the back of the courtroom, that's where the potential jurors will be sitting.
No, Your Honor.
To watch the whole
Mr.
process.
Stillwell, anything else?
Nothing terribly formal, Your Honor. Just a question. Mr. Wakeman does have some family and friends who'd like to attend. When the jury panel is here, is there a place maybe they could sit on the sides? Would it be appropriate for them to? Yeah.
Teresa, do we have, how many do you don't know how many jurors we have right now, do you? I don't. Okay. So maybe, how many folks?
Just the 3 who are present here.
We could just put 3 chairs somewhere.
Reverend, spill the beans. I missed it. What did 90s Music Band post?
Just not too close to the jury. Sure. Sure. That's a good idea. So it's not the most comfortable spot up against the wall, but it won't be all day. After that, we're done with the jury, then that'll be the audience section, and you'll be back there if you want to stay. So it's not the best courtroom, not the best facility, but we're doing it. So yes, so that's what we'll do. And then of course, if anybody else comes in, there's another chair over there. Anything else?
None, Your Honor.
Okay. And obviously those folks, you have no intention of calling even in rebuttal?
No, Your Honor.
Okay. All right. Yep. Orientation. Okay.
All right.
What time do they do that?
Amanda, we're going to see the jury members. Yes, we'll see everyone. This court does not keep jury members secret. We'll be watching them.
So they'll be done with them, and then they'll take a break from 11:40 or 1:45, and then we'll get them at 2. Okay. Make sure that everybody takes a potty break before, because I don't want to.
Okay, guys. Apparently, the judge is ordering bathroom breaks before trial.
And then we won't get the jury questionnaire packets until we get the jury, but as soon as you can get those, if you could just put one on each counsel table, and as soon as Ms. Garza has them, she'll get them out to you to look at. So as soon as they can give them to us. A lot of times they can't get you an earlier packet because people come in and haven't filled it out. And then all of a sudden they've got these people in their hands and they're filling this out. And so they can't put the packet together for
Guys,
you.
fill out your jury packets
as soon as
before
it's
you go to
available,
court.
we'll get it to you and I'll try and give you some time to look through that. Me too. All right, I think that's it. So let's all be back at 1:45. Realize that the jurors will be collected in here, so don't come on in here. Kind of check with Ms. Garza. Not quite sure where everybody's going to be.
They're just hang out.
And then just remember
by the
one
Coke
thing,
machine.
and I'll certainly tell the jurors this, that I've done this, is that each of the attorneys here are responsible for their witnesses, their for your client, for his contact with witnesses, contact with jurors, not to be having any contact with witnesses or jurors outside the courtroom here as allowed by the court. And you, of course, are both under orders, and you know this well, not to have contact with the jurors outside of the courtroom under the proceedings, or and just do your best to keep everybody separate, knowing that we have public restrooms out there. Try and be careful about witnesses or Mr. Wakeman using those. Jurors
Mr. Wakeman, if you need to go to the bathroom,
Once
you have to
we've
yell,
got a
any
jury
jurors in
picked,
here?
it'll be a
Before you
lot
go in the
easier
bathroom.
to deal with. But right now you don't know who they are, and there'll be lots of them, and they're going to be all over this. So I also would recommend that from now until we're back together at 1:45, you're not going to be able to hang in here. And
No hanging in the
you and your
courtroom.
witnesses and Mr. Wakeman and his family and friends don't hang out in the public areas of this building, because you're going to bump into everybody. And it's best not to have that going after all this strain and stress has to happen again.
Bumping after strain and stress is not
Just
good.
a reminder of that. We'll just be back at
Not sure why she said
1:45 and see where everybody is. Okay, thanks. Thank you.
All right, let's see if the feed is kept up. It is not, so we're going to jump back to this view here. Oops, sorry, give you whiplash. Let me get to the next. I think they're back now already, though. Let's see. Let's see where we're at. Go back. Go back. Let's see. When was this one done? This was. So that was 52 minutes ago. 1:45. So we've got about 12 minutes or so. We could catch up with. We can jump back to Tennessee for a minute and get a little further in that case, because we have two that we're going on, trying to get through both of them today. But we'll see. I don't know. What time? He said 1:45. That's Washington time. Oh man, is this a long break? We might be able to finish all of the Tennessee case before this comes back and we get the evening coverage. Let's see. I was in the bathroom, couldn't find any jurors. Knocked on all the stalls. Any jurors in here? Any jurors in here? Oh, Robin, that is no fun. Please stay safe and warm. Hope you guys get power restored right away. Oh my goodness. Iked Mel is 400 away from 200K. Wow. That is awesome. Iked Mel, good luck there. Congratulations. That's going to happen right away. That's in the next day or so. I think that he might hit it today if he's got a good case. Lanny, good to have you here on the replay crew. Hanging out with Brandy is always an acceptable reason to be gone. I do it myself sometimes. All right, that's 2 hours. That's in 2 hours. Okay, so we have enough time to follow the Tennessee case with Judge Wolfe. It's just motions in that second-degree murder trial. I feel like we're channel surfing. Oh, we are. We've got, let me see, where were we at? We're down over here. This is the court we were at. Let's see if we can begin this one and pick up where we left off. So this is the trial where, just a brief heads up, this happened yesterday. Tennessee, Judge Wolfe on the left. On the right, we have the defendant who's sort of hidden behind that post. He's on the right-hand side. His lawyer's there. The man standing up there is a prosecutor. He's about to make some opening statements of some sort, I believe. The defendant is charged with selling drugs to someone in another county, not Cheatham County, which is where we're at. Selling drugs to somebody in another county where they use the drugs in another county, used too much, overdosed, had a medical condition as a result of medical situation, was treated, was resuscitated, and somewhere in between taking the drugs and overdosing and being resuscitated and then later going back into cardiac arrest and dying. He was in Cheatham County. And so somewhere in the middle, he was in Cheatham County, and they're saying, we'd like to charge him for all the crimes here, even though he didn't sell the drugs here, the drugs were not consumed here, and the guy didn't die here. Okay, so they're trying to. This is an argument over subject matter jurisdiction, really, and he's going to start making the case. He's got some witnesses to present as to what I believe. This is just where the evidence happened. This is not the actual trial. This is sort of like a pre-trial hearing of some sort. So we'll see how this goes.
And Your Honor, the beginning of the state's proof is the 911 call. Mr. Atchison and I have already discussed this, and it would come in as an excited utterance, but it's going to allow me, I believe, for the purposes of this hearing, to go ahead and play it without bringing in the person in charge of 911.
If it's stipulated, the only reason to have a witness authenticated is if there's a question about its authenticity, so we'll allow it to be played.
Are we going to be able to see it, Judge? No. So the mom was also arrested in that young couple murder trial. Their bodies were found in the car. She was pregnant. Drug deal gone bad. It was a father and son that were arrested initially, and now the third person, the mom, has been arrested. It's even possible, I think some people are saying she may have been in the vehicle with them as they were trying to cover up the crime, hide the body. Wow, whole family responds to that
So, Your Honor, I'm going to begin with this, actually with the state's first exhibit, which is the 911 call. I believe the father would play this television as well.
This is one of the 911 operators here that we see on the screen.
No, actually, Your Honor, that's my daughter.
That's my daughter? Why do we have a video of, oh, I guess it's a screenshot.
Both of those your daughter, or only one of them?
Only the one who's still visible, Judge. Everyone's the last.
Playing the ukulele?
Yes, Judge. She plays the ukulele. I apologize. She plays the ukulele and the piano.
I'm not sure if this is relevant.
Okay, Your Honor, this is the state's first exhibit. It's the 911.
All right, so
state has the wrong.
It was just the screensaver or the backdrop, the desktop image on his desktop when he plugged in his computer, and the judge was questioning about who was on there.
Your Honor, the state is gonna go ahead and play the 911 call in a moment. I'm gonna start with Deputy Randall Smith, Mason County Sheriff's Office.
Say Randall Smith.
Yes.
The judge does his own camera work, apparently.
Okay, raise your right hand. Do you solemnly swear or affirm that the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
yes.
Give me that microphone.
Yes, ma'am.
How's it going this morning, Deputy?
Hey, Jack.
Please tell the court who you are and what you do, and spell your name for the reporter.
Deputy Randall Smith, RANDALL SMITH. I'm a patrol deputy with Thurston County Sheriff's Office.
Now, were you previously employed at the Cheatham County Sheriff's Office?
Yes, sir.
And were you employed in that capacity on October 3rd, 2020?
Yes.
Now, in that capacity, did you respond to a emergency call at Gates Lane here in Cheatham County?
Yes.
And when you responded to that, did you have a body worn camera on?
Yes.
Would you recognize the footage you've already showed?
Yes.
You might have to turn it.
The witness has to turn around.
Does this appear to be your footage from that evening that's here on the screen?
I think so, yeah.
Okay, let me play.
Until the door right there.
Fair. Let me, I'm gonna. All right, is this a correct copy of the footage from that evening?
Yes.
Wait. Do you have a little trouble finding the exact address?
Yes.
This could be really bad audio. A microphone picking up courtroom echo of a body cam. It's not going to be good.
Can you turn the lights down? Can you turn the lights on so you can see it better? Can you turn the lights on?
There's like no difference. Okay, lights are off now.
Second, which way is it again when you get back here?
Now, if CAD reflects that y'all's response took roughly 12 minutes from the call coming in, would that be reasonable or fairly accurate?
Yes.
Now, is the young man on the ground here, Jordan Knight?
Yes.
And is this in Cheatham County?
Yes.
I don't know what the hell you took. Hey, you got Dunkin' Donuts? Hey, now I'm running over here.
Are you administering Narcan?
Yes.
Now, at this time, could you tell if he was breathing and or his heart was beating?
I could tell he wasn't breathing.
Hey, you get off the phone and stay over here. What's his name? Jordan what?
Is he doing a sternum rub here? Trying to get some response. Realize this is a second-degree murder case, so we know the outcome of all these efforts ultimately, even though he was able to be resuscitated here.
Point 6, 997, CPR charges.
Corey from Tennessee.
I'll put it there.
Good to have you here, Corey.
Is that Cheatham County EMS responding?
Yes.
Judge, I'm going to have some of this video to play for EMS, but those are my questions for Deputy Smith. Mr. Atchison might have some questions.
Turn the lights back on.
Aziz, lights. So the white balance take effect here. Everything looks really yellow right now. Sneak peek on the judge's desk here. It's a little
Morning,
bit
Deputy
busy.
Smith. How are you? Morning. First off, let me start by commending your response to the scene. Deputy Smith, when you arrived, who was the individual standing outside the car?
I'd have to look back at my report, sir.
If I were to say the name Thurston Matthews, would that sound correct?
I believe the last name I remember.
Deputy Smith, when you arrived, was Mr. Matthews in the process of CPR?
Yes.
Was he on the phone?
He was on and off the phone, yes.
Any idea who he was talking to?
Not at first, no.
Now, I'm going to fast forward past your initial response. Where General Arnold stopped the video, you would agree that's where EMS is placing Mr. Knight on the medical journey, correct?
Yes.
After EMS has him loaded and has him secured, did you happen to speak with the male subject that was on the scene?
I did, yes.
And Deputy Smith, have you had a chance to review your incident report prior to this?
No, sir.
They called the cops on you playing the didgeridoo? That's awful. I can't play one, but they sound really cool.
Judge, may I approach?
No.
Deputy Smith, I'm going to hand you a document. Give you a chance to look over that for just a second.
In just a second, I said, put it down, sir.
Deputy Smith, do you recognize that as your incident report?
Yes.
Second paragraph. I have underlined a sentence. Could you read that sentence aloud to the court?
Tristan stated that Jordan asked where the bitches were at, and that then they traveled to 9th Street.
Deputy Smith, did you obtain a written statement from Mr. Matthews on the scene?
I'd have to look back and answer.
Do you recall if any statements were made by Mr. Matthews in regards to what Mr. Knight may have taken or may have ingested?
I believe, yes.
You do recall him stating, do you recall what he said?
He didn't state exactly what it was, no.
Okay. And when you leave the scene here at Yates Lane, do you in fact go to the hospital in Springfield?
No.
So your response ended here?
Yes.
That's all the questions I've got.
Thank you, Dennis.
Redirect.
No, Judge, that's it for this witness.
All right, thank you. You may stand down. Did you make an exhibit yet of this video?
I did not. I was going to introduce it after the next witness.
Well, it was his body cam footage, correct?
That's right, Judge. I'd like to introduce the video as the state's first exhibit.
We'll make it as an exhibit through his testimony. That'll be exhibit 1.
And I apologize to the clerk, but I'm not going to hand it to you.
That's fine.
Apologize to the clerk, but I'm not going to hand it to you.
Cheatham County EMT, former Cheatham County EMT, Christy Lane is the staff.
Okay, let me just say, Amazon just sent me an email that says, we found something you might like. And I just would like to say on the record, they are cheating. They have enough data about me from my searches and from everything I purchased. They know what I like. And them emailing me, telling me to buy more stuff, they know I will buy it. This is not fair. It is really not fair. If I overspend and blow my budget on Amazon, it is their fault because of effective advertising. Okay, I'm going to click. What is it that... Oh, I do want that. This is good. That is cool. I need one of these now.
Morning. If you'll raise your right hand, let the clerk place you on the oath. Let's go.
Do you solemnly swear or affirm that the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
Be careful for that, Church. Good morning.
Good morning. How are you?
Not too bad. How about yourself?
Good.
If you would please give us your name and spell it for the court reporter.
My name is Christy Farrell, Kristy Farrell.
Mrs. R.A. is literally doing finances as we speak. Like I'm getting emails of her paying different bills. And I'm still shopping on Amazon.
Oh, congratulations. Thank you. Now, are you currently an EMT?
No, I'm currently a paramedic.
These are one of those distinctions only the people who do it
at National Fire
are adamant about.
Prior to that, were you?
At Cheatham County.
And when you were working with Cheatham County Emergency Medical, did you have occasion to be in an ambulance that responded to an emergency at Yates Lane in Cheatham County?
Yes, I did.
Okay. Now, was that October 3rd, 2020?
I don't recall the date.
Okay. Well, let me ask you, would you be able to recognize yourself on video?
Yes.
If you wouldn't mind, if you'll go ahead and look at the exhibit.
You guys, I
What's his name? Jordan what?
I bought one for Mrs. R.A. last year, but I bought it from Starbucks for like
926, 997, CPR card.
$15.
I'll put it there. Steve Rose, stuff right
Is that you sort of facing the camera from our perspective?
Yes, and talking.
Okay. And so, do you recall roughly how quick y'all's response was on the scene?
I think it took us from our hall to there, it was like 10 to 12 minutes.
Okay. And fair to say, very quickly after Deputy Smith got there.
Yes, we were right behind them.
That guy had flatlines. They give him CPR. They're able to resuscitate
play
him.
a little more, and then I'm going to ask you what you guys are up to.
Sent 3 doses of Arcan. 1 from him, 2 from me. Where's the ball? Back on his. What is that? Jordan 9.
We're in a mini trial, and the trial is all about subject matter jurisdiction for a second-degree murder charge. We're watching CPR being performed on an overdose patient. I'll tell you how it ends. It was successful. At least they were able to revive him a little bit. It's a drug overdose.
Hey, stay in your car for a minute, okay? Please. Okay, just stay in your car. Just stay in your car. We're working on you, okay?
Let's say, so what are you guys trying to do in terms of while you're getting the patient into the ambulance and getting them to the ambulance, and then we're not going to be able to see what you guys do once you're in the ambulance. So run us through all that.
So we would have put him on our stretcher, did CPR the entire time, loading him in, and then ultimately put him on an auto pulse machine, which does compressions for us. So it's a machine that does the compressions that way. It won't tire out like the person would. So they're more likely to be exact and the compression rate that a person would need during CPR. While that's going on, we would put them on a monitor, obtain an IV, and start any medications that would need to be given.
Okay. And so you guys did all of that.
We did all of that. Yes.
And the machine that you guys put them on, that's actually in the ambulance.
It is, yes.
Now, I don't know if you noticed, did you also get some information on the scene about what had happened before?
Yes.
And what, if anything, were you able to gather?
We knew that he came from Davis County because the gentleman that was on the scene there with him told us that they had driven past the McDonald's in Jolton. So we knew then that's how far they had driven before they arrived on the scene. And I even asked when he went unconscious, and he did say somewhere around that area. So it gave us a time frame of how long he had gone without any CPR or oxygen.
Were you with Jordan the entire time he was in the ambulance?
Yes.
If you would, could you tell us what, and have you had an opportunity to at least review your run sheet prior to this?
I did, but it wasn't my run ticket, it was my partner's run ticket.
Sorry.
Carlos wrote the run ticket. He was the paramedic on the scene.
Got it. But you had time to review that.
I did. I did.
And do you pretty well remember this, frankly?
The call, yes, for the most part.
So what additional interventions can you remember doing in the ambulance?
I know that he got, I think, 8 rounds of epi. I think 2 additional doses of Narcan. He received amiodarone. I think he was shocked either 2 or 3 times.
Whoa.
And that was, if I recall correctly, that was before we left. We did 10 minutes of intervention before the ambulance ever left the scene.
Did you guys have somebody else drive so y'all can keep working?
We did. We had a firefighter drive us. That way Carlos and I could go the same back with him.
8 EpiPens,
Now,
2
do you
Narcans,
ever recall
constant
getting the same
CPR.
heartbeat?
I don't recall getting them. Well, we did have a rhythm on the monitor. We never actually felt a heart rhythm.
And in terms of the monitor, are there various things that could impact whether or not it reads something?
Of course, yeah. I mean, there could be just motion of the ambulance itself, vibration of the ambulance, any movement that the auto pulse was doing to the patient during these things. There's just a couple of different variables.
Gotcha. Do you remember if the firefighter was good at avoiding bumps?
Not all.
That's speculation.
Sustained.
Do you remember going over a lot of bumps?
Yes.
All right. Thank you very much. Is Lauren to have some questions?
Mr. Atchison.
Just briefly. That's okay. morning, sir.
Hi, how are you?
Better than I deserve. How are you?
She's
So
now
the
being
entire
questioned by
time
Dave Ramsey.
that this incident's taking place, when you arrived on the scene, you spent with Mr. Knight in some capacity.
Yes.
And I'm not sure if General Arnold asked this and I missed it. How long have you been an EMT and or paramedic?
Now it's 5 years.
5
I've been a
years.
paramedic for 2 years. And when I worked for Cheatham County, when this occurred, I was an EMT for 3 or 4 years.
And now, the questions that General Arnold asked you as far as what took place inside the ambulance, would you characterize those as everyday, normal life-saving measures that you guys do within the scope of your profession? You would not deviate from those no matter what the incident or the particulars around an incident, such as this or any other incident. Those wouldn't change, correct?
Correct. We would do all of the same things regardless of the patient if the circumstances of the patient's nature were the same.
And so whether or not someone is responsive or unresponsive when you guys arrive, your protocol and your procedures don't change. You would do those same life-saving measures for each individual, correct?
Yes.
And your response to General Arnold's question, you don't recall a heartbeat or a rhythm, correct?
No, I know initially he didn't have one when we felt, but
Right.
I don't recall him ever getting one back. But that doesn't mean that the monitor may have showed that he had a rhythm, but that doesn't necessarily mean you could palpate a heartbeat.
I got you. And so you also testified that you had some interaction with Mr. Matthews while on scene, correct? The male subject who was present.
Yes, he was who I was speaking to when we got there.
And it was his statement to you that Mr. Knight began to go unconscious, or whatever word terminology we want to use, pass out, unresponsive. The McDonald's and jolting,
Yes.
correct? You guys got a timeline of how far that was from where he continued
Yes.
to drive with Mr. Knight in this condition.
Yes.
Ms. Farrell, based on your experience in your profession, is that reasonable for someone to continue driving someone that's unresponsive?
Sustained, I don't know how she would, I mean, you're asking her based on her experience, whether it's reasonable for a person to take certain action. I don't think that's beyond experience and beyond anyone's experience to subject or to speculate on what's reasonable for one person to do or another.
Ms. Farrell.
That's a long sustain.
Based on your experience in your profession, the proper response would have been to call medical personnel at that point in time.
Yes.
Redirect.
No, Judge.
Thank you, ma'am. You may step down. Are we releasing her from her subpoena?
Yes, Your Honor.
You're released to go about your business. Call your next witness.
Your Honor, the state of Tennessee calls Carlos Elliott.
So the state here is just trying to prove that enough happened in their county that they have jurisdiction for this case. That's my understanding. They're just trying to prove subject matter jurisdiction. This is not the actual trial. So when the actual trial begins, if they do, if they prevail here and prove they have subject matter jurisdiction, then I guess then the trial can move forward. Love Judge Wolfe. We've watched him on a couple smaller trials. And we are in Tennessee with this, by the way. We're going to jump back to Thurston County when they come back live, but I think we've got a little
If you'll
bit of time.
step up in there and raise your right hand.
You solemnly swear or affirm that the testimony you give will be the truth, the whole truth, and nothing but the truth to help you God.
Good morning, Mr. Ayden. If you would please tell us who you are and what you do, or at least until recently did.
My name's Carlos Elliott. I'm a paramedic. I was a paramedic for Cheatham County EMS till I was retired. I'm a paramedic in Montgomery County also, that I'm currently working.
Now, if you would please go ahead and spell your name for the court report.
First name Carlos, C-A-R-L-O-S, last name Elliott, E-L-L-I-O-T-T.
Now, in your capacity as a paramedic for Cheatham County, did you have occasion to respond to an overdose on Gates Lane in Cheatham County on October 3rd, 2020?
Yes.
And it's a little bit out of order, but at that time, how long had you been a paramedic?
Total paramedic. I've been a paramedic for 26 years. I just been working with Cheatham for 12.
Okay.
I actually work two full-time. I'm working two full-time jobs.
Okay, you got me. I work three
Now,
jobs. I work three jobs.
Prior to your testimony today, did you have occasion to review the run ticket from this intervention?
Yes.
Now, of course, we've asked your coworker some of this, but if you would tell us what interventions you took on the victim Jordan Knight that night while he was in your ambulance, and tell us about the transport.
Can you rephrase like what I did for him?
Oh, yes. What did you guys do in the ambulance? What response did you get from him that time?
Can I have a report to be?
Oh, sure. Well, let me ask you, would you be able to answer that without consulting your run ticket?
Majority of it, yes.
Would it help to consult your run ticket to remember the details?
Yes.
Your Honor, if there's no objection, may I show this run ticket?
No objection.
All right, he'll be allowed to refresh his memory using that thing.
And I apologize, there might be some handwritten notes on there that you're either I made or your coworker made. Just ignore those.
So when we initially got the call and arrived on scene with a 30-year-old male unresponsive out front yard, there was CPR being performed by sheriff deputy on scene. Firefighters were with us, Pleasant Fire Department was with us, and pretty much took over CPR. While we're getting the cot and some equipment ready, we went to the patient, unresponsive, pretty much a quick load. Put them on the cot, put them in the back of the truck. Then we initially started a mechanical CPR, which is an auto pulse, which compresses the heart, frees us up where we don't have to do manual CPR.
It's basically the same testimony for another observer, another participant there that day.
Where, let me rephrase, prior to us loading him from the sheriff's department, had administered Narcan prior to us. When we did our ACLS protocol, administered Epi, administered Narcan. He's also had prior to us leaving, had IV therapy done for him and all that stuff. So he was able to be intubated, which is where we did a tube down their throat and start ventilating, breathing for him.
So he was intubated. He had
transported him.
8 EpiPens, 2 Narcan doses,
We went to Northcrest.
an auto CPR machine.
It's the closest hospital from where we were. We took back roads all the way over to 431. That got us there even quicker. During transport, he was defibrillated where we shot the heart a total of 3 times. Had no response. He was in a rhythm of PA, which is a pulseless electrical activity. It shows a rhythm on a cardiac monitor, but you can't feel a pulse. It's kind of hard to feel a pulse, even when we're traveling down the road in the back of a medic unit. So
what?
He kept going from PEA to ventricular fibrillation. As everybody knows, is you get wiggle form and it tells you that you need a shot.
A go? Is a go missing?
So now, is pulseless electrical activity, does that mean his heart's beating?
That means that there's some electrical activity going on, but it's not beating where you can feel it.
And can you tell from your ticket or either from your memory whether or not you guys were ever able to get his heart beating where it stayed beating?
No, not that. So PEA, like I said earlier, PEA is really hard to. When you see a rhythm in PEA, trying to feel for a pulse, a carotid, radial, even a femoral, it's really hard to feel, especially in the back of a medic unit. In a hospital, when it's a calm setting like that, sometimes you can feel a pulse, but if they're in PEA, when they have a rhythm, we don't feel a pulse. That's our PEA. There's a pulseless electrical activity. Now, not saying that he didn't have one, we just could not feel one. Gotcha. So that's the reason why in my report that I put PEA, because there was a rhythm on the monitor, but I could not feel a pulse. So we have to continue CPR regardless.
Gotcha. Now, do you happen, I know you already told us that you guys transported him to Northcrest, but do you remember off the top of your head, or either by looking at that, how long you guys worked on him in the ambulance at the initial location?
At the hospital?
No.
Gotcha. At the scene. So we got on the scene at 21:22, and we left at 21:46. So we stayed on the scene roughly 24 minutes.
And you guys were trying to get his heart started that whole time?
Yes. There was no stopping of CPR. The auto pulse, which is the mechanical machine that we have to free us up that does the compressions, was constantly CPR going the whole time.
Do you recall how much of your epinephrine you guys used?
We pretty much used every bit of epinephrine that we had on the truck. I think
Man, they filled him. They just hit him with everything. That is crazy.
We used 8 boxes of it, which is every 10,000.
8 epinephrine.
And is that something you guys do to try to start somebody's heart?
Exactly. So even after, during the epi, when he went into VFib, fibrillation, I did administer 300 milligrams of amiodarone to help his heart.
Was there anything on the truck that you did not inject into the patient?
He went back into PEA, and that's when we go back into epi after pushing epi after that. Gotcha.
So the whole time it was pretty much CPR and ventilations the entire trip.
Thank you very much. His lawyer, or Mr. Day's lawyer, Mr. Atchison, might have some questions, please.
Somebody try the late command and see if it works now. I added a go back. It should work.
Good morning, Mr. Elliott.
Hello.
So based on your emergency response and your testimony, Mr. Elliott, General Arnold allowed you to refresh your memory with this run sheet. It's commonly what it's called. Do you still have that in front of you?
Yes, sir.
Did they say 10,000 milligrams?
The time marker 2127. What does that number show in the pulse chart?
Well, it shows 45.
Now, based on your testimony, I believe you stated that just because you couldn't feel a pulse doesn't mean that it's not there, correct?
Correct.
And you guys, emergency response, paramedic personnel, continued the emergency life-saving measures, and that's by protocol, correct?
Yes.
So that's a continuation. You're not going to stop doing those things.
No.
Whether you can feel a pulse or not, correct?
Correct.
And Mr. Elliott, there's no EEG machine on board the ambulance, correct?
EEG, correct? No.
And so you would have absolutely no knowledge if Mr. Knight had brainwave activity or any of that, correct?
No, sir.
Now, when you arrived at North Crest, did you stay on scene?
We stayed to clean up our truck.
But not inside the facility?
I stayed in there just a little bit. I didn't stay there long. We had to leave and get our truck back.
I understand. I'm making sure at the point that you arrived, cleanup procedures, and you didn't stay the extended time that Mr. Knight was being assessed medically by staff.
No, I stayed long enough to give a report, to give them everything that I performed on, and then I pretty much went back out to help my partner clean up and then leave later.
That's all the questions I've got, Judge.
Mr. Arnold?
Judge, those are my questions for Mr. Elliott.
Thank you, Mr. Elliott. You may stand down. You're released from your subpoena.
And Your Honor, I'm actually in a position to play that 911 call now.
All right.
For my accident.
Okay, he's in a position to play the 911 call. We're going to listen really quickly to that. I'm still taking an eye on the Thurston, see if Thurston's back. This is worse than Charlie Brown.
And how much of weight is male or female? Male, 138. Is he breathing? No. Is there a remote? Is there a remote in there? While I'm moving? Other than that, I get no reply. Okay, so you're no longer in there with him now? I'm looking around. But I'm freaking out a little bit. Okay. Can you put on people, like, did you feel comfortable going to check on him, see if we can maybe start CPR? It's okay if you don't want to, I understand. But if you can do some addiction and we can figure out if he's breathing, we can try to fit them. Like, if you could start watching the phone in your way, sir. Just start somewhere for more.
Yep.
Okay, flip them over to the back.
Listen to
What
the-
do you take more money? I don't know.
Sorry, guys, that's my fault.
Get a fly on his back and see if you can feel his chest rising slowly from the roof. It's just hard. It's hard. I think pull him out of the car and get him on the ground. It's just like you're not going to hurt him any worse than he's hurt right now if you're able to pull him out. Okay, you feel any air coming out of his mouth? No. Yes? No. No? Do you feel comfortable attempting CPR or walking through it? Yes. Okay, we're going to push fast and hard. Put the palm of your hand in the center of his chest between his nipples and your other hand on top. We're going to push fast and hard until he comes to me. Okay, are you ready, sir? Yes, ma'am. All right. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30. If you feel comfortable doing it, sir, you can pinch his nose until his head back. Give him 2 breaths. Only if you feel comfortable. All right, we're going to do another breath. Ready? 1, 2, 3, 4,
This is
5, 6, 7, 8,
this is not the way you want to be trained on CPR. I mean, they're doing it right, but hopefully you get the opportunity to learn this when it's not somebody else's life on the line.
3, 4, 25, 26, 27, 28, 29, 30. Go ahead and pinch his nose. Tilt his head back. 2 more breaths. Are you good with this? Hey, come. Hey, we're good. Hold on. Hey. Anything? We don't have to wait for long down to run stuff and you can do it. Okay, if you've got anything in his mouth or nose, you can point that out. No, hey. No. Yes. All right, do you see your chest rising on its own or anything right now? No, I'm on the get a stomach jerk back into the fire. Okay, let's go ahead and do another rest. He's not changed it. Are you ready, Phil? Okay. Okay. If you don't want to, sir, you don't have to go to you. Okay. If you want to continue to go, let me know and I'll walk you through it, okay? But there's 2 times. Come on. I think you can do like something like that and let's just be done. Okay, hey, what does that look like? What does it look like? It's going to be a cylinder. Naloxone or Narcan on the bottle or on the okay. They may say it's NaL. So you can hear. Hey, sometimes you don't.
EMT just sent me the protocol they were probably following here. Let's see.
Plug one of his nostrils. Plug one of his nostrils with your finger, and put the other nostril in his other nostril and administer it. Okay.
It's a flow chart. That's
No, I need my video. Looking at the just a nature one and squeeze it. See how that goes. Okay, it's pretty close to his other nostril.
This is it's difficult to hear. I mean, difficult, like technically it's difficult to hear. It's also difficult to listen to this. Doing CPR is a serious thing.
Come on, bro. I just started on fight that come along. Okay, so can I have your name before you hang up with me? Okay, just keep time, like if I still know something will be on the phone, keep I want to know what's going on. You can call your mom as soon as they get there. But just keep talking to them if you want to hit CPR again, I can walk you through it, it's whatever you want to do. But that's dirty, hold on, it's pretty tight. Put the top of your pants and fingers in the bowl, and your other hand on top, and I'll count for you. Every time I count, put it down, all right?
So the defendant is talking to 911. 911 is the lady's voice giving him instructions on what to do.
All right. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30. Give them 2 breaths if you want to, Jason. Let's go ahead and do another round of questions. It's going to keep it on. Ready? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30. Give them 2 more breaths if you have anything else. Okay, after that, let's go ahead and do some progressions, okay? So they get there. Ready? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30. All right, 2 more breaths. Good to finish. Let's do a compression, okay? you ready? Yeah. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30. All right, is there any change with us, Jenny?
Those are the two breaths. Let me just tell you, you can hear him performing this on the other side. He's actually doing this.
Ready? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30. Are these video tapes? All right, keep doing compressions. Ready? 1, 2, 3, 4, 5, 6, 7, 8. Okay, keep doing compressions until they come and relieve you. Okay, they're gonna help you out.
So the medical technicians, EMTs there have arrived, but he's still doing compressions, or should continue doing them until somebody's right there to take over for him. The protocol is to minimize interruptions to the rhythm.
He's coming to you, okay? Just make sure that's right house. He's tested on his desk, okay? Well, this is right out. Okay, keep doing compressions on and off this next with you, okay? With him? I did. Okay.
I think what they're trying to prove, the state's trying to prove that he was dead there.
That'll be the state's second exhibit.
Even though the machine found a pulse, the EMTs could not feel the pulse. It was very weak. So the machine found a pulse, but the EMTs could not feel a pulse. So they continued with the automated machine doing CPR on him. And eventually he was pronounced dead a while later. It is an overdose situation. The defendant is the one who's charged with selling him the drugs.
Sorry about that. Yeah. Exhibit 1 and Exhibit 2 on some drive. Your Honor, the state's last witness would be the Tennessee medical examiner, Shannon Crook.
She's going to be in person in the little tiny witness box. I can't help but think that the witness box is designed symbolically. It is literally a box. Get in the box. Climb the ladder. Get in the box. Here we go. Up the ladder. In the chair.
You solemnly swear or affirm that the testimony you gave will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Drugs were sold in another county. They were not sold in Cheatham County. He did not overdose initially in Cheatham County. He was driven into Cheatham County where they called 911. And then they took him to another county, to a hospital where he was proclaimed dead. But Cheatham County is the one who is prosecuting him here. And the whole purpose of this hearing is to determine if they're able to proceed with this prosecution.
If you would please tell us who you are, what you do, and start a report.
My name is Shannon Crook, SHANNONCROOK, and I'm a forensic pathologist and employed as an assistant medical examiner in the Davidson County Medical Examiner's Office.
And were you employed in that capacity in October of 2020?
Yes, sir.
Now, I've got your CV. I'm going to go ahead and pass it up to you.
They're charging him with second-degree murder. He did call 911. He did perform.
Is that an accurate copy of your CV?
Yes, sir.
And if you don't mind, would you run us sort of through the high points of your education and qualifications?
I completed my undergraduate degree in biology from Middle Tennessee State University in Murfreesboro, Tennessee. I then earned my medical degree from East Tennessee State University in Johnson City, Tennessee. I then did a 4-year combined anatomic and clinical pathology residency at the University of Kentucky in Lexington, Kentucky. I then did a 1-year forensic pathology fellowship in Dallas, Texas with the Dallas County Medical Examiner's Office. And I am board certified in anatomic, clinical, and forensic pathology through the American Board of Pathology. And I'm a licensed physician in Tennessee and Kentucky.
Judge, I'd like to tender her as an expert in forensic pathology.
Any questions, Mr. Atchison? All right, she'll be qualified as a expert in those fields.
And if I could submit her CD as the next.
All right, we'll mark it as Exhibit 3.
Now, did you record or did you prepare a medical examiner autopsy report for Jordan Knight?
Yes.
And would you recognize a copy of that if I showed it to you?
Yes.
For those that are following along, in the Savannah Soto and Matthew Guerrera trial case, that was the pregnant teen and the boyfriend found dead, shot in the car. The mom has now been arrested. She was let out on a perp walk wearing an Ozzy Osbourne shirt, which is just interesting. She's been arrested also in that. So now the dad, the mom, and the son have all been arrested for their role in that or the follow up of that the shooting.
Is that an accurate copy of your report of investigation?
Stepmom. Sorry, stepmom.
And the autopsy report in this case.
Yes, sir.
And in terms of
that case is going off the rails.
Were you able to establish a cause of death?
Yes, sir.
What was that?
The cause of death, in my opinion, in this case is due to the toxic effects of fentanyl, acetylfentanyl, and methamphetamine.
And as part of preparing this report, did you receive information from the sending institutions, namely Vanderbilt University Medical Center and I believe North Press and Robertson?
Yes.
And is that information provided in the narrative summary of the report?
A general summary. Yes, in the conclusion portion of.
And that is page 4 and 5, is that right?
Yes, sir.
Now, I know I asked you about this before, but ultimately, brain death was declared by Vanderbilt University Medical Center. Is that correct?
Yes, sir.
What does that mean?
Brain death is a clinical term indicating they performed tests and have determined that the brain shows no functions anymore.
What could you give us some information about what sort of things cause that and what relationship that has to the cause of death here, insofar as you know about that?
Based on my understanding of the case, so brain death means that you have cessation of any activity of the brain, including the brainstem, which is that primitive portion of the brain that tells you to breathe in your heart. So these are tests showing that the brain does not have that function anymore. So if he were to be taken off of life supportive machines, that he would not be able to breathe or have breathing anymore on his own. And so the underlying cause as to how he came to be in this condition, in my opinion, is due to the drugs that were found in his blood.
Your Honor, I would like to submit the medical examiner report as the state's next exhibit.
All right, we'll mark it as Exhibit 4.
And I believe you also obtained for us a copy of his death certificate in this case. Is that right?
Yes.
I'm going to pass that up. And I know it's not certified or anything, but is that an accurate copy of the death certificate for Jordan Knight?
They didn't get a certified death certificate?
Your Honor, I'd like to submit that as the state's next exhibit.
Exhibit 5.
Why couldn't they certify it?
And so I'm going to sort of ask this again. So, and if I'm wrong, just tell me that I'm wrong. Okay. So brain death is what happens when a person's brain isn't powering his or her heart and lungs.
Yes.
And so what it means is without a machine doing it, they would stop.
Yes.
And that is the condition that's described by Vanderbilt University Medical Center in this case.
Yes.
Okay. And in this instance, the cause would have been the overdose.
Yes.
Thank you very much. Mr. Davis, lawyer, Mr. Atchison, you probably have some questions.
Mr. Atchison, you may cross-examine.
That other case still is on break. That's in Washington. It's going to go late today, so we're going to be up late with this one, but we'll pick that one up as soon as it comes back. This one's short. It's just a hearing, so it's not a full trial. We'll be done with this. Actually, let me check and see what our time is on this. Yeah, we've got.
Oh, sorry.
I'm going to read this. Can you guys see it? It's 2 hours and 15 minutes long. We're an hour and a half, so we've got 45 minutes left on this one. We'll be back to Washington for Thurston for the rest of that trial. Jury selection and all.
For this for Now, Mr. Based on your involvement and your assessment of Mr. Knight, how did you rule the manner of death?
Accident.
And based on all the information you had received prior to conducting said autopsy, to the best of your knowledge, isn't it true that Mr. Knight's heart was beating on its own at Northcrest Medical Center, according to your notes in your summary? I can provide it back to you if you.
Yeah, from what I recall of the medical records, he was not pronounced deceased. They were able to get post-practice.
Judge, may I pray?
You may.
This is in your conclusion section. And right there where I am placed a pin mark or an asterisk, could you read that section of your report?
Return to spontaneous circulation, or ROS, ROSC, was achieved, and he was transferred to a tertiary care facility for further management.
Thank you. And now, in layman's terms, for all of us who don't have a medical degree, what does that mean?
It means that they were able to revive pulse.
And you're also aware that when Vandy pronounced that term brain dead, that was in fact 2 days after the incident date. You're familiar with that, correct?
Yes.
And so that would have been on October the 5th.
Yes.
And so we know factually, and there's no dispute, that Mr. Knight had a heartbeat at Northcrest Medical Center.
As far as my understanding.
And so, based on your report and your notes that you received, this in fact, the end result was a decline of his condition, correct?
Yes.
Now, based on your experience, Mr. Knight being transported from North Crest to Vandy was a continuation of that medical care, correct?
Yes.
So at some point, and correct me if I'm wrong, there was a need to continue this care, correct?
Yes, sir.
And so, let me back up just briefly. Do you remember the substances that were found in Mr. Knight's blood?
I would need to review the toxicology report.
Judge, may I interrupt you? Dr. Crook, is that an accurate depiction of the toxicology report?
Yes.
And so if you would just tell the court what was found in Mr. Knight's blood.
So this was blood that was drawn at the first hospital, and the substances that were able to be detected were 4-AMPP, caffeine, naloxone, venlafaxine, O-desmethyl venlafaxine, fentanyl, acetylfentanyl, and methamphetamine.
Dr. Crook, are any of those heroin?
No.
And Judge, if I could I possibly see exhibit number 5? Dr. Crook, you provided us with the certificate of death for Mr. Knight, correct?
Yes.
And what county was Mr. Knight pronounced dead in?
Dates.
And so based on your testimony, we know that after Mr. Knight left Cheatham County, that he did in fact have signs of life and a heartbeat at North Crest Medical Center, which is located in Robinson County. Correct.
Okay, so that testimony right there should possibly exclude this from being heard in this court. If he was alive.
And based on your medical experience and your background, the EMTs or paramedics that were on scene with Mr. Knight in Cheatham County, they would not be qualified to pronounce death, correct?
That is determined by their medical director and their protocols. So it'll be based on that.
Thank you, ma'am. Judge, that's all the questions.
Mr. Arnold?
Just a quick redirect. So Mr. Atchison sort of asked a question, but he
kind of asked it in two different ways, so I want to maybe distinguish them. Is it the same thing for someone's heart to be beating as it is for someone's heart to be beating on its own? Sure.
She says, can you rephrase that?
At Northcrest Hospital, we know that his heart was beating, right?
Yes.
Do we know that it was beating without the assistance of machines?
That they said the return of spontaneous circulation had been achieved, so that would be it's spontaneous.
Okay. So Ross means that that they got it to beat on its own with these signs.
Yes.
Okay. All right. That's my question. Now, in terms of, but we do know from your report that at Vanderbilt, at some point, his heart, though beating, was not beating on its own. Is that fair?
That's my understanding.
That's my understanding.
And that follows from the definition you gave us of brain damage.
Yes.
Those are the follow-ups.
Mr. Atchison, anything? Doctor, if there had been if extraordinary remedies or methods had not been used to try to resuscitate him, would he have survived?
If he had not received as much resuscitation as he had, based on everything that I know, he most likely would not have.
Anything else?
Okay, so the judge using.
Thank you, Doctor. You may stand down when released, or you may stay around. Mr. Arnold, you may call your next witness.
No more witnesses.
Your Honor, that's the state's proof for the purpose of this hearing.
Does the defense have any proof you wish to offer? Wish to make an argument, I'll be glad to hear it.
Now they're going to argue, based on that evidence, that they have subject matter jurisdiction in this case, that this court should continue to hear this trial, even though very little happened in this court or in this county.
So, Your Honor, I've submitted a couple of cases. One is controlling.
When did you submit them?
Sorry, with the state's motion.
I haven't read your motion. I've seen those.
Oh, fair enough. And part of the issue in this case is there is not at present a case that speaks on exactly this point. All of the cases that I've submitted deal with instances where the jurisdiction of the court is in question, in the sense of we have a crime that occurs partly inside of Tennessee and partly outside of Tennessee. So the two cases that I gave, Your Honor, a Court of Criminal Appeals case, Johnson, and I believe a Supreme Court case, Legg. Sure. But in any case, they're not directly on, Your Honor. And that puts us in kind of in a sort of strange or awkward position. That being said, both of those cases, and in fact, all of the Supreme Court cases that deal with the venue statute, which says, of course, that a crime may be prosecuted where any of the elements of the crime has occurred.
So
also
what's
make reference to the construction statute, which is immediately following, which in essence says that the rules are to be construed in such a way as to not have a counterintuitive result. Legg, it's either Johnson or Legg, one of the cases, maybe both, rely on this construction statute at several points. In addition, the case law is clear that were Jordan Knight to have been pronounced dead in Cheatham County, or as a result of having been allowed to expire in the yard where Your Honor saw him, venue would absolutely lie in Cheatham County. So there's no question about that. Obviously, we're not in that situation. Your Honor heard testimony from Chief of EMS, from the deputy. Your Honor heard a 911 call, and several instances of extraordinary measures were taken to attempt to revive him. And while he was not successfully continuously revived, he was not successfully continuously revived until he arrived at Northwest Hospital. The state's primary argument is that it would be a counterintuitive result, it would be an unjust result, if the life-saving intervention that we want our emergency medical personnel to engage in could take venue away from a county where it lies and remove that venue from that county. Here in Cheatham County and in Dixon County, we've prosecuted several of these second-degree murder cases where the actual sale of the substance occurred in a different county. And virtually every time that we've prosecuted one of those, not every time though, because after a while people figure out, well, it's allowable, but we fought that venue argument, and the venue, of course, has lied with us, has laid with us because of the fact that the person died. That is, in fact, an act. I guess what I'm asking, Judge, is, and in addition to that, there's actually case law. There are some published cases that say that the location of a deceased victim's body creates a presumption of pain. Again, that's not directly on point. I'm not saying that it is, but for the intervention, that is the situation you would likely have had. That's Reynolds versus State, State versus Killebrew, that's 760 Southwest 2nd, 228. State versus Krusty, that's 326 Southwest 3rd, 582. And I guess what I'm asking Your Honor is to obviously, ultimately, venue will be a question for the jury. But
question for the jury: what are the elements that they have to prove that the case, that the crime occurred in this county?
This is the Cheatham County part of the case, Your Honor. Right? There will be other proof about a sale in Davidson County and all that sort of thing, but obviously that, isn't part of this argument. If seeing all of this proof, Your Honor, after consulting the cases, if you would have to find as a matter of law that that we cannot, that no rational juror could find venue by a preponderance, then Your Honor would have to dismiss the case. What I'm asking is, Your Honor, to do is to look at that case law, and I believe between that and this proof and the fact that but for the emergency intervention, the young man during the night would absolutely have died here in Cheatham County, or at least the jury could find that by a preponderance. I'm asking Your Honor to find that there is enough for the jury to consider the question of venue. Thank you.
Mr. Atchison?
I don't know the outcome.
Judge,
I know it's out there, but I don't know it.
With General Arnold's assessment of not only the statute, but also the basis of case law in which it's used. There's no element of this offense that occurred in Cheatham County. And while I understand that venue is not an element of crime, it does in fact have to be established. Case law supports this manner in which individuals are charged as not a continuation crime. We know that the sale, and while not put on today because of certain witnesses not present, the use and the death of Mr. Knight, none of those occurred in Cheatham County. The death certificate provided by Dr. Crook in and of itself, self-authenticating, it's clear and convincing. Mr. Knight was pronounced dead in Davidson County. We also know, based on her testimony and medical reports in this case, that Mr. Knight had a spontaneous return of circulation.
Spontaneous return after all of the things that have been done to
Judge,
try to get a spontaneous return.
Judge, there's not an asterisk in the statute that depicts or defines, and to circle back to this extraordinary effort of EMS, EMTs, and paramedics and medical staff, I find absurd, quite honestly, that the state would fall back on them doing their job. That's what they do for a living.
Whether it took a little effort or a lot of effort, he was resuscitated.
To skate around the idea that, well, if they would have let Mr. Knight expire in the driveway, we'd have venue, Judge. That was not the legislature's intent in writing this statute. The state, in an effort to bring this back into Cheatham County when none of the events took place here. In fact, there's witness statements within discovery, Judge. They're not present today, but in terms of establishing venue, that would state that Mr. Knight began to overdose or go unconscious at the McDonald's in Jolton, which is located in Davidson County. So if we start that run,
you know how close Jolton is to Cheatham County. Right?
I do. I understand the closeness and the proximity.
You got like 100 feet. It's
But
right
to
on the border.
rely on this idea that but for causation of medical personnel intervening and giving this young man the opportunity to survive, all in an effort to save venue, I can't stand on that, Judge. I do feel that there's a proper venue for this case, and that
Davidson
proper
County.
venue is Davidson County.
Yep. I agree with him.
It's not Cheatham County's battle. It's not General Arnold's battle to fight that fight here. Davidson County is controlled. I feel that Davidson County is the venue. Previous cases that General Arnold alluded to are irrelevant in this matter. The fact that nobody has challenged it previously is no fault of Mr. Day. It's definitely no fault of defense counsel that hasn't been raised before. I understand that in certain situations, defendants waive venue and they accept certain situations based on the end result of whatever their case settles out to or whatever negotiations are met and made. But prior cases have no bearing on this hearing or your ruling, Your Honor, to speculate, if we will, the jury's ability to decide venue still doesn't negate that what we have in front of us by testimony and medical reports and statements involved in this case.
He's sort of repeating himself. He needs to wrap up here.
We know Mr. Knight's heart was beating at Northcrest Medical Center in Robertson County. We know that 2 days later, he was removed from life support at Vanderbilt Medical Center. Judge, we have none of the elements necessary for this to be tried in Cheatham County. And for those reasons, I would respectfully disagree with the state's position in that venue could be established.
All right.
Well, this is a question that I'm obviously going to be controlled by whatever law there is on the point, and I'm going to take a short recess and read those two cases that Mr. Arnold has submitted along with his motion, and I have done some legal research on my own about this issue, so I will come back and give you my ruling.
Okay, so as he leaves to go do his research, we're going to take a little jaunt over to his community page, because when he comes back, there's an audio problem. Thank you for letting me know about this, by the way, that was the situation. So we're going to go to, let's see, the judge's community page. Let me see if I can get this full screen here. All right, here we go with the results. Due to a sound malfunction during the court's ruling on the state's motion regarding venue, the following summary of the ruling is provided for those who are watching the hearing. After reviewing the applicable rule and the current case law, the court found that venue is a fact issue for the jury to determine, and the state has the burden to prove venue by a preponderance of the evidence and may be established by circumstantial evidence. The jury is permitted to draw all reasonable inferences from the evidence presented in making their decision. The court finds that under the law, venue may lie in the county where some element of the crime was committed. The proof here is that the drug was distributed to the victim in Davidson County, and somewhere around the Davidson-Cheatham County line, he began to show signs of overdosing. The 911 tape indicates that the victim was unresponsive, and the proof was that he had no obvious signs of life while at the scene in Cheatham County. The efforts of emergency personnel may have revived him to the extent that he had some heart activity, but he was on life support until he was declared brain dead. The court finds that there is sufficient evidence of elements of the crime charged which took place in this county to allow the jury to make the final decision on venue during the trial of this case. The court, therefore, declines to hold, as a matter of law, that venue does not lie in Cheatham County, and the case will be tried here. So the judge says we're keeping it. We are going to allow this to go forward. This is interesting. This is super interesting. Let me tell you why. First of all, let me search and make sure I don't have Thurston County. They're not back yet, so we're not ready to jump up to Thurston. That is surprising. It's surprising for a couple of reasons. First of all, what is most surprising to me is this: the state now has an added burden, and what it's one of the elements of the crime that is normally a gimme. It's normally a gimme, right? It's like, this occurred in Davidson County, in Cheatham County, in whichever county it occurred in. It's usually an easy one. It's like, well, this is where it happened. This is where the blood is on the floor. This is where the car accident, where the cars crashed together. This is where the fight occurred. We've got the video camera that films it. The location, one of the elements of the crime, if you look through the elements, is like, first of all, you have to prove that this happened in the county, right? Now the state has to prove that it happened in the county, and it's a stretch. It's a stretch. They've literally set the bar really high for themselves and given the jury another way to not convict him. Now, why are they charging him instead of Davidson County? I don't know. It could be that Davidson County has a prosecutor who looked at this and said, I don't know. He called 911. He was doing CPR. Yeah, he sold him the drugs, but he wasn't trying to kill him. And this is just accidents happen. We're just not going to charge him. We might not prosecute. It's going to be a tough one to get a conviction on. Let's just not do it. So this county says, hey, if they're not going to do it, we are, because we take a hard stance on fentanyl use, right? And so we're going to try. But their reasoning to handle this is, or to have jurisdiction over this is thin, and it's so thin that it's up to the jury to decide if it's even there. So interesting. There are some other discussions that are deeply embedded in this case, in this issue, that are bigger discussions. The discussion of personal responsibility versus the responsibility of the provider. Okay, my one camera is frozen. Hey, it is. That means I have to go to this camera. It's going to reboot. We'll give it a minute. Is it a responsibility? This is like if you have a situation where, sorry, I have to make sure the camera turns off so I can turn it back on again. Still powering off, still thinking about it. If you have a situation where, say, let's take Ivan's liquor store. Ivan, thanks for letting us use your liquor store as an example here. Camera's turned on by itself. Yeah, let's see if it works. GoPro's here. Not sponsored by GoPro. It would be nice if they did. They would be much cheaper to buy if these were sponsored. There we go. Camera's live again. We take Ivan's liquor store. We say Ivan sells a bottle of Pappy O'Daniels. Okay, I think there's a bottle called Pappy O'Daniels. That sounds like something that Ivan would sell, right? and he sells it to somebody, and they drink the whole thing and die. Probably, I'm pretty sure. I'm not sure what's inside it, but it's probably something strong enough that you're only supposed to, recommended daily usage is 0, but probably small amounts, like little shots or something. I'm not an alcohol guy, so I don't know. But then there's the question, Pappy Van Winkle. That's better. See, I was like 6 close. I was so close. I think it was like Jack Daniels and Pappy Van Winkle that I mixed together. And maybe you shouldn't mix those two drinks. Pappy Van Winkle and Jack Daniels. I did what? Pappy Van Daniel? I forget what I said even to begin with. But Pappy Van Winkle sounds good. I don't know my Irish whiskeys or bourbons. Ivan's going to call me up in just a minute. He's like, no. You've got it all wrong. I wouldn't sell that crap. You can tell. All right, just drink. It's the one you drink out of the little glass, right? Holding Ivan liable for what happens in you guys give me a break here. Let me work through this analogy here. Grant me a little space for my ignorance. Holding Ivan responsible for what somebody does with their bottle of alcohol. A lot of people would say, there's got to be personal responsibility. You purchased it. You know what it is. The fact that you abused it, used too much, had some, and then thought, I can handle a little bit more, and just kept drinking. It's you guys are brutal. It shouldn't be Ivan's responsibility to make sure you use his product correctly. Now, I realize we have a difference in this situation where you have an illegal substance. It's not legal to sell it. It's not legal to own it. This fentanyl, it's a serious thing. It can be prescribed, but the stuff on the streets is not okay. And now, at some point, you have to say, should it be like Ivan's liquor store, where, look, as long as you're legally allowed to purchase it and he's legally allowed to sell it to you, he should have no responsibility in what you do after you consume his legally sold product. Or, yes, everyone's saying exactly what I was trying to say, RA. Yeah, I just can't name whatever the bottle is. Let's go with Jack Daniels instead of whatever the Pappy stuff is. Pappy Van Winkle, Van Daniels, Van whatever. Some people don't know things are laced with fentanyl. Well, then only buy your drugs from reputable locations, I guess. But should the seller be responsible? And here they've got the seller, who they're now trying to hold responsible for the death of the user, and that's an interesting legal conundrum. How far can this responsibility be pressed to carry on? I mean, do we do this? Say I go to Lowe's and I buy a riding lawnmower. And I set the cruise control on my riding lawnmower, and it actually accidentally mows over my neighbor, and he dies. That's tragic. Okay, I should, I bypass the safety mechanism, and it mows over my neighbor. It's a horrible example. I know I shouldn't have done this after lunch. But do I then go back and sue Lowe's, or does Lowe's get sued by my neighbor's kids for selling the John Deere lawnmower that I bought? That then, where's the responsibility stop? How far up the chain can you, Jessica? Maybe I make the worst examples and comparisons, but how far up the chain can you pass that responsibility and make that liability stick in court, either criminally or civilly? It's an interesting discussion. We're going to see that in the Crumbly case. And I think there it's much easier to see the line. I can see the state's evidence on that one a little bit clearer than I could on, say, like if Ivan were sued for somebody who consumed one of his products and then was driving drunk afterwards and caused an accident and injured somebody. Fentanyl is different, though. This case will be precedent for the nation. I think the Crumbly case will be a precedent for the nation. I think we've seen many of these cases before, where we've seen the drug dealer who is held liable for the drug user overdosing. I think one of the common threads in the case is usually that the user overdoses in the presence of the drug dealer, and then the response is ineffective as well. So it's not like a clean-cut example where it's just like somebody went to the store and bought something and here's the receipt and they left and they used it and it killed them. It's not like that. It's like, hey, we were at a party and so bought some from this guy and we used way too much, and everyone's like, hey, has anybody seen so and so? And he's floating in the pool. It's a different scenario. Ivy says, so when I bump against the door with a hangover, I sue Ivan, right? That's basically what we've learned, Ivy. That's what we've learned. Everybody sues Ivan for everything. Kim R says, explain this using candy bars. I've already had a Mountain Dew today. I cannot, if I do candy bars on top of that, it would be bad. Bartender can be held responsible for an accident if they are found to have overserved. So Deb, now there are some laws in place there. There are some laws in place that say if you serve alcohol to somebody who's obviously inebriated, okay, you clearly can observe that they no longer have the ability to make rational decisions, or their decision-making skills are at the bare minimum, okay? They can basically sustain life and stumble in a direction one or the other, and you just keep serving them alcohol, then you are responsible for that. But we have laws in place for that. All right, let's see about, Becca says, I'm suing Ivan for my typos. You're talking about proximate causation, which is way different in products liability than in criminal cases. I'm mixing all of them up together. I can see this is a civil case, but probably not legal. This particular case that we watched, I was only interested in it because it's a subject matter jurisdiction. It's, does the court have jurisdiction over this case, over this alleged crime? Speaking of which, let me check Thurston one more time. What did they say? They said 1:45. Do we have half an hour before they come back? Does anyone remember the time that Thurston said they'd have? Oh, I think it was 2 o'clock Washington time. Let me check with, let's see. Hey Siri, what time is it in Washington State? It's thinking. Hey Siri, what time is it in Thurston, Washington? Siri's having, I think Siri's in diabetic shock right now. It's just going boom, boom, thunk. Something went wrong. Something went wrong. It's 2:15, so we have half an hour. No, if it's... Okay, so I've got conflicting answers here. Twelble says 2:15. Kevin says 1:20. I'm going to go with the 1:20 answer, which means we have 40 minutes before Thurston comes back. Apparently Siri was still listening. Just minus 3 hours from you time, says Deb. This is higher math, Deb. We can't do higher math live on stream because we know what happens there when I try to count. Siri says, sorry, RA, I'm not responsible for you. Okay. Let's try this again. Siri's out of her jurisdiction. Why is Siri... Siri, stop. Quit listening in. Okay. The defendant should go full soft sit and say no court has subject matter jurisdiction. Paula Darrell Brooks. We need a Mrs. RA video on time zones. I need a Mrs. RA video on time zones. Let's see. Three hours less. Okay, so we've got a few minutes before Thurston comes back. The jury is supposed to be ready at 2, but I'm not sure if that's going to be like in place, ready to go live at 2. For those of you who have not watched a trial with us out of Thurston County, Washington, first of all, they're fantastic. I like this particular courtroom, and it's a weird setup, right? Yeah, it looks like we're literally meeting the lobby of the Hotel Marriott or something. Okay, it's a funny setting. It's like the corner of a library or something. They've set up this courtroom. They have chairs spaced out. The jury selection is done on camera, live. We get to hear it. We get to see it. We get to see everybody who's in the panel to be selected. We get to hear the judges' questions, who raises their hand. It's a little hard to hear some of the responses. So hopefully today the mics are a little better. We can hear what the jury responses are. They're fun to hear sometimes when somebody's just trying to get out of serving on jury duty and what excuse they come up with that think this is sure to work. And the judge is like, no, next. So those are fun. We'll see that. And we'll see just a variety of people. It's just fun to just see who gets called in for jury service. And then, a handful of them are going to be selected, 6 of them in this case, for this trial this afternoon. And it's immediate. I mean, you show up for jury duty, you sit through the panel, you do your voir dire, you get selected, you sit in the box, the trial happens, you go deliberate for a few minutes, and then you're done. It's all one and done, like in one day. So it's really, really interesting here up in Washington. For some reason, the prosecutor is always one in training. Yes, we've had like 3 cases up there where the prosecutor has been the very first case they've ever handled. So I don't know if there's a local law college that is just cranking out the graduates and they all come here to practice or what. But let me say this. I always I like supporting other creators a little bit. And we're not gonna end the show right now. We're gonna keep staying here through the afternoon. But if you are inclined, there's another LawTube adjacent streamer named Ikadmel, who is he's like 200 away from hitting 200,000 on his live stream today, like 200,000 subscribers. It's a huge benchmark. He's been trying to hit this for some time. Let's see, he's almost there. Hang on. Let me see where he's at. He's 167. He's 157 away from hitting 200,000 subscribers. There's Ikadmel right there. That's his name. That's how we say it. If you're inclined, it would be awesome to go over and sub to him just to help. He puts in a lot of work. He follows a lot of the same cases. He's friends with some of our same friends. We haven't done a lot directly with each other, but and it's a very different feel over on his channel than our channel. So I'm not saying that he's like a mirror image of me, and I wouldn't want him to be. But popping over there and saying hi and giving him a high five and subscribing. Obviously, if you like his content, watch it as well. I'd encourage that as well. But he does lots of fun stuff. Does car chases, follows a lot of true crime. He puts in a lot of work in what he does. So anyway, just it would be cool if those of you who are into that would go over and give him a sub on the channel. Love to help out other streamers, even ones that are bigger than me. It's awesome to congratulate them on bigger threshold accomplishments. All right. Too bad you can't gift subscriptions. Oh, Becca, breaking news just now. Starting this year, I've been allowed to gift 10 memberships per month, but they won't let me choose who it goes to. So what we've said is on the first podcast live stream of each month, we're going to gift 10 memberships. And the reason we're going to choose the podcast is because it has the lowest viewer count of any of the shows we do. It's in the evening. It's quiet. It's a more intimate setting. There's a lot more back and forth between the audience and me because there's fewer people. We can sort of have more of a conversation. Thomas is here. I'm here. And that's going to be the best chance for somebody who wants to win a membership to be there and win one. So we gave out 10 memberships. They call them promotional memberships. They don't cost me anything. They don't benefit me anything. They only help you. And I get to do 10 of them every month. And if I don't use them during the month, then they just disappear. So if I forget to do that, the first podcast, make sure you remind me so we can give those out. So I can give them out, but you can't gift them to specific people. All right. Thank you, Mama of Three. I see you went over there and subbed and sent a message as well. That is really cool. All right. You guys are awesome that way. Thanks for helping out somebody else. If we can help one person, whoever it is, yeah, he just needs subscriptions. You don't need to to become a member. You don't need to pay for anything. I'm not asking you to do that. I'm asking you to do the free thing where you just hit the subscribe button. You don't even need to ring the bell. Just a sub is all we need. So, all right, he's getting close. He's 1,900 or 199,844 away. Okay. That being said, let's do this. Let's go back to Lacey. Trying to see if I can pull up the live stream of the arrest in that case today. Let's see. The perp walk. The perp walk was interesting. Okay. My computer's going so slowly today, it's going nuts. Thank you, Samantha Terry. Appreciate that. Okay, I'm trying to see. Okay, we've got the stepmom of the suspect was arrested. Murda Ramonos in connection with the murder of Matthew Guerra and Savannah Soto, which is believed to be the stepmom of the suspect. Okay, let me see if I can pull this up. Just one second here. Ken 5 in Washington had a reporter up there who filmed the perp walk just on his phone. Portrait mode, I might say. Let's go back here. It's taken forever. I'm going to need to reboot my computer this week for sure. Okay, I'll bring this on to channel 3. This is so bad. My computer's dying, and it's not pretty. Okay, let me see if I can bring this up here. Let's see, perp walk. There we go. So this is her on the. This is Game de la Cruz who posted this one. Third arrest. This is the mom of the, or the stepmom. I believe they say that it's the stepmom of the suspect. We're going to rewind just a little bit. Do we have any audio on this one? I'm not hearing any audio.
Using this murder.
Why'd you do it?
Are you sorry? You have nothing to say to the family. Did you give Christopher your gun? How can you sleep at night? Do you have anything to say to the family? Do you have anything to say to these families? Did you give Christopher your gun
There's
to use in
the
this
Ozzy
murder?
Osbourne shirt.
Why'd you do it?
Are you sorry?
And the Christmas PJ bottoms.
You have nothing to say.
Interesting look. So a lot of quick questions from the press. No response from the suspect. That was the arrest number 3. Arrest number 3. There's a couple different videos of the third arrest. Here's another one here from One Juror Matters on Twitter. Let's hit the like button here on these. This is my computer experience today. But The suspect was arrested here. So that's San Antonio Express shows this news. Similar view here with the Aussie shirt. Anyway, so that happened. So now we have the dad, the stepmom, and the son all charged in this case in San Antonio. I don't know what judge is going to handle it. There's a chance that Judge Boyd could be over some of this, which would be really interesting. Seeing her preside in a high-profile murder trial like that would be quite interesting. Let's see. I love the "how do you sleep at night" question. Yeah, not all the people that are asking questions are like what they sometimes say is bona fide media, like the real media channels, the ones who are with news or newspaper or an online publication. It can be just anybody who's showing up there and taking pictures. It's open to the public, and so some of the questions you get are quite interesting. And occasionally we've seen people interject themselves in a Zoom in a conference like that and ask a crazy question just to draw attention to themselves. That's why they won't let me have a microphone, says Adam. Paula Mack says, every time I go to another YouTube channel, my PC locks up and kicks me out. Good. The program is working. Great news, Paula. Great. Good to hear. So, I knew she threw the dad the towel in the truck. Yes, that's what everyone was speculating. I think that somebody threw the towel to the dad, and we think that was her. Chat is going crazy. He's 81 away from subscribing. Thank you guys for going over and giving him a little boost. He had the worst case of the hiccups today. He was looking for solutions. Everyone was proposing their homemade cure for how to get rid of the hiccups, and of course none of them were working. Eventually, one of them did, though. I think it was the drinking water upside down or something like that seemed to be successful. Okay, so what is this case? The arrest with the mom, that's the case out of San Antonio, where you might have seen it on the news. There was a young couple, a girl who was pregnant and her boyfriend, both found dead in the car. The girl shot in the passenger seat. The boy shot, and he was in the back seat, and the car dumped somewhere. No one in the driver's seat. There's indication that they were shot and then put back into the vehicles and then driven that way. So they arrested soon afterwards. They had video of a truck helping stage this, the whole setup with the car. But anyway, it's down in San Antonio. It's in Judge Stephanie Boyd's neck of the woods. Ms. Holmes, we're talking about Ikidmel on YouTube. He's another LawTube adjacent content creator right here. This is his name. A little more rowdy in his presentation. Let's see who this is.
Call from Bree.
Bree, this is Recovery Addict. How are you doing this wonderful hump day?
Good. I've been following this case religiously because originally I had a friend who kind of passed in the same way when she was pregnant, but it was the boyfriend that did it. So I kind of got drawn in early. And now I've been following it. But if you watch that full presser, the officers that they do the interview with afterwards will tell you that it's the mom or the stepmom's gun. So there was never the fight over a gun because the gun was the family's that's in the house, and they found it in the house.
Okay, so that goes into the defendant, the son, who they believe did the shooting. He told a story saying that he was confronted with the gun. The boy who was dead was holding the gun. He was confronted with the gun. There was a struggle. He was able to manipulate it and turn it, and when it went off, it shot the girlfriend. And then he was confronted with the gun again, or in a separate, or possibly a later point in the same altercation. There's a struggle. He's able to manipulate the gun, turn it, and it goes off, and it shoots the person who's holding it, which was the boy. But
Absolutely, he's Keanu Reeves from The Matrix.
Yes, he must be if he's able to pull this off. He's dodging and diving and cape and everything. I guess trench coat is the right word, not a cape.
Yeah.
But yeah, so that's a huge problem if the gun is his mom's, and that would explain the question we saw in the perp walk where somebody shouted and said, "Did you give him your son your gun, or did he let him have your gun to do this?"
And I guess in one of those, the lady officer said that they they would not they wouldn't give her up, but they have video of her getting in the truck with them, the truck leaving, and then him getting out with the son and the dad, or the son, the dad, and him all getting out. That's all in the presser. So,
man, yeah, that's the video is going to do them in on this one. I don't think they realized that they were on camera when that happened. The truck was spotted, and they did a quick search and found who it was in the area. So it was pretty quick.
And I will send you a DM in Twitter. There's another creator, and I know we don't promote whatever.
Oh, go ahead.
But
Name
they had
them.
gotten a records request. So Zav Girl did a records request, and she got the incident report from when they found the car.
Okay.
And in that incident report, it says they were both unalived by a strike in the back of their head. Ooh. So it's very obvious that it's not self-defense. And so, and then it talks about how they were positioned in the car, let's say, and stuff like that. So, I mean, it's very obvious that it's not what he says it was. Yeah. And it's just really depressing. An entire family is taken out, and an entire family could be going to prison for the rest of their life over something stupid.
Yeah. And the fact that she was pregnant, I mean, she had she was carrying a child, and
yeah. So I've been following this. I'll keep sending you updates. I know I sent you a couple of screenshots of when they were going to court, but it doesn't show the times. But I think based on, since this could go to court, it would be a 9 a.m. court docket.
Yeah. So we don't know the judge yet, right? We don't know which judge is going to handle this.
I think we find that out on the 5th and the 6th.
5th and 6th.
Yeah, because that's February 5th and 6th. Yeah.
Okay. I'm fingers crossed for Judge Boyd. That would be amazing. Amazing to watch. So the downside, if it's Judge Boyd, is that Judge Boyd typically does not. We don't get to see the video most times of if there's evidence presented in court. We sort of just get the courtroom view, and you get to watch everyone watching the video. So if there's security camera footage of trucks and things like that, we don't get to witness that. But I would pay good money to get the off the record moment with her in this case.
Oh, yeah.
After a conviction, that would be incredible.
100%. And I know that, they, part of that police report, it's a report, calls out as like officer in trouble because the family had gotten there before a lot of the officers did, because that's how it was found or whatever. So I have a feeling that courtroom is probably going to be a little bit disruptive based on what I'm hearing from both sides. I think they're a little bit emotionally invested, and she's not going to put up with that. And I would just love some golden Judge Boyd moments during that.
It's going to be good. Fingers crossed. I mean, there are many judges down there. San Antonio is a big city, and there are lots of judges in that building. So,
yeah,
it would be interesting.
But there's like that records request is out, and like I said, there's a lot. If you go in and watch the end of the perp walk, they give a lot more information after that too. So if you want to use that or whatever, just wanted to let you know that was in there.
Well, thank you, Bree. And just for the record, I love supporting other content creaters.
Oh no, so I know. I just didn't want to be.
Feel free to mention somebody. If there's somebody who did something awesome, they deserve the credit for it. They deserve the props. Give them a subscribe. Go check out their content. I do believe the internet's big enough for all of us, and there's
I agree.
There's places to watch.
There's also a line of respect, and you just don't want to. I like to at least ask
that
for
respect line is
stuff out.
It would be a little. I'd have a hard time if somebody came in the chat and was like, "Hey, everybody, come over to my channel. I'm doing a live stream."
Right.
That's a little bit. It's like, hey, just ease up a little bit. I'd love to to check you out, and then as long as you check out, I'd love to send people your way. But I do. Sure. I'm very open to supporting other creators. So if you see something, feel free to share it, bring it to my attention. That's awesome, and I appreciate you doing that.
Yeah. So yeah, but like I said, that's out there. So if you need that, I can send that to you too. But yeah, it's just taking those like lifetime movie turns that you just don't really expect. So
yeah, it's gonna be a crazy case. With all this evidence, I don't know if it will go to trial. I don't know if they're going to fight it. It's probably going to be a guilty plea, or somebody's going to turn on the others. You've got 3 family members, and one of them, who wants to talk. Is one of the parents, does mom, to keep mom out? I don't know if there are other children involved or siblings. It's a terrible situation.
And the arrest affidavit already basically points out that the dad said, yes, it was him that was at the truck, and yes, the bodies were in the car. So, I mean, there's not really a whole lot more to convict on at that point. So.
Yeah. And give us the name one more time of who had was it Zav Girl?
Yeah.
Okay. Awesome. Thank you very much. All right, Bree, keep me in the loop, especially if you hear what judge is going to handle that, so we can start getting some requests.
100%.
All right. Have a good one. Thank you so much.
You too. Bye, guys.
Bye. All right. Let me just, I'm not going to go live with his feed, but I think he's like a dozen away. It's so close. Where are we at? 17. He's got 17 more, I think. His feed is a little delayed behind, but it's going to happen right now. 18, 17, somewhere around there. Let's see. There's a lot of evidence, but the defense will go to the messy evidence collection. 16, 15. Let's see. Yeah, it's going to happen. I'd love it if you guys give him a congrats. Even if you're not a subscriber over there, jump over there. It's not a small thing, you guys. To get 200,000 people to subscribe to your channel is a huge accomplishment. So big congratulations to him. Let's check out Thurston. We just have a couple minutes here, I think, before they come back with the court case. He's got 10 to go. 9, 8, 7, 6, 5. 5, 7, 4. It jumps around. It's funny how this happens because everyone wants to be the 200,000th, and so they like unsubscribe at the last minute, and so you end up hitting the threshold, and then because of the delay, missing it again and dropping down underneath it. But he hit it. He hit it. He did it. That is awesome. Oh, he just got up. Headphones off. Walked off camera. Big congrats to Ayden Mel. Big congrats. I know he met with Brandy down at CrimeCon, and they spent some time down there exploring that, and Brandy had some great things to say about that, and that is just awesome. I love that for him. You guys are awesome. Thanks for supporting. I appreciate your help there. He would have done it without us. But maybe we saved him a few minutes of waiting. So, all right. That's really cool. It's fun to be here when somebody hits a threshold. It really is. It's almost like you get to participate in the moment of celebration. It looks like he might be a little emotional about this. He's off camera. But that's just awesome. And he's getting flooded with congratulations. It is fun. All right, we have just a few minutes. We are still following the Thurston case. This case that we're going back to here. It's in our Thurston County Courtroom 4, which is the same room we watched PNW Transparency's case where he won that one. We also watched this is the same room we had Mr. Farag in, and so it's a familiar courtroom. When you see it, you'll be like, oh yeah, that one. It's the one with all the chairs in back that are socially distantly spaced. And so when we come back, it's going to be starting jury selection, and this is going to be rapid fire. It's just quick process. The judge has a little bit. Each side gets 20 minutes of asking questions for the jurors as they try to weed out which ones they do or don't want or may not want on the jury. The first 6 that are left after they weed them out are going to be seated on the jury. Their judge is then going to have an alternate pick. The next one's going to be an alternate, and then the rest go home. And then they move over to the jury box, which is off camera, and it begins. So it's going to be a lot of fun to watch this. It's a process we don't normally get to see in a trial. Jury selection is usually something that happens, off camera and before the cameras arrive and out of the view of the public. Even though a lot of them are open to the public, we need it's an interesting process to see and just understand how it happens. So we'll get that pulled up as soon as it happens. I love the support train. I'm seeing names that I recognize on the support train. You guys are awesome. Thank you very much for giving Ayden Mel a warm welcome to the 200,000 club. That is a very, very elite club. I realize there's some big streamers out there, but the number of people that are over 200,000, it's a small club, and that's just really cool. I'm so excited for him. Okay. All right. I love that he's just ready. Let me tell you, this is what I love about Ikid. I love that he's just ready for when news happens and he runs with it. And you see that a lot in the car chase streams he does. But just his ability to be ready and go. He's very committed to his channel. He gives a lot. I mean, he live streams a lot, which is hard work. And he puts it in and does, he's doing it from home. So that's really cool. All right. Do we need a little break? Do I need a little break? Do you guys need a break? Have I not given you a break? I thought I gave you guys a break. Okay, we'll have a break. Kim R, by the way, you're doing a great job with the internet. Continue to do so, even though I unpin your message here. Let's see. My burrito is done. That's actually my home security alarm. But Vids by Emily, welcome. You just click the subscribe button. You don't know this, but you just became part of the family. Welcome. You can never leave. Alberta White, thank you as well. Thank you, guys. Appreciate you guys showing up. We're just cheering on Ikid Mel. Not sure if you're familiar with him. He just hit 200,000 today. As we tried to send a few people over just to speed up the process as he was watching that. It's like the watch pot that never boils, right? You're sitting there and you're like, any minute now. It's like steaming. It's too hot to touch, but it's not boiling yet. And so as he's watching that countdown, as it's slowly approaching 200,000, he had about I think about 300 or 400 to go when I started watching his stream this afternoon. It seems to take forever, and he had like 6K people in chat, and everyone was subscribed. So it's like, we need more people. So I was happy if I could send a few people over there to speed that up a little bit. All right. Yes, we ate lunch. I ate lunch, Jan, and then I had a Mountain Dew. So I'm not sure if that's counterproductive or not. My squeaky bird has learned the sound of your door beeper. Every time he hears it, he repeats it. Miss Violet, I've trained your bird. Just be glad he didn't learn the sound of the hump day yell. I mean, it could have been worse. Oh, that's funny. All right. Come on, Thurston County. Thurston County doesn't disappoint. It's got some unique trials, and I'm honestly initially I was a little bit, I wasn't sure if I was going to like seeing trials with brand new prosecutors, but they seem to not be afraid of putting brand new prosecutors in charge in cases, and it's fun to watch them learn or attempt to learn how to be a prosecutor. And so like when they usually have a handler or somebody who's there to help them along, a more experienced attorney who's there for the state representing, and they can always turn and confer, and the judge is usually really allows a lot of space for that. So if at any point during the trial they don't know what they're doing, she'll allow a break where they can just confer and they can sort of get fed the lines, tell me my lines in my ear and I'll repeat them again. As it takes everybody. I guess the judge at one point, as whether she or he was a prosecutor, or probably was a prosecutor or a defense lawyer before, was in that same position and had somebody, giving them the reins for the very first time, and letting them, stand up before the judge and make an argument in a case that's important. I mean, this might just be a reckless driving case for a 16-year-old, but for the 16-year-old, it's very important. And for the state, it's very important. So, all right, we're quirky up in Washington, says PNW Transparency. You are, but in a good way. In a good way. It's all about that PNW life. Listening to the whispers is entertaining. I don't think they know that we can hear as well as we do, Robin. I'm pretty sure, I'm like 100% sure that in the courtroom themselves, that whisper is not picked up and retransmitted as loudly as we hear it. So it's a lot of hot mic situations happening up there. We have a couple more cases coming up that we're keeping an eye on, obviously. Mr. Farag, who we've got some sound bites from, he bailed out. He was halfway through his trial. He left on lunch and never came back. And eventually, they're probably going to find him in custody, or arrest him, or something. And he's going to have to face the music for that. But he's also got another court date because he had several pending cases in the works, and that court date is coming up. I think this week or next week. Obviously, PNW transparency. There's another one pending. I think there's an assault charge where you were doing an audit. If I remember correctly, you told us you were doing a First Amendment audit, and they ended up trying to charge you with assault. And I have no idea of the facts of that one. Obviously, that's between you and your lawyer, who is, if you're using the same one as before, great job, great choice. Let's see, correct on that one. Yeah, so if it's all right, we'd like to watch that one as well. PNW Transparency, we found him. He's also a YouTuber, by the way. He does First Amendment audit videos. If you haven't seen his channel, where I'll say this, PNW, you can correct me if you don't like the spin I put on this, but he finds situations where typically a government building where the law is not being followed as far as what people are allowed to do. When it comes to free speech, when it comes to filming in public, when it comes to taking pictures of something, and he will push the envelope up to that line, and then it generally results in some sort of a confrontation with somebody who either doesn't understand the law and what is allowed, or with an officer who responds and thinks their job may be different than what their job actually is. And then he posts those videos of those situations, whether it was successful, whether he went there and they respected the rights of the free speech rights, or whether they sort of failed that audit. So it takes a little bit of a risk doing that, and obviously that risk is playing out here as sometimes gets charged with something during that confrontation. All right, Thurston, we are ready in 8 minutes for you to begin. I've stalled as long as I can, but we need court to begin. So I was seeing this. I tried to send a message to Ickadmill. I'm not sure if he saw it, but back when he was suffering from the hiccups earlier in his live stream, I told him the only way to cure hiccups is to drink the tears of your enemy out of a pink Starbucks Stanley mug. Not sure if he got that message or if that's what actually worked to stop the hiccups, but that works for me. If you ever need to try that, I think it's a good way to go. Hiccups are hilarious. You guys, that is so bad. I only had the hiccups a couple times, and usually I'm able to mute it and they go away before, because you can sort of tell when they're going to hiccup, right? I can tell when it's going to happen, and I've only had them when I was not actively, when we were listening to court and things like that. But if you have persistent hiccups during a live stream, there's nothing you can do. You just have to roll with it. All right. Okay. Trying to find, there's my other camera down here. There's Thurston County District 3. That's not the right one. We need 4. They took a nice long break. It's been 3 hours since the last live stream. It spawned a big, long conversation about the current cult of Stanley. Full confession, I have a Starbucks Stanley mug that I bought for Mrs. R.A. I bought it last year at Starbucks, and I did this, and I've shared this with you before. I tell you, I told you about this like two weeks ago. I said, if you want a good business model, if you want to make a quick buck that doesn't require, they always say it takes money to make money, but if you want to start a business that doesn't take very much money to start at all, the business of reselling Starbucks mugs online is huge. is huge, and you can make a killing doing it. And the reason is this: Starbucks stopped selling their products, their merchandise online. They said, we're only going to sell it in store. And so suddenly anyone, if you want to have like that mug that Starbucks sells, you have to go to a Starbucks that has it. And if the Starbucks you go to doesn't have to, you have to go to another Starbucks. It's a great model to get people in the store. It's a great model to get people buying drinks, buying sandwiches, whatever it is they make there. I think it's mostly coffee. But it's a great model to get people in the door. But for somebody who's just in the market for the mugs, for the merchandise, who needs that last mug for the collectible set, it makes them have a lot of effort. And a lot of people say, I don't have time to drive to all 7 Starbucks that are in my city to find the one piece I need. I'm just going to go online and I'll pay someone else to do it. They're going to go out, they're going to find it, they're going to put it up for sale 3 times the cost of what it costs to find in Starbucks. It's less of a hassle for me to pay that than to look for it myself. And there's a whole ecosystem out there. And so the black market for Starbucks mugs, it's real, very, very real. I would tell you that it's so much of a thing that they won't tell you this up front, and they're not supposed to do it. But at many Starbucks where I've talked to the managers are in on this deal. And the good mugs, when they come in, often never make it to the floor. I won't reveal names. I won't say locations, but there are many managers who have thriving eBay accounts. Who sell just Starbucks mugs. But anyway, it's you don't have to spend any money, 80s Music Man. Here's the idea. Here's how it works. If you live in an area that is a destination for somebody, say you live in Virginia Beach. Say you're in Virginia Beach. You can go to your local Starbucks store and you can buy a mug that says I was here or I am here. They have like you are here mugs where in that store, it has the only mug you can buy is the one for Virginia Beach. You can't get the one for Hard Rock Cafe, Las Vegas. You can't get the one for, Los Angeles. You can't get the one for Seattle. You only get the Virginia one. Well, somebody over in Seattle had that Virginia mug and they loved it. It was their favorite mug, and they dropped it this morning on the floor, and they knew they're like, oh man, my Virginia mug, it broke, and they want another one. And they can either buy a plane ticket and fly over to Virginia and buy another Starbucks mug and come back, because the option is not there to buy it online. You can't just go to starbucks.com and say, give me another Virginia You Were Here mug. So you can go and you can say, you can buy a mug if you want, or you can just take pictures of one in the store and then you post it on eBay and say, I'm selling Virginia You Were Here mug. Starbucks, brand new in the package. You don't even have to buy it yet. And then when somebody orders it from you on eBay, you then go to the store, use the money they gave you to buy the mug and ship it to them, and you keep the profit. So there you go. There's your $1 million business idea. And I'm just giving this stuff away, guys. You can't find this elsewhere. Where else are you going to find this great advice? All right. Shut the front door. The same thing for zoo and aquarium gift shops in major cities. Disney stuff, oh my goodness. There are people who make a business out of taking your online orders for them to go into the Disney, collectibles store, buy at Disneyland, and then send out the next day. And they literally have all the samples. Like, what do you need? Do you tell me what we want? I'll go in there, because they just restock the same merchandise over and over and over. And those things that are always there, you can sell that way. All right. This is why my late husband's son's fiance works at Starbucks in Virginia Beach. What's the odds? Hey, if you need that mug, Sinbad, now you know who to go to. All right. Come on, Thurston. We're waiting for court. We're going to jump back to this court because if you have not watched a court out of Thurston County, it is different than anything you've ever seen, mostly because we get to see the jurors. Okay, we're like a minute away, so it's any second now it's gonna pop up here. We'll give them a minute in case they're late. But Becca, we're starting a new trial. It's a short one. We have a 16-year-old who's accused of reckless driving. It sounds like he's accused of reckless driving on like a second offense. Whatever the reason, there's also some other behavior that he may have done before. He may have driven previously without a license. There were some other, he may have tried to get away from the cop after the cop flipped the lights on. There's awfully speeding, running a red light. For whatever the reason, The judge has counseled both sides and said, look, do you really want to do this? Earlier today, she sat down with both the prosecution and defense and said, look, you've got a 16-year-old kid here that you're about to convict, who for the rest of his life on every application, even down at Jack in the Box, will have to say, yes, I've been convicted of a crime. You know, every job application, every college entrance, form, everywhere he goes, do you really want to go this route? Or is there some sort of agreement you guys could come to? Because I've sat here in this court where you had a much older defendant who was accused of drunk driving, and you guys were able to come to an agreement then. And you're able to say, hey, we're going to knock this down to a charge of, whatever they knock it down to, parking illegally. What's the state that always knocks down the DUI to, failure to maintain a vehicle or something like that? It's a weird lesser included. But apparently they want to pursue this option and take it to court. But the judge gave them the chance to confer. They did not. And now it's going to go to a trial with a jury. So the jury is going to be picked in front of us as we watch this happen. And they just barely came live right now. So we're going to jump to that as we speak. Jury's filing in. There's our defendant. He's 16 years old. One of the motions that the defense made was, or they actually fought against and won, was that they're able to tell the jury how old the defendant is, which the state said, you can't do that. That's prejudice. Everyone's going to be like, oh, he's just a kid. I can't hit him with this conviction and ruin his life, which, the judge agreed, said, yeah, they should be able to tell, the defense should be able to use his age when they say, hey, this is the defendant. This is who he is. The judge looked at this case and said the same thing. He said, oh, he's just 16. Are you sure you want to do this? So I think the state had a strong argument there based on the judge's own comments at the beginning. But we'll see how this goes on this case here. It's going to be quick. It should be just all done today. We might be here a little bit late. But the people in back, those are not. He is 16. He is 16. Or at least he was at the time of the crime. Those are not members of the public just here to watch. They're wearing badges because those are your potential jurors. He is charged with reckless driving. That's the only charge. I think the judge is coming in right now. Let's see. But what you're going to see is the defendants, and the defendant and the attorneys are going to pop around to the other side of the table. They're going to move their chairs around. They're going to face the jury. The judge will talk to them. Both sides will talk to them and ask questions. We get to watch the voir dire. We get to hear the questions. We probably won't hear the answers very well, but it's gonna be great. Out of that group, six plus one are going to be deliberating on this trial before the day's over. It's get to know the jury time. Hey, is my wife in here, Mrs. R.A.? I didn't see her comment. I see you guys saying her comments. Oh, you want me to get her?
Thanks, folks. Please be seated. Good morning or good afternoon, I should say, to all of the potential jurors. Thank you for your promptness, your attention already today, and thanks to the lawyers and parties here for being so prompt and on time as well. So we're going to get going with what we call jury pick. We're going to pick 6 or 7 of you to stay with us for today and tomorrow to hear this case. And first off, let me get everybody introduced here. So, Mr. Stillwell, would you like to introduce yourself and your client?
Thank you, Your Honor. Good afternoon, everyone. My name is Jake Stillwell. I'm the defense attorney in this case. My client here is Russell Wakeman. Also present at the table here is Mariah Julian from our office.
Thanks, Mr. Stillwell. And Ms. Mann, would you like to introduce yourself and your colleague?
Hello, everyone. It's nice to meet you. My name is Devin Mann. I'll be representing the Thurston County Prosecuting Attorney's Office, and with me is Mr. Corey Thompson.
Thanks, folks. All right. And again, I'm Judge Kayla Wilcox. I'm here with the District Court. That's where you are, is the District Court. This is our jury facility. We also have 3 courtrooms over at the main campus. But I've got some introductory remarks. I'm going to try and introduce you to the case so that you kind of have a frame of reference for what we're asking you questions about. So give me a moment here. And also, I broke my arm. I hope this doesn't distract anyone. Playing pickleball. Yep, it's about the most ridiculous way to do it. So I'm kind of weaning myself off of this thing. Things are mending up, and so you'll see me with it. Without it, I might even end up with a blankie. So I'm not taking a nap. But just so you know, don't let that distract you, right?
That brutal sport of pickleball. It'll get you every time.
How are we doing on hearing? Anybody? Of course, if you can't hear, then look to your neighbors, see if someone looks like, huh, what's going on? One seems all right.
Please raise your hand.
Surprise of each other if it looks like someone isn't hearing, of course, then let me know so I can help with that. And I'm going to sit down, and if that doesn't work, I'll stand up again and do this. But let me know. Raise a hand or something if things aren't working, if you can't see, if you can't hear, because I won't know. And it's really important that each one of you pay really close and careful attention to everything that's happening. So what we're doing today is a criminal case, and it's brought by the state. You've met Ms. Mann and her colleague, Mr. Thompson. They're representing the state of Washington or Thurston County. And you've met Mr. Stillwell and his client, Mr. Wakeman. And Mr. Stillwell is the defense attorney, and his client is called the defendant, Mr. Wakeman. And so you've already met Teresa Garza. She's my clerk. She's my bailiff. She's my everything. And she is everything for you, too. If you have questions about procedure, logistics, where to go to lunch, how to find the bathroom, anything, she's the one. So when I say bailiff, I say clerk, that's Ms. Garza. And she'll be with us throughout all these proceedings. So let's see. In district court, we record everything. We don't have a stenographer that sits in the middle taking notes like on a strange machine. That's Superior Court. We're district court. We put it all on a record, a tape recording, I was going to say, but tape doesn't exist anymore, but you know what I'm saying. And so that's the official record, and that's kept, again, by Ms. Garza, and she'll tell me if there's anything awry, and then we all are quiet until we get it right. But that's how we do it here. And so let's get into the meat of the matter. So Mr. Wakeman, Mr. Russell Wakeman here, he's named the defendant, and he is charged by the state of Washington through the Thurston County Prosecuting Attorney's Office with, I'm going to read to you that charge. Let's see. So the Thurston County Prosecuting Attorney's Office has brought charges against Mr. Wakeman. They say he's charged with reckless driving under RCW 46-61-500. And they're saying that the defendant, Russell Thomas James Wakeman, in Thurston County in the state of Washington on or about September 12th of 2023, did drive a motor vehicle in willful and wanton disregard for the safety of persons or property. And this was signed by a deputy prosecuting attorney and filed with the court. That's how this all started. So, keep in mind that this charge by the prosecuting attorney's office is only an accusation. And the filing of a charge is not evidence that the charge is true. Your decisions as jurors, let me find my glasses, must be made on the evidence as presented in court and presented only during these proceedings. So to the charge of reckless driving, Mr. Wakeman, the defendant, has entered a plea of not guilty. Now, the plea of not guilty means that you, the jury, must decide whether the state has proved every element of the crime charged, and the state has the burden of proving every element beyond a reasonable doubt. And the defendant, Mr. Wakeman, has no burden of proving that a reasonable doubt exists. And he has no duty to call witnesses, no duty to produce evidence, no duty to testify.
And the defendant, Mr. Wakeman, is presumed innocent. And this presumption of innocence continues throughout this entire trial. And the presumption means that you, the jury, must find the defendant not guilty unless you conclude at the end of your deliberations that the evidence has established the defendant's guilt beyond a reasonable doubt. And a reasonable doubt is one for which a reason exists. It may arise from the evidence, it may arise from the lack of evidence. A reasonable doubt is a doubt that would exist in the mind of a reasonable person after fully, fairly, and carefully considering all of the evidence or lack of evidence. And if after such consideration, you have an abiding belief in the truth of the charge, then you're satisfied beyond reasonable doubt. We're going to hear more about reasonable doubt later, I'm sure, and this isn't the first time you're going to hear me saying some of these things, but it's sort of introductory to get you going. So the first stage of the trial is what we're doing right now is called jury selection. Sometimes it's called voir dire in the Latin. Sometimes it's called jury pick. All of that's the same. We're picking 6 or 7 of you to stay with us for the jury duration to decide this case. That's what we're doing. So the purpose of this process is to make sure that we select a jury that is free from any outside or pre-existing bias that may interfere with that jury or that juror's ability to fairly decide the case based upon the evidence and upon the law received all here in this courtroom during the proceedings. And it's important that you discharge your duties without discrimination, meaning that bias regarding race, color, religious beliefs, national origin, sexual orientation, gender, or disability of any party, of any witness, of the lawyers, should play no part in the exercise of your judgment throughout the trial. And these are called conscious biases. And when answering questions, it is important, even if uncomfortable for you, to share these views with the court, with the lawyers. You've all had that video before you came in here about biases. And so we're glad to have provided that to you to give you a kind of a frame of reference to keep in there and keep watch over yourself. So, and that's what I'm going to talk here about that, the implicit bias. So, however, there's that another more subtle tendency at work that we must all be aware of for ourselves. And this part of human nature is understandable, but it must play no role in your service as jurors. And in our daily lives, there are many times, many issues that require us to make quick decisions. And then move on. And in making these daily decisions, we may well rely upon generalities, even what we might call biases or prejudices. And that may be appropriate as a coping mechanism in our daily lives as life comes at us fast and we have to make decisions fast. But bias and prejudice can play no role and no part in any decisions that you make as a juror, that you make deliberatively and thoughtfully and consciously. So your decisions as jurors must be based solely on, again, an open-minded, fair consideration of evidence that comes before you during this trial. So that's what you're asking to do, and that's what we all have to do is struggle with our own. We all have them. We all have biases. We all have prejudices. We all have that, and we have to struggle with it. So in a moment, I'm going to be asking some background questions, and then I will allow each of the lawyers, Ms. Mann and Mr. Stillwell, to ask you questions as well about your qualifications to serve as jurors. And most importantly, I'm asking you to look within yourselves and see if there's anything in your life experience or your personal beliefs that might be such a strong influence that would overcome your ability to serve as a fair and impartial juror on this case. And these questions may involve issues that are sensitive for you. If you're uncomfortable answering any particular question in front of all these other folks here, let me know. There may be a way that we can discuss things with just the lawyers and you and me. It'll still be on the record. It'll still be on that public record that we're making by a recording. So at the conclusion of the trial, it's my job to instruct you on the law as it applies to this case, and those are called jury instructions. And these instructions are binding on you. regardless of what you personally believe the law is or what you personally believe the law should be. It's binding on you to follow my instructions. During deliberations, the job of the jury will be to apply the law to the facts that you have found proved to determine whether the state has overcome this presumption of innocence and proved the charges against Mr. Wakefield, the defendant, beyond a reasonable doubt. So again, the purpose of jury selection is to determine if you have that open frame of mind that is needed to fairly serve as a juror. And before any questions are asked, I'm going to put you all under oath as a group. And then remember, I want you to be forthright, truthful, just lay it on the line here. Let us know who you are. And so for now, let me get you under oath. So everyone gets to stand up with me if you can. And I'll have you all raise your right hand with me. Do each of you solemnly swear or affirm that you will truthfully answer the questions that I ask of you and the questions I allow these lawyers to ask of you about your qualifications to be a juror? So I'm going to start here at 1 and go down. 1, do you take that oath? You can have a seat. 2?
Yes.
And 3, me seated. 4, 5, that's a yes? A nod? Okay. 6?
Yes.
Thanks. No. All right, we'll go the middle row. He's 7, do you take that oath? Thank you. Have a seat. 8?
I'd like
9,
to just give us the numbers here.
And 10?
That's how we're going to refer to them.
11? Yes. 12?
Yes.
And 13?
Yes.
Okay, go to the back row here. 14?
Yes.
And 15?
Yes.
16?
Yes.
And 17? 18?
Yes.
Okay, 19?
Yeah.
And 20?
Yeah.
All right,
The
thank
back
you
row
all.
has a very low chance of serving.
And I do that because we really can't quite see you past your first 2 rows as well, so we go through it like that. All right, so you should know obviously already, you've got a number, so if you're not sure who you are, look down. And we're going to refer to you by number. I mean, the bottom line is I'm trying to give you a little anonymity or a little margin. And also, frankly, I'm never going to be able to know what your names are. That's impossible. So the lawyers here will refer to you by number and only by number. That's how we do it here, and it's appropriate. Please don't take offense.
Reckless
we know
driving
that
is
you
a
are
gross
far
misdemeanor.
more than a number, and you're very important to this process.
More than a number.
We really appreciate your duty here as jurors to the district court. So
gross misdemeanor, up to 1 year in jail and a $5,000 fine.
Raise your hand, leave it raised, because I'm going to take note of who all says that and probably follow up, and then also for the lawyers if they feel the need to follow up. You'd say no, well, you'd keep your hand in your lap. But mostly, I think you're going to be raising your hand a lot because you may say, I don't understand that question. Probably a lot because we're not clear sometimes. Or, wonder if they need to know this, or maybe, or Raise your hand all the time. We'll get it cleared up. We'll figure it out, and you'll help us do that. So that's how we'll do it. So I've looked at all who's here. I'm just going to see if anybody knows anyone here already. Do any of you know? Oh, you're gonna
spin around.
Oh, that's a good idea. How about everyone get a chance, wherever you want to be.
Do the hokey pokey, spin yourself around.
Again, we kind of jury rigged this courtroom. It's not really how they're designed.
This is not a courtroom.
The acoustics are horrible, so we're trying to make it work. So this is how it is. You need you got your computers, and the cords are long enough for both of you and
yes,
all of you. Okay, good. Okay. So any of you know each other from before today, or are you all new friends? Nobody knows each other. Okay. And then does anyone know me? Again, I'm Judge Kayla Wilcox, Thurston County District Court. Doesn't ring a bell. Okay, none of you ring a bell to me either at this point, but maybe as we go along, if all of a sudden you go, Juror 16, I think I worked with him a few years ago, let us know, as things come to mind, or if we may know each other and we didn't figure it out until later, let us know. So anyone, Ms. Mann here, the prosecuting attorney, anyone familiar with Ms. Mann before today? Ms. Mann, do you recognize anybody? No. Okay. Mr. Thompson? No, back and forth. Anyone recognize Mr. Thompson? Know him from before? Nope. Mr. Stillwell? Back and forth. Any jurors know Mr. Stillwell? Mr. Stillwell, you think you know anyone?
This is a good start.
Okay. And then Mr. Wakefield? Anybody know Mr. Wakefield from before today?
Yeah, he
Or
races
Mr.
past
Wakefield,
my
anybody
business
look
on his
familiar?
car all the time.
Okay. Let's see, witnesses. Where am I? There it is. Anyone know Thurston County Deputy Sheriff, Deputy Dustin Leishman? Deputy Dustin Leishman. Anybody familiar with that? Thurston County Sheriff Deputy? Nope. Okay. All right. Anybody know anything about this case before you walked in here today? No, I expect that. All right, so any of you personally ever been involved in a court system before, either here in Washington, somewhere else? Okay, hands up. Let me take
all the hands
quick here.
Okay.
Let's see.
1.
We got a few. 1 and
3,
3 and 6,
7, 8,
and 7, 8,
10. I think 10's got his hand up. 11,
10, 11. We have so much paper.
17, 18, 19,
17,
and 20.
18, 19, and 20. Okay.
So the judge asked me to read off the numbers of
All
people
right.
if I
Well,
saw
let's
it.
find out. Juror 1, what's your association either now or in the past with this court system?
I was sued through a probate. I was the executor of a will, and through probate, I had to testify to an insurance claim.
Okay.
Cool.
All right.
You're good still. No problems.
And was that in Thurston County Superior Court?
It was so many years ago, I'm going to say yes.
Okay.
I think it was here in Thurston County, so.
That would be Thurston County Superior. All right. Sounds likely. All right. And then 3?
For like a car accident.
Were you suing someone or being sued?
No.
Were you?
I just had to like stand in front of a judge and I tried to get it dismissed.
Okay. So you maybe were charged with a crime or a ticket?
Yeah, I took
Okay. You got a ticket. How long ago do you think that was?
like maybe a year and a half ago.
Okay.
Okay, so
Would that probably
prosecutors
have been,
don't
was
want
that
her.
in this county?
No, it would have been Pierce.
Okay.
She went to
Pierce
court to
County.
fight a ticket.
And so you stood in front of a judge, talked about a ticket you got, and ended up with either a fine or nothing?
Yeah, well, it was like in front of like a computer, but yeah.
Oh, really? That bad up in Pierce County? Okay. Yep. All right. And then 6, sir.
Yes, I'm an attorney and I worked for the Attorney General's office for a little under 42 years. I retired about a year and a half ago.
Okay. Congratulations. So what division were you most recently in?
I was in the torts division most recently.
Torts
Okay.
and prosecuting kids
And
for
what kind of
street racing.
litigation did you do?
Personal injury litigation for the last 20 years. I was the head of the appellate team and oversaw civil rights and personal injury appeals in state and federal court.
Okay. All right.
So if he's selected on the jury, meet your new
And
foreman.
then 7, where'd you go? Hello?
Well, was it just for like I was on a jury? I mean, is that
Sure.
Okay.
Yeah, that's fine if that's what it is.
Yeah.
Okay. And 8?
Driving on a suspended license.
You get
He's
charged
out.
with that?
No.
He's out.
Okay. You were a witness or what?
Oh, well, I guess I did.
Okay. And so do you know if that was in this court or this county? Do you know how long ago that was?
Probably like 7 years ago.
Okay.
So you were 16 at the time?
All right. Driving while suspended. All right. Number 10. Hello.
Hi, I was in fourth floor of a training order.
Okay. You asked for one?
Yes.
Okay. And do you know if that was in this King County? Okay. How long ago do you think?
That was back in 2010.
Okay. And number 11?
I was the victim of domestic violence. The case was out of King County. The charge was complete at the end of 2019, and then a restraining order and a parenting plan out of Pierce County, again, 2018-19.
Okay. All right. And 17, let's see where, there you are. Hello.
Yeah, I was charged with DUI, but it got brought to, I can't remember if it's been so long ago, 16 years ago, I was reckless. And I've also been in and out of the court system from like age 6 to 17. My mom kidnapped me when I was 8, and so there was a big custody battle and all this stuff, and so it was a lot of that. My dad, he was a retired county officer for like 50 years.
Yeah,
she's for like 30 years, and then my brother's also Thurston County officer as well.
Okay. All right.
Sorry, not Thurston County, Lakewood.
Okay.
That's out under pressure right now.
That's okay. It's a tough spot. I know. We're under pressure. I understand. Okay. So 16 years ago, you dealt with a DUI, got reduced to something to do. So that was.
I think what's below reckless?
Negligent driving, maybe.
Yeah.
Okay. Sounds good. All right. And then, do you know what court that was?
I got pulled over by the state, so I think it was King County. I went to Redmond.
Okay, yeah, it'd be King County. 16 years ago. All right. And then you were kind of the subject of a parenting, contentious
we went
parenting
to the
thing.
district court or superior court for all of that.
Yeah.
Yeah.
Up in King County, you think?
It was through, well, it went to the state court too. So I think it started in King County.
Okay.
Yeah.
All right. All right. And then 18. Hello.
So I got a speeding ticket in Thurston County.
Okay. Do you know how long ago that was?
10 years ago.
Okay. You probably came to district court, or did you just pay it, or don't even remember? Okay.
No, I went to court paid.
Okay, gotcha. And then 19?
I served in Missouri, but that was in Southern California.
Okay.
And I got a DUI
About 10 years ago?
So a couple
and was
DUIs.
That also in Southern California? Okay.
Can we find 6
and
that
then
we serve
finally
here?
20?
So I've served on jury in Thurston County District Court twice before, and I was also a plaintiff in a federal discrimination case. But that was, I don't want to say it.
A plaintiff in a federal discrimination case.
You see your number keeps coming up, huh?
I know, I was lucky.
She's at the very end. I don't think
I know. That's a really good point. Okay, let's see. We've all answered a lot of questions, and I'm going to keep asking, and so maybe this is very helpful. Maybe we can streamline this. So, anyone here, family or friend, ever been charged with something like this? Reckless driving, neg driving, DUI, got a lot of tickets or something. Any family or friend? Some hands starting to go up. Okay.
About half of them.
Let me make a note. Okay, we've got one and
6.
3.
Oh, 1, 3, 6.
And
9.
6. And I've got 1.
9, 10.
Put your hand down. 6, 9,
13.
10, 13.
And then pretty much the whole back row. The usual suspects on the back row.
16, 18, 19, 20. 16, 18, 19, and 20. Okay. Well, we'll start at the back again. Hi, 20. So, family or friend?
My son's best friend was charged with DUI.
Okay. Were you a witness to any of that?
Just in court for moral support.
Just
in court for moral support, so you weren't called to testify?
No. She's not.
All right. And do you know how long ago that was?
It was before the pandemic. I want to say 2018.
Okay, let's say 2018. And all right. In 19?
Co-worker, yeah, friend.
I'm sorry, co-worker.
Friend.
I missed.
Friend.
Who did?
Friend.
Okay.
Yeah.
And what happened?
DUI.
DUI. Do you know if that was in Thurston County or SoCal? Okay, Southern California again?
Sure.
Do you know how long ago? Good long time ago. And did you have to testify? Did you witness anything? No? Just heard about it, moral support? Okay. And 18?
So I have a brother that's, can't use the word, but crazy. The past 20 years, he's pretty much been charged with everything he's charged for.
Here in Thurston County?
No.
Nope.
Minnesota.
Okay. And so have you, in all those years, were you ever witness to things?
I don't even talk.
You're here, he's there. Okay.
I just know he's always in trouble.
Okay, so you haven't been a witness to it, you haven't been called to testify. Okay. Do you think anything like reckless driving or?
I think he's been charged with about everything he's charged for.
Okay, all right.
I've got a brother who's been charged with all the crimes, is that what he said?
Hello.
I have a nephew that he was, well, his license got suspended because of, I think he was, I just know because that's what he told me. I think he lost it because he was drinking. It was DUI. And that's in Marion County, Oregon.
Okay. And do you know how long ago?
Like 2 years ago.
Okay. All right. And then 13, where'd you go? Oh, wait, you're over there. Hello.
I'm sorry, I forgot to say before that I got this driving ticket.
Okay.
I had to pay for it. It was 20 years ago, and it was in New York State.
Ah.
So nothing else. I paid for it, and it was the first time to be in court.
Okay. And you probably just told on yourself because 20 years ago, I bet nobody can even find that. So, all right. And number 10, where'd you go? Hi.
Hi, I have a cousin that had a DUI.
Okay. And was that recently?
Yeah, I think a year and a half.
Okay.
And it was Thurston County.
Okay. And did you witness anything or called to testify?
No.
Okay. Just heard about it from cousin or through family?
You guys, wrong answers are always appropriate in chat about some of these questions.
Let's see, number 9.
This one is great,
Hi.
Mathis.
It was a very long time ago, 40 years ago. My best friend and roommate was arrested for the DUI, and I yelled her out of jail.
Okay, 40 years ago. Was that here in Thurston County?
In Northern California.
Okay. And then 6, where'd you go? There you are.
51 years ago in Thurston County, my best friend was charged with reckless driving. I was in the car with him, and I did testify in the trial.
Okay.
For or against?
51 years ago.
This guy's off
That's
already.
impressive memory. All right. And 3, there you are.
My husband, I think he was like 17 or 18. I don't know, like I don't remember exactly what I was charged with, but I think it was reckless driving.
Okay.
And then I think he got a speeding ticket, but that would have been like before the pandemic.
Okay. So if he was 17 years old, how long ago do you think that was?
Like 20 or 15 years ago.
So 20 years ago, how, so wait, 33, 17, so he'd be about 17. Okay. All right. Thanks. And then 1?
I wanted to go back to question number 1 because after hearing these, it triggered my memory. I actually went to court, I think it was like in 2018, before the pandemic or right around the pandemic, for a speeding ticket.
Okay.
And it was deferred.
And was that here in Thurston County? Okay.
So for the second question,
Everybody's got something.
My
This is so
father, probably, I'm going to guess 35 years ago, DUI, and then my brother-in-law, I'm going to say probably 15 years ago, DUI. So that's my affiliation.
Okay, thanks. All
Both
right.
Thurston County.
All Thurston County? Yeah. Okay. All right, let's see.
Apparently, you guys have a bunch of bad drivers up in Thurston County.
Okay, you individually,
to...
we've heard a lot of folks who've told on themselves, but anyone that we haven't heard from, that I missed, that yourself have been charged with something like reckless driving, negligent driving, got a ticket for something like that? Nope. Okay, I think we've heard we got that out of everyone. So anyone here yourself, either presently or in the past, involved in law enforcement activities? Nope. Oh, as an AG, number 6?
Yes.
In what way other than being an AAG?
Well, a long time ago, I was the head of the death penalty litigation team.
Okay.
So that's criminal type law, so I thought I should.
Okay.
Death penalty
In the
mitigation
utmost of
team?
caution. Good thought. So what about family, close friends who are involved in law enforcement activity? They may still be or retired. Any hands
Lots
up?
of hands. How many?
Yeah, keep those hands up.
How
They're
many?
coming up. Okay,
How do you
here.
mitigate a death penalty?
1 and 7, thank you. And 9, 10, 11. 9, 10, 11.
The back row will never serve on a jury.
And
Ever, ever, ever.
16, 17. Okay, 16, 17. All right, so 1, who do you know?
He's no longer a police officer, but he used to belong to the Lacey Police Department. I no longer have affiliation with them, but
old friend or
yeah.
Did you say Lacey or lazy?
All right, and number 7. There you are.
My brother-in-law is the chief of police in California.
Okay. In California. So did your brother-in-law, are you recently to Washington or are you from?
No, I've been here 38 years.
Okay.
But my sister's married to him. It is all the time.
Okay, that's how it works. All right, thanks. And then 9.
My stepdaughter's husband is an attorney with the AG's office.
Okay.
Here. Come on.
And here in there's Olympia or Washington? Okay. Know what that person does?
Yeah, he's an attorney for the AG's office.
The attorney does with something with the prison system, labor issues.
Okay. So who knows? All right. Let's see. 10. Oh, 6?
I defended a lot of troopers over my career in civil rights litigation off and on.
Okay. And so Washington State Patrol, you were, so there may have been suits brought by citizens against Washington State Patrol and officers in particular?
He's off.
Okay. And so you defended in state
He's
and
always on the side
court?
of the trooper, apparently.
Okay. Gotcha. All right. And then 10.
My uncle is a retired police chief from Seaside, Oregon.
Okay.
Be nice to Mr.
And
Farag.
11.
He needs his day in court.
I have several cousins who have married police officers. The closest one is currently married to a Washington State trooper.
Those cousins marrying
And
the
is
police
that here in
officers.
Thurston County or elsewhere?
They live in Tacoma.
Pierce County. All right. And 16.
I have a nephew down in Marion County, Oregon, who was a deputy for a little bit, but he's no longer is.
Do you know how long ago he held that job?
He only held for, I think it was like, I would say half a year.
Okay.
He decided to do a different route.
All right. And 17, you know someone.
I had the retired police officer, and then my brother is a police officer currently with Lakeland.
Okay. And so your dad was with what agency?
He was with King County, Port of Seattle, and then he was in Texas for a while.
Okay. And then your brother?
He's kind of like what he graduated from. He's been with them for 3 years now.
Okay. So he's on patrol in
Everyone's like, yeah,
City
I've got
Lake.
an uncle who's
Okay.
a police officer.
All
He's the one I
right.
told you about with the DUI.
Let's see what else I have to ask you before we move on here.
Seriously, they're going for bragging rights. Yeah, I see you're 51 years. I'm going to raise you.
Okay, so like I said before, is that one of my responsibilities as the judge here is I'm going to instruct the jury, whoever you are, as to what the law is, what it is, not what you personally wish it were or think it is. It's what it is, and you're bound to accept that from my instructions. And regardless of whether you agree with what the law is or should be. And so I need to be able to know from each of you, will you follow my instructions, even if you don't agree? with what the state legislature passed as a law? Will you follow my instructions? Or fairly, you're like, nah, I can't. So I need to know those who just will not follow my instructions. If you disagree with what the law is from the state legislature. Anyone? You're all good to follow my instructions so far? Okay, good. So we're going to be here tomorrow. We're going to we may start the trial this afternoon, depending on what time, but definitely tomorrow morning. And I don't expect it to be very long, but your deliberations as a jury can go as long as you want. So that really kind of dictates how long you're here. But I need to take care of you. Me and Ms. Garza will take good care of you, and we'll get you breaks and take care of your needs. But I want to know if there's something that I should pay special attention to that might get in the way of your ability to focus.
Hang on, here we go.
Pay attention and be a good juror. I'm not asking for your whole medical history. You get to keep that private. But if there's something I need to know about, you need an extra break every hour, or you need to stand up, sit down. And if you could do that while, if you're seated over here as a jury and you can quietly stand up and sit down to kind of relax your back or something, we can do that. Anything about something I need to know that I can accommodate, or I need to accommodate, I'm happy to do it. So 3 and 9 and 11. Okay. Like I say, you can keep things personal. But 3, is there something that would get in the way of being able to focus?
Well, I'm just like nervous.
Nervous. I understand. Everybody's nervous in court, and I try to make it better, but it's nervous time. Does that make it difficult to kind of follow what's going on?
Yeah, a little bit.
Okay, what can I do to make it better if you're on the jury?
Just being able to stand.
Okay, we can easily do that. And I like to take breaks because, frankly, this is kind of a weird way that we do things. The way we do things in courts goes back hundreds of years. We talk at you, we tell you stuff. We all learn different ways. We acquire information different ways, but this is how we do it. And so I think it's important as adult learning, certainly, and adult listening, that we take a lot of breaks. And frankly, it's just more comfortable to take breaks. So I try to pay close attention to the jurors and the parties here, and we take breaks. And if you're on that jury and you raise your hand, you say, I want a break, I'm never going to ask why. I'm just going to say, we're taking a break, and say, thanks, because I'd like one too.
Lunch, Judge.
So know that. Realize we're not going to put you to the wheel and lash you and make you do it, So I'm here to help you make this the best experience as possible and accommodate things. So, all right. So 9, is there something I can help you with?
I spent the first 3 days of the new year in the hospital with his heart condition, and I'm just concerned about leaving him alone.
Okay. You're his primary caregiver. Okay. And
this is a valid
he's alone
reason.
right now. And that was just last week. Okay.
Judges can say you can go. You can go.
It's kind of an extra question I'm going to ask next, but might as well get that out there. So 11 is to anything to help you?
I have migraines that are triggered by my neck being tense and tight. So I just need to kind of move a lot or stand up. Don't want it to, I might look fidgety.
Okay. So get you some time to stretch and make sure, okay, we can definitely do that because that's helpful here. I'm getting this weirdness on this one. It's making everything all weird over here. So I will welcome that opportunity to stretch. Okay, that number 9 brought up a good question. That was kind of my next thing. Anyone here have just that? Do you have someone at home that needs you, that you're the person that's going to take care of them, and if you're not there, they're alone and it's not a good situation? Do you have, keep those hands up, do you have tickets to, I always say Peru, I don't know why, because I want to go there. Do you have tickets to Peru for tomorrow or the next day that you're not going to, come on, I'm not going to have you miss your trip to Peru and lose all that money. But we're talking hardship, or someone in your family is going to be put at some risk or hardship without you. So raise your hand. We've got number 8. Okay. Hi, number 8 and 20. Okay, I'll come back to 20. So number 8?
We have 5 kids, and they have to be let in because they're in elementary school.
Okay. So that means, so are you the only one, the only adult?
I'm a single parent, yes.
Okay, so 5 kids, elementary. How old are they all?
Well, one's in middle school, 6th grade. She's 11. We got 7, 5, 2, a 2-year-old, and a 6-month-old.
Who's with them now?
All right. So, when do you need to be there?
Actually, today's half day, so I need to be off earlier.
So who's finding them? Who's getting them home today?
I don't know. Can't be on the phone now.
Okay, so
So he
they're
needs to
all
go
right. So
right
your
now.
11-year-old kind of, you lean on your 11-year-old today to get him home.
Oh my goodness, he's off.
Okay. All right. So you need to be there by what time?
We're not going to get a jury out of this pool.
Okay. All right. Got it. And otherwise, these kids are on their own at home. Okay. All right. And 20?
Surprised she didn't ask if there was.
If that's later, that's fine. I just didn't want to miss my opportunity to talk about it.
So a work hardship, what do you mean?
So I'm a sole proprietor of my company, and if I'm not there, then I can't hire a temp to do work. I can't get it done. And I have events scheduled on Thursday afternoon and Friday.
Okay. So do you have contracts then Thursday afternoon?
I do have contracts, especially for Friday. I have a training on Friday up in Tacoma that's been contracted for months.
Okay. And if you tell me about that, then if you cancel out on Friday afternoon, let me get the dates right. So when's
So Friday morning, I have a contract for a training that starts at 8 a.m.
Okay. That's the one you're worried about.
That is.
Okay. So Thursday, you're good to go.
It would still be a hardship, but yeah, I mean, I would have to probably work till midnight on Thursdays. Nobody does the work if I'm not there.
Yeah.
So,
To get ready for Friday.
correct.
Got it. Okay. But Friday, 8 a.m. And if you canceled that contract, you'd lose money or.
Well, I'd be in breach of contract with my clients because it's a training where people are coming in from all over the state to attend.
Okay. All right. Got it. Understanding better.
Okay, I don't think we're going to get to her. She's got many reasons why she won't be picked.
Okay.
The least of which
Anyone
she's
else
number
with
20.
some,
She would be the alternate.
Okay, I think we got that covered. All right, I'm going to turn this over to Ms. Mann to ask her questions, and then Mr. Stillwell will have an opportunity as well. So, Ms. Mann.
Hi, everyone. Thank you again for being here today. If anyone's ever seen Law and Order, I'm sure you know that trials involve a lot of talking and a lot of getting talked at if you're jurors. But this is kind of the more fun part where you get to talk to us, tell us your opinions on things. And so thank you ahead of time for cooperating and participating. I know I really appreciate it, and I'm sure everyone else does as well.
Yeah. Yeah, make sure.
It works better.
Am I getting picked up?
There you go.
And as far as how are we doing with levels on Ms. Mann?
Hello.
So Ms. Mann, you might want to stand. You don't have to sit down, but that red lighted thing is you pull it as close and put it in the record.
Don't touch it though.
You have to be stuck where you are just because of this room.
How's that? Testing?
Better?
And
Okay,
thank you for
there you
your
go.
patience with technology issues. And I just want to say, before I begin, the purpose of jury selection isn't to embarrass you or pry. We're just trying to really get to know you, and thank you again for participating in that. Is anyone here really excited for jury duty? Yeah? Woo!
Is it?
Is anyone really not excited? Yeah, fair enough.
Back row.
A few of you mentioned that you've served on juries before. If you have, would you mind raising your hand? Nice. Number 5, could you tell me a little bit about that?
Yes, fellow was here in Thurston County, and it was a drug charge.
Drug charge?
And what was your experience like in that jury?
It was interesting, and the jury did a good job. I think that was great. Discussing everything.
Can't hear her.
Did anyone else not enjoy their time serving on a jury?
18,
Number 19. Could you tell me about that?
Well, it was a criminal case, it just felt like most of the jury just wanted to get out until they wanted to convict. And me and another person kept fighting them because of this trial. But it didn't seem like they were very attached to the area like that.
Sounds like they argued a lot in deliberations.
Thank you for sharing
and
that.
Come to a conclusion.
Did anyone else who served on a jury feel like they had a similar experience or an opposite experience? We've talked about, some people have had experiences with the criminal justice system or their families have. Does anyone have really negative feelings about these experiences towards the criminal justice system or maybe just towards what happened? Number 19.
Yeah, like I said, I just didn't feel like this person that she was being given a fair trial. And then the circumstances weren't there enough with her, so it just left me with that that
Look how many people are shifting. They're
Thank you for
uncomfortable with
sharing
these
that.
responses. Everyone's
What's your
crossing their
opinion of
legs.
a fair trial? Can I ask?
well, like I said, if the whole jury had been there and actually wanted to discuss everything, not to tell it. So I thought we had discussed it longer than maybe.
He's speaking through a mask, and it's a little
Does
hard to
anyone
hear
else
him.
have any opinions on what they'd like to see in a fair trial and what that means to them?
19's out.
What about any negative feelings towards law enforcement or any particular positive ones? Does anyone have any strong feelings? I guess I'm asking.
Oh.
Yeah.
Well, I guess I just my family both all law enforcement and what I've grown up with officers. So I guess I have positive view.
Thank you for sharing that. Anyone else?
Good luck,
Yeah,
B&W.
number
I was a
16.
volunteer firefighter for a long time, so every time he kind of always, education, anything like that. I mean, never had anything negative.
Good to hear. What about you, number 9?
Important to have a system, and we sometimes brush up against it, but it's key to having a safe health.
Thank you for sharing that. Now, I have a maybe more fun hypothetical question for you guys. If you woke up tomorrow and you saw that there was snow on the ground, what would you assume had happened? It's not a trick question, I promise. It snowed, yeah. Would you need video evidence to think that? No? Is there anything else that might have happened instead?
Snow machine.
Feel
brought
free
in.
to guess something wild.
Could be fake now.
Yeah, it totally could be fake snow.
I wouldn't see it.
Yeah. Would you assume
19,
that's
you're
what
out.
would have happened though?
Yep.
Why be skeptical?
I'd like to test it
fair
first.
enough. You're looking into it.
He is so out of this jury.
But is that the most reasonable assumption?
Yeah. He's holding his own.
Fair enough. I like you. You're thinking hard about stuff. What about, and thank you for participating in that. I know it's, a little quirky. What about, does anyone here have a photogenic memory?
Photogenic. Like it
Does
really
anyone
looks good
need
when
to
you
make
photograph
notes
it.
or lists to kind of remember things? I know I do. Yeah. Would anyone hold it against, an officer or witness who would need to refresh his memory, maybe from a note or a list that he made while he was testifying? And now back to another question that I promise isn't a trap. What's the point of having speed limits? Number 9, you kind of made a little sound. Sorry to call you out there.
No, it's I have a little lead foot, but it's important to keep safety in school zones, in neighborhoods, freeway, still to be safe.
Yeah, absolutely. You mentioned school zones. What makes that, a particularly important place to have a speed limit?
Well, as a retired educator, to keep the kids safe. And
yeah, absolutely. Does anyone else have any opinions about? Yeah, absolutely. Number 7.
I pull a very big horse trailer.
Mm-hmm.
Nothing that makes you madder is have somebody cut you off.
Oh man, she's off.
Because you give yourself area, to stop. And then when that person cuts you off, you can't stop them on a dime.
Oh yeah.
So if everybody would obey the speed limits, and if people would stay back away from each other, it would make my life easy.
Yeah, I bet. Oof, a horse trailer.
Oh my goodness, this jury is going to be.
Anyone else have any strong feelings about
this.
speed limits? Yeah, number 19.
Like the speed limit here is pretty low. I'm suffering 55, so I do have free trucks going to that.
Yeah, you're entitled to them.
The speed limit's too low, he says. This
awesome.
Is great.
And then we kind of touched on that. Has anyone ever seen the Fast and the Furious movies? Yeah, 11. Are you a fan of like Vin Diesel? Yeah. Do you think it's okay to kind of imitate some of the stunts they do on actual roads? No.
When there's nobody
19,
around.
you're shaking your head. No.
There's our silent witness. Imitating the stunts they're doing. Wow. Can't wait for the evidence. Was he drifting?
19, do you mind if I pick on you a little bit more? You're just so vocal. I love it. You talked about your past experience as a juror and how you didn't think the defendant was given a fair trial. Can you talk about how you think the state was treated in that case by the jurors? Do you think that side was given a fair trial as well? Or yeah, okay, so you felt maybe the discussion was one-sided.
Yeah, I felt like they were listening more to the state than they were to.
Right. Yeah, absolutely. Thank you. And so we talked about speeding and speed limits a little bit. Maybe number 7, how do you know someone's speeding?
Because if I'm doing the speed limit,
The judge is over this. She left.
Anyone else? Have you ever seen someone maybe blow by you on the highway? Yeah. What makes you think that person is speeding?
Because I'm speeding and they're passing me.
Number 9, yeah.
Yeah, if I'm doing whatever the speed limit is and they're going by me, then they're going faster than I am at the speed limit.
Definitely. What if maybe you were a pedestrian and you were on the sidewalk? Have you ever seen someone speeding then? Yeah. Yeah, number 20, I see you nodding. What made you think that?
And I recognize that we are a pedestrian, the cars seem faster than we are, but it also, if they're pedestrians, you should be going slower. So if they speed by you, if they make you feel unsafe, like you've got to jump out of the way, or,
Yeah. Does anyone have anything else to add to that? I saw a couple of people nodding. Great. Well, thank you guys so much. This was really helpful. I really enjoyed getting to know you. And I think we're good for that, at least on my side. Thank you.
Okay, now defense gets to ask questions.
Go ahead.
Figure on. Good afternoon, everyone. Once again, I'm Jake Stillwell. I'm Russell Wakeman's attorney, and I'll also be asking you some questions. And similar to what Ms. Mann said, we're not here to try to figure out who's a good or a bad person or anything like that. It's just not that every particular person is right for a particular case, right? And, the facts of this case are unique to this case, and we want to make sure that we get an impartial jury where everyone's going to take a look at what's going on here with a set of fair and impartial eyes. So that's really what this exercise is all about. And If you were on trial, or if a family member or friend was on trial, you'd want the same thing for them, for jurors to be honest and forthcoming with their answers from talking to the lawyers. And I'm just asking, the same for my client, Mr. Wakeman. All right. So, who here has ever settled an argument between two people? Could be your kids, coworkers. Number 11, your hand was up first.
I'm a special education high school teacher, so I am settling arguments all the time.
I bet. All right. And in settling your arguments, do you like to hear from both sides?
Yes.
Why is that important?
You need the facts of what happened. You need to hear, both people need to feel heard, also to be able to deal with whatever the consequences are of it or the outcomes.
In number 4, I see you're kind of shaking your head or nodding your head in agreement. Do you have a similar view?
I agree. I think that there are two sides to every story. And you can hear one side and you can hear the other side, and some of it's a perception. But there's got to be an answer somewhere in the middle. Like, I'm not all right and you're not all right. We're both kind of right.
That's compromise.
All right. Thank you. Anyone else?
I think 13, 14, someone? No?
Yeah, I think in everyday life, this makes sense. You bring up the situation of being in class where you want to hear both sides of an argument, right? Well, this is a different kind of argument that we're having here. This is a very formal type of argument. Where somebody accused of a crime has the right not to testify and give their side of the story. So going back to you, number 11, do you feel that in this situation, were you to only hear one side of the story, is that something, would you feel comfortable making a decision if, after Ms. Mann presents the state's evidence, I'd kind of sit down and say, that's nothing for me. Are you going to feel that it impacts your ability to make a decision?
That's kind of a really tough question because I don't know the case yet. I don't know but I would think that just given who I am, I could do the job set before me to be a part of the jury, if that makes sense.
Okay, so you're saying you could sort of set that typical desire aside to hear both sides of the juror and try to.
Yeah.
Number 4, what about you?
Well, and as the judge said, our goal here is there reasonable doubt or not? So if they're going to present their case, you may not present anything, but our job is to determine whether presenting is there any reasonable doubt. If not, then that's what we determine. So you're going to only hear one side of it, but we're following the letter of the law. So I think I can do that.
Anybody else here? Yes, number 9.
If the state presents a case, you can rebut any facts or ask questions against
sure.
the state is presenting. So you're kind of getting two sides of the story, right? Yeah. You're questioning state evidence.
Yeah, that's true. And as the attorney, I can stand up here and you'll see me cross-examining witnesses and things like that. But what about Mr. Wakeman here? If at the end of our case, Mr. Wakeman decides that he's not going to testify in his own behalf, does that change, number 11, number 4, number 9, does that change anything about what you were talking about being able to set that aside?
11, 4, and 9, 3 that he
feel
wants.
Comfortable making a decision even if you weren't here, Mr. Wakeman? Let's get some contrary views. Anyone feel differently? Anyone, would anyone here feel uncomfortable making a decision here without having heard from Mr. Wakeman?
Oh, number 17.
All right.
Or 18.
There's a lot of discussion about folks who have law enforcement in their lives, friends and family. Anyone mind raising your hands again? We were talking with Judge Wilcox earlier about that. Juror number 1, do you feel that folks in law enforcement, are they inherently more trustful than maybe some others in your experience?
I wouldn't say inherently, no.
No. Anyone feel that way? Maybe who has law enforcement in their family, that sort of with the duty and the responsibilities that come with that, they're sort of infused with some extra Trustworthiness. Yes, number
Police
7.
Officer, you're asking?
Yeah.
Yeah, I trust my brother-in-law totally.
Yeah.
I've known him since I was 11 years old. So, yeah. And most of the men and women that served underneath him, they're all great people.
Yep, she's off.
Anyone else?
Let me
Number
just
10?
cross that one
I
off.
would agree with what she's saying. My uncle is a retired police chief, and I feel like he's trustworthy.
Sure. And then,
I would not trust someone just because of the title or job position that they held. So I guess I was kind of confused at what you were asking.
Oh, sure.
I don't know if that answered.
Yeah, I was just asking if there's anyone who feels that being in law enforcement gives you some extra trustability over folks who aren't in law enforcement. So numbers 10 and 7, let's talk a little bit more about that. What about them being in law enforcement? And I understand it sounds like they're also close family members, but their positions in law enforcement. Talk about that a little bit more. Why does that give them a little bit extra trustworthiness in your eyes?
I feel like you have to move up through the ranks. Like he didn't start off as a police chief, so I feel like he's obviously trusted by his coworkers or people around him. He promoted up through the ranks.
And number 7?
Yeah, I agree. I mean, I saw him start out as a sheriff and then went into city work. And, as he went up through the ranks, he always, it was a very helpful, giving person. But he also used to tell me he was playing devil's advocate because he'd say, well, you got to think about things differently. What if this meant this? And so he taught me a lot growing up because, like I said, I've known him since I was 11. I'm 65. And it really did make you look at things a little different sometimes. But, most of the police officers that I knew that he was friends with, they were all trustworthy. I'm not saying there's not bad ones here and there.
This is a reckless driving case.
Now,
defendant is 16 years old.
Thank you for these answers. And, I think we're all kind of taught growing up that, you want to trust the police and you want to go to them when you're in a bind and things of that nature. For the two of you and anyone else perhaps who does think this way, if the state does call as a witness a police officer, does it sound like then perhaps you would lend maybe some more credibility to their testimony than if somebody who wasn't an officer were to come up and testify?
I think I would look at it both ways, but I would probably trust the police officer to have done the duty.
Okay, so she's not able to be fair and impartial. Is that what he's getting at?
Juror number 6, you talked about how back earlier in your career, it sounds like you worked with an organization or with the Attorney General's office defending Washington State Patrol officers?
Yes.
Okay, all right. Sounds good. And so what about you? In your experience, do you find that you sort of trust officers more, especially having been sort of in the grind of defending them in court? Have you sort of gained
There are a lot of wonderful people who dedicated their career to law enforcement, state patrol, and I've experienced that personally. I also, though, have seen bad apples. I'll just leave it at that. And so I wouldn't automatically take someone's word just because they were a law enforcement officer.
You kind of have to earn that trust, sounds like.
Well, I would depend on the process and the prosecutor putting on their case and you would cross-examine. And if there are issues, I would assume you bring them up.
Yeah. Well, I try to do a good job.
Yeah.
Number 9, were you raising your hand?
No.
Oh, all right.
Notice how he doesn't pay much attention
Anyone
to the
here
last
a
jurors.
true crime podcast fan?
Oh, yeah. Great question.
About
Please.
Law and Orders?
YouTube?
This man mentioned Law and Order earlier, too.
Do we have any
Numbers 10 and 11?
Recovery Addict fans?
Any John Grisham fans? Anything like that? I'll just pick on you all so much. All right. Well, let me put it another way. When you were all in the room here and myself and Mr. Wakeman, we walked in here, anyone think off the top of your head, I haven't heard the charge yet, I wonder what he did? That kind of a thought came into anyone's mind when we walked in here?
I think everyone everyone would think that. I mean, what are we here for? I mean, I think everyone felt that.
Yeah.
I wouldn't necessarily say what did he do? What is he being, charged with?
Yeah.
It's not that I automatically thought that what did he do?
All
So
right.
I think the wording there is
Yeah, and let me rephrase. It's not why are we here necessarily, but what did he do? What did this guy do? Why are we at a trial? Anyone think that? Let's talk about that a little bit. Why do we think that? Juror number 19, sounds like you were in a pretty heated jury back in the day. Do you want to talk a little bit about sort of your view of the presumption of innocence and what that meant to you as a juror?
Well, yeah, like I mean, right? You have to come in and assume that like the person's not guilty, and you have to look at all the facts. And I just felt like there was like the majority of the jury was doing that. I don't know if it was just their background. So I think that might have been something that's good, but I just didn't really do that.
Yeah, thank you for that. And that's really the cornerstone of this whole system is presumption of innocence. And so it's important when you sort of cross that threshold and you walk into a courtroom that Mr. Wakeman does have that presumption of innocence that, as Judge Wilcox mentioned, carries through the trial. And that's why I'm asking, want to ask questions about, if Mr. Wakeman doesn't take the stand, things of that nature. Are you able to sort of keep that front and center in your mind as we move forward? So I have one final question, and then we can get you all on your way today. And that's, we talked a little bit about speeding earlier, and I live around here too, and speeding can frustrate me. It seems like out of just about everything, the discussion of speeding sort of generated some strong feelings here. And so I want to talk about that a little bit. Juror number 7 in particular, you're talking about the horse trailer, I think. And so, let's say, if there is allegations of speeding or something like that, that's not necessarily part of, ultimately what you're doing, what you're judging. But if, speeding is a part of that, do you feel that sort of colors how you think about the rest of the situation?
probably.
Yeah. And anybody else? And if you were told that you have to sort of mentally put that aside, do you think you'd be able to do that, or is that something you feel pretty strongly about?
I'm pretty strong about it. Okay. Pulling a horse trailer over I-90, you see everything. And I've been in wrecks, I don't know how many times, because of people that's the way they drive.
Okay, she's out.
Okay. Thank you for that. Anyone else? I know we were talking about speeding before, right? And that is frustrating. Again, we're all out on the roads.
He's pushing to see if he can get her eliminated with for cause.
He's worked for DOT for 40 years, and he brings home all the statistics. And so when I see people driving fast, now I know the faster they go, the worse the wreck, the more people get hurt. And so I have a real issue with speeding.
And similar question to you then, if there were allegations of somebody doing one thing that was unrelated, maybe perhaps unrelated to speeding, but speeding was involved in the allegations though, would you be able to separate the speeding from the rest of the allegations?
Oh, I think so.
Yeah.
Okay, there's so many, they're going to use all the strikes.
Else? There was discussion earlier about speeding by school zones, things like that. I can't remember which juror that was. Number 9, yeah. Okay. Does that similarly, if if there's allegations of speeding around kind of residential areas, do you feel that makes you feel stronger about the outcome of that question for you?
Probably, I would be a little more concerned because there's the element of the risk there is much higher. If you're out on the freeway doing ridiculous things, which is not good either. But in a residential area or school area where there tend to be more pedestrians.
Okay, so a couple people are problematic for the defense here.
Okay. Well, thank you all. Those are all the questions that I have. Appreciate your time today, and we'll continue on here.
Free to be.
Thanks,
Welcome.
Mr. Stillwell. So at this stage, folks, you still can't
She's gonna
leave. And you can stand up and stay right where you are and stretch and whatever. And I'm going to ask you to, if you might not visit with each other, that you don't talk about the issues we talked about at all. Don't talk about anything we just talked about. And keep it low, because what I'm going to do next is have the lawyers and Mr. Wakeman join me here, and we're going to figure out the folks who qualify as jurors. And then we'll be back with you. So
the defendant
gets
to
leave.
The lawyers and the defendant gets
so
to
when
join
you're
for
ready,
this process.
Mr. Well, and your client and
Nice.
this man.
May we have just a few minutes?
Oh, sure.
Thank you.
Free to be. Good evening. Good to have you here. Thank you so much for being here. 9 months of support as well. Okay, so this is interesting. We've got a couple that are definitely out. I think the defense wants the horse trailer lady gone. I thought number 6 was going to be out, but I think the defense is now going to let him stay. He's a wild card. He's got the law enforcement side, but he's defended cops. He did not jump up saying, hey, all cops are good. He said, I've been with cops. I've been the defense guy for defending cops in situations. I know there are some that aren't true. I wouldn't inherently trust them over somebody else. You've got two jurors, I believe, who have legitimate reasons. I think it's number 8 and 9 to be excused. 8 with the 5 young kids at home, the sole parent. The 11-year-old is taking care of the kids right now while he's sitting in court. He's out the door in just a minute. 9 is a sole medical provider for someone who just came out of the hospital for treatment. I think she's going to be granted that pass as well. The back row, you saw a very experienced attorney on the defendant. You saw he showed his experience in how he listened to the jurors and paid attention more to the first, like starting at number 1. And paying less attention to the back end. I think the inexperienced prosecutor asking all those questions of number 19, we're probably not going to get to number 19, right? He's probably, statistically, I mean, look at the numbers. Each got 3 objections each. If we object to the whole front row, the middle row serves. There's like, unless the judge throws out for cause a bunch of people, 19's not going to serve. 20 is not going to serve. And so she spends half of her time questioning these last couple jurors who are just here for show. Honestly, it's like we're not going to get there. So yes, but then again, we might get that far. We have just a wealth of people who are connected with similarly charged individuals, whether it's family members or friends, somebody who has reckless driving, somebody got DUIs, lots of associates there. And also, how many of those said, oh, this was a long time ago. When I was younger, this happened. When I was in high school, my friend got charged with reckless driving. I was in the car with him. I had to testify in court. So they're going to look at this kid. They're going to find out he's 16 years old. Okay, ignore the ponytail. Okay, the kid, once they hear he's 16, he's going to look like a baby in their eyes. And they're going to be like, oh man, when I was 16, I was in high school and we were doing donuts through the parking lot and racing down the neighbor's street. And is it right? No, it's not. But I think that I think this kid has a good chance of getting off on the charge, or possibly if they'll do it, a lesser included. A lesser included, maybe something negligent instead of reckless. But interesting. So this process here, we're waiting. They're doing their paperwork right now. Then as soon as they're ready, they're going to turn around and talk to the judge. The jury's just going to sit there. The judge will excuse the people. She will probably do it all at once. So all the 4 causes, the people who the judge says you aren't eligible to serve because of your family situation. I can't. You won't be able to be here. I have to excuse you because your contract. I don't know. I think she might excuse number 20 because of the contract. I don't think 20 is going to serve. Even if we got to her, one side would have objected by that point. Of course, they're going to be out of objections. So 20. Yeah, this is going to be great. This is going to be great. Mindy Battle, great to be here. You finally got here. This is going to be a late night. Remember, we're in Washington, so you thought you were going to be going home early today. Not going to happen. Court is going to continue, and it looks like the way this is stretched on, it is going into the morning as well. So we'll be back here midday, which is when their court starts, for the second half of this trial tomorrow. Let's see. I wonder if there's a video of the pickleball biff. Yeah, while I was up in Asheville, I saw a bunch of people playing pickleball. And you guys are saying that the lawyer you know was in Asheville while I was up in Asheville. And that he's a pickleball fan. Did he play pickleball? Is there a chance that I walked right by the lawyer you know and saw Peter Tragos playing pickleball on the court and did not see the shine off his hair as he was, what do they call it, batting it back and forth? What do you call that in pickleball? Just clubbing the ball back and forth? All right. Minimum age to drive in the UK is 17. In the United States, most states are 16. Some have 15 with like a provisional license where you can drive with a parent in the vehicle and no other occupants, but only during daylight hours. And so it's like a learner's permit. It's not a full license. Okay. The gifts command, you type exclamation point gifts. 80s Music Man. Or 80s Music Man imposter. I'm not sure which one of you is real now. I know on the burner phone because if I ever need to see who's a real 80s Music Man, I can have them text me, and I know I've got it saved because I sent you a hoodie. So I know which number is yours. Yeah, we're going to have a trial. Hopefully it'll go for a couple more hours. I think it's going to probably go a couple more hours. I don't see them reaching a verdict tonight at the pace this is going. Juror number 1 is still swaying. Maybe it's a self-soothing thing. I've never seen somebody like juror number 9, who's right behind juror number, that's 7, who's right behind juror number 1. I've never seen somebody have so much of a pet project issue as that juror who is all about pulling horse trailers on the freeway and reckless drivers. Clearly, if they can't get her dismissed for cause because she had said she would not be able to set aside her strongly held opinions, if they cannot get the judge to say, yeah, we're going to release her because she's won't agree to be fair, they will definitely use a preemptive on her. Definitely. And then 9's all about the reckless driving as well. But 9's can be excused because of her husband's or family member's medical condition. So I'm thinking 8 and 9 are gone. 7's going to be gone because of a strike, if not for cause. 6 might be in.
Mr. Stillwell, Mr. Wakeman should be this guy in the case. It's all about him.
Yeah, bring your client. That is some hair. Some hair.
So, we're going to pick a jury.
Oh, it's in dreads. I didn't realize it was in dreads.
So, as I said, we've got this whole crowd, 1 through 20.
We get to hear this.
Turn back and forth with 4 cons. And the whole crowd, 4 cons. And one at a time. Don't say 3 of them. Just give me one at a time so we can make a good record. So, 4 cons.
Oh, did they mute the mic?
She said that if I allow stand, I'll get through. I didn't see any follow-up questions about that. Let me ask Mr. Stillwell.
We're cranking the volume here.
I don't think it's enough for cons. I don't agree. There isn't enough. There isn't a follow-up. She told me I could accommodate her. So I won't strike 3 for cons. Any other for cons? I just hold 2 from the state. Okay, Mr. Stillwell, any for cause? For cause, jury number 7, Your Honor.
Jury number 7, there it is.
Okay, for cause. Your Honor, she expressed speaking. Set that aside. And Judge Thurston.
She said she's not able to set aside her strongly held opinion. So they're asking for us to set 7 aside as a for cause, meaning the judge will strike them, not use one of their strikes.
Okay.
Let's hear the response from the state.
Well, I was concerned about her response. It would color how she would think, probably would. Pretty strong about it. Could she put it aside? She was not able to. Right. You're right. It is part of her personal experience. They are, but to be able to move through that and not have it affect. So I'm going to excuse 7 on cause.
7's out.
We can do this upside down. Any other for cause? Okay. One thing I wanted to step back and I should have said, I'm a little concerned about a couple of them hardships. I thought we were next. Man, I should have done it first, but I'm going to look into this. Kids.
He's a quiet whisperer. Okay, so 7 is out. 3 is not going to be excused or dismissed for cause, but 7 is. So far, 1, 2, 3, 4.
He's got an 11-year-old is the oldest. He's got 6 months old is the youngest. He's got kids coming home from elementary school. He didn't tell me he's a single dad. He didn't tell me that he had anybody else there. They're alone right now. And so if, I presume we're going to get this to a jury deliberation tomorrow afternoon, I don't want him thinking about his kids rather than your client. So I'm going to excuse 8 as a hardship.
8 has gone for a hardship. 9 possibly for hardship 2 now.
Any others, Mr. Stillwell?
Not for hardship.
Okay, any other hardship or anything that you come across from the state? Nice.
They're talking about 9 now.
I think we all pegged that right. It's just out of the hospital and an aged person. And no one there to take care of.
So 9's going to be.
Any others, Mr. Stillwell, Ms. McGannis, to hardship? 20, the work situation. It sounded like it would be substantial hardship or distracting as well. So on Friday morning, you're down there. She was part of the jury, and likely I expect deliberation will be tomorrow afternoon. And she said she'd be working into the night to be ready for Friday, and at Friday she can be there, be able to contact with her client. So, Mr. Stillwell.
Machines and plan.
Yep. Yeah, it's a close one, but I am going to excuse 20.
Okay, so 20.
I usually don't on the work exception, but this one.
7, 8, 9, and 20.
She's worried all about that and worried about preparing. She's in deliberation. I think that's going to intrude on your client's rights and the state's rights. Did I do that upside down? Thank you. It's hard to do this upside down. All right, so now I'm going to constantly turn to Ms. Garza. Just going to keep us straight. And right now, 1 through 6 is our presumed jury. So we're going to talk about preemptories 1 through 6 only, and I'll start here, go there, right here, go there, start here, go there. So first off, Ms. Mann, within 1 through 6. Number 1. Any thing to say on that? Okay. Let's sit down.
So 1's in.
6 and 10. So we're through preemptories within that crowd, Mr. Stillwell.
Yes, Your Honor. Excuse number 5.
5's out.
8.
So 1 and 5 are out.
Then it's preemptory 1. Because it's 11. 11 is man. 3.
3 is out. So 2's serving a penalty.
All right, Mr. Stillwell, we're through 12 within that crowd. preemptory.
6 is out. He's the AG guy.
13 is man. State's fine, Your Honor. Accept that man. Right, Mr. Stillwell through 13. That's your last preemptory. Yes. All right, so now we do have room for an alternate, and the alternate would be 11. Does the state have any preemptory as to? Well, wait a second. Let me make sure. 2, 4.
2, 4.
Thank you. So 14 would be our presumed jury. So 15 would be our. Yes. Let me count my 1. Okay, 15 would be a potential alternate because the state had any preemptory exercise there.
15 is the alternate.
Okay, Mr. Stillwell, 15 is an alternate.
Okay, we've got our jury. Look at the lawyer's desktop. Look at his screensaver. He's got like 2 hot rod cars on his laptop. You see this?
So we got a jury.
The defense side. We have our jury.
Garza. Tell me who.
2, 4, 11, 12, 13, alternate 15.
2, 4, 11, 12, 13, alternate 15.
So what we'll do next, so we'll just kind of logistics. So I'll be letting all these folks know. We'll get them into the jury box. They'll give them about 15 minutes of instruction. Let's see, it is 3:30. Why don't we do openings, 10 minutes apiece, get those out of the way. I'd like to start. I'd like to have everybody back tomorrow at 8:30. It's usually 9, but let's all be back at 8:30. I'd like to make sure we don't have Snowmageddon. I don't think it's going to happen, but just in case. And then, if there's anything we need to take up before the jury, I can't imagine why, but if there is something, we've got a little time, and I'll have these folks back by as well. We can get going with your case and see where we are.
We brought the evidence to be
Hallelujah. So make sure all your witness is ready to go. 8:30, just in case. All right.
We elected not to have it marked before beginning because the jurors were already in the room.
I understand.
Okay, sorry.
Thanks. Yeah, we didn't expect that. All right. Yes. The packets, everything. You don't get to keep anything. It's all shredded, so if you made notes, it's gone. All right. Have a seat. Get the jury's lined up and we'll do openings.
Okay, here we go.
All right, folks, thanks for your patience. We picked a jury, and let me, everyone served your duties, so you don't have to call back. You served. Thank you very much on behalf of Thurston County District Court. But folks staying with us, let's see, Juror 2, you're staying with us. Juror 4, you're staying with us. Juror 11, you're staying with us. Juror 12, you're staying. 13, you're staying. 14, you're staying. And 15, you're staying. So, Ms. Garza will get those folks who are staying, but the rest of you, just grab up your personal belongings. Thanks again. You've served your duty. Have a great rest of the week.
Horse Trailer's a little mad that she didn't get to stay and participate in this.
Spin yourselves around and
do the hokey pokey.
Oh, yeah.
You guys, I love that. I love that we got to be involved in all those parts there.
Maybe the lawyers can hand me your jury packets and everything. We can make sure we don't forget.
I think I'm going to put that. Okay.
Look at the defense lawyer's computer right there. He's got like, what is that? Those Ferraris, Lambos. I don't know. He's got some racing cars on there. Most of the back rows dismissed only because we didn't get to them. I'm surprised the state used a preemptive. Right? Did I say that right? Is it preemptive or preemptive? I always get it wrong. But they used one on like number 19 or something.
Right. Just keep yourselves in order. Just a 15.
Okay, so the jury's taking their places. The people now in the background are not alternate jurors. I mean, they could have been jurors, but those are just members of the public. They're probably family members or friends of the defendant from where they're sitting in the courts. They're for support.
There we go.
Yeah, tomorrow we're going to have opening statements today from the two sides, which will be half an hour.
I just want to know if we need a break. Because what we're going to do now is I'm going to give you some instructions, more information about all of this and where we're headed. We're going to hear opening statements today, and then we're going to recess and come back tomorrow morning at 8:30 to hear the state's case in chief. Need a break? Need something to drink? So that's going to be probably 20-40 minutes. Okay, let's soldier on. So I'll have you all stand up with me. I'm going to pitch under oath to my jurors. A little different oath. So raise your right hand with me. You all solemnly swear or affirm that you will fairly try the issues in this case according to the facts that you find proved and the law as I instruct you. Each take that oath?
Yes.
Yes. See you all saying yes. Thank you. Have a seat. All right. So this is your chair for the next day or two. And let me explain the procedure that we're going to go through, what happens first, second, and third.
This is a reckless driving case.
First off, the prosecuting attorney, Ms. Mann, will make an opening statement outlining the testimony that she expects to present to you, witnesses she expects, evidence she expects to present to you. And then Mr. Stillwell, the defense attorney, may then make an opening statement, or he may reserve it or save it for later. So we'll find out. After we hear the opening statements today, like I say, we're going to take a break and come back tomorrow to start the state's case in chief. But tomorrow then the prosecuting attorney, Ms. Mann, will then present the testimony of those witnesses, that evidence. She'll present all that to you in her case in chief. When she's finished, then the defense attorney, Mr. Stillwell, may then, but remember, need not, present testimony, witnesses, or evidence to you. Now, each witness who testifies is going to be seated right here, and they may be cross-examined by each side. That's proper. If someone presents a witness, the other side gets to ask them questions too, back and forth. After we get all of the evidence is presented and all the witnesses are heard from, that's when I will give you the instructions as to the law. Now, I'm going to do that in writing. You'll each have a packet of information, and one of those packets at least will go with you into the jury room, so you'll have it. But I'll instruct you as to that. We're old school. I'll be reading it to you. You'll have a copy. And then after I give you instruction as to law, then the lawyers will give you closing arguments. Now remember, that's opening statement versus closing argument. So that's when the argument happens from the lawyers. And then finally, after closing arguments, then you'll be taken into the jury room, which you'll find is right behind that door. Pretty big room. And that's where you will deliberate on this case. So it always says bailiff here. Superior Court gets all sorts of folks like clerks, bailiffs, reporters. We get Ms. Garza. She's everything. So she knows what she's doing. So anyway, you get taken into the jury room by Ms. Garza, where you select a presiding juror. Of course, the presiding juror will preside over your discussions about this case, which are called deliberations. And you'll then deliberate in order to reach a decision, which is called a verdict, whatever that decision is. And until you're in the jury room for those deliberations, you shall not discuss this case with each other or any of the issues with each other, right? Not until I say you're in deliberations, go to it. Not until then. On breaks, when you're in there, over lunch, anytime. You shall not discuss the case with each other, the issues in the case, or with anyone else. So you got family and friends, they're going to say, hey, cool, you got picked for a jury. Tell me all about it. And you're going to say no. Can't tell you under court order, tell you later, because I will relieve you of this, and you can tell the world in any way or not later when we're done, not now. And so I caution you, social media, don't go to whatever you use and say, this is what I did today. I was in jury duty. Because guess what happens? You've now very innocently violated your oath to this court, because the whole world will go, oh, okay, they live in Thurston County, Olympia, let's look that up. There's that case. Oh, let me look up all the people in it and send all this information to you. Who knows if it's right, wrong? Who knows what it is? It's not the evidence of this case. It's not the law in this case. So don't do that. You're going to have to kind of go social media silent on what you're doing today and tomorrow, as long as you're in court. So, and other folks like family, friends, social or co-workers, you know, you see in person, talking with them, whatever, just tell them, can't tell you yet, can't tell you, under court order, tell you all about it later. And you never have to tell anybody about what you're doing. You know, you're not under any obligation, but if you want to, it'll happen pretty quick. So just wait. And then let's see. So of course, I think this is funny. These were written by the Supreme Court, and I always laugh about some of these things when we talk about blackberries. I think my brother is the only one who has the last one in the nation. But no discussion means in any way, emailing, texting, blogging, any kind of social media, any in-person communication, any way you communicate, that's discussing the case. So just don't. So because it's your duty to decide this case based on facts presented to you during these proceedings, during this trial, and only that evidence. So evidence is a legal term. What does it mean? It just means witnesses who are talking. It means documents, physical objects, pictures, videos, audios. That's evidence. Stuff that is presented to you to help you decide, make a decision here, make a verdict. So again, it's also your duty to accept the law from my instructions, as I've said a lot today, regardless of what you personally think the law is or should be. And then you're to apply the law and my instructions to the facts that you find proved. And in that way, then you decide the case. So again, the only evidence you're to consider consists of the testimony of witnesses, the exhibits that I admit into evidence. What that means is I allow to go to you. I admit it. You get to see it, you get to use it, you get to review it. So when witnesses testify, as I say, they'll be right here, and you don't see a stenographer. It's not TV where they say, well, will you read that back to me? Not happening. So, and it's frustrating. But, you know, this says rarely will, if ever, will testimony be repeated for you. I'm telling it, it won't be. So if you can't hear something, if you can't see something, let me know. Raise a hand. Again, what? Didn't hear it, didn't see it. Let me know so I can make sure you get that information. So anything that I allow in, any evidence that I allow to be seen by you admitted, will go with you into the jury room, and you'll be able to see it more fully, but you'll also see it during proceedings. But you'll see it during your deliberations too. So the lawyer's remarks or statements or arguments are intended to help you understand the evidence and to apply the law in my instructions. However, you have to understand that the lawyer's statements are not the evidence nor the law. The evidence, again, is the testimony of witnesses, the exhibits. The law is contained in my instructions to you. That's what the law is. So you must disregard anything the lawyer says, and there's conflict with the evidence and the law and instructions. You're going to hear objections made by the lawyers to maybe another lawyer's question, and that's completely proper. Each party has the right to make those objections, may have a duty to make that objection. I'm just asking, don't let these objections influence you in any way. Don't draw any conclusions. Don't make any assumptions about these objections. And one of my duties as the judge here is to decide, again, whether evidence is admitted or allowed for you to see. That means I must decide whether or not you should consider it or not. And I'm using case law, I'm using court rules, I'm using all of those things that that are put down by in the state of Washington laws. And so, for example, if a party offers a photograph as an exhibit, and I then have to decide whether it's admissible or allowed to be seen by you. Don't be concerned about the reasons for my rulings. Again, don't draw any conclusions. Don't make any assumptions about my rulings. Don't discuss or consider any evidence that I don't admit, or if I tell you to disregard something, don't disregard it. And again, our state constitution, Washington state constitution, prohibits me, I'm the trial judge, from making a comment on the evidence, because it's your duty to do that. It's your role to evaluate the evidence. And so it'd be improper then for me to express by words or action in any way my personal belief or opinion of the weight or value of evidence. Now, I'm not going to do that. I will not intentionally do that. But if you think I did, you disregard that entirely. It's your role, and I'm not in your toolbox. Okay. So,
the jury's off to the right of the screen here. Off to the
so
right
you're
by
allowed
the
to take
podium.
notes if
Opposite
that
me.
helps you. And we'll give you a pen and paper. What I'll ask you to do is those notes don't leave the courthouse, and off to lunch, we're going to grab them up, put them in a safe, secure spot, and scores, and we'll do that. So the first page, I would suggest to make some sort of pretty picture or initial or something that tells you that's your notebook. And then after that, do your notes, if you decide to do notes. And whatever you do with notes, just make sure it doesn't interrupt your ability to watch this witness, evaluate the credibility, because that's your job. See all the evidence. Just don't let it get in the way of that. And at the end of the day, and at the end of this trial, when we're all done, no one will ever see those notes. They will be shredded. They are not public record. And again, don't discuss your notes with each other. Don't discuss your notes with anyone else. Don't show them to each other. When you get into deliberation, then it's all wide open and you can share them, but not until then. And also just don't assume that your notes are necessarily more accurate than your memory. Again, I'm giving you that opportunity to make your own notes if that's useful to you, to remember clearly, but not to substitute for your memory nor the memory of your fellow jurors. Keep that in mind. So again, what else goes on? Throughout trial, you'll go directly from that jury room.
Did you say a couple? Oh, I'm just going to move on.
So what'll happen tomorrow morning, and we'll get you oriented. You probably have no idea where you are right now. But you'll come in through security into the public area. So if there's something you don't want to have a hassle with the security, leave it at home or somewhere else. But you'll come through security, and as far as will find you, she'll get you into the jury room through a different door. And that's where you'll stay until we're ready to get going. And try very hard not to have too many pauses and very long pauses. I want you to have the best use of your time you can. Some things are unavoidable. You never quite know what's going to come up. But you'll do that. So you'll never come into this courtroom unless you're escorted by myself or Ms. Garza. Never come into this courtroom. Don't come in through that public access. You'll go into the jury room, you'll stay there. Only when Ms. Garza or myself bring you in are you allowed in. That allows you to, there's lots of things that happen that have nothing to do with the evidence and testimony in this case. And so we want to help you steer clear of anything that would be unfair. Obviously there's public restrooms out there, there's public areas, and I've instructed the lawyers here, and they're not surprised by that. They're not to have contact with you throughout this trial. After it's all over, everybody can talk as much as they want or not. But now, and they are policing their witnesses, their people shall not have contact with you either. Try not to put them in a spot that they need to talk to you. I mean, they'll seem rude. They won't open the door for you. They won't tell you where the restroom is. They won't tell you where to have lunch. Don't put them in that spot. They'll have to be rude. So they're under my orders. And then, because it's essential to a fair trial that everything comes to you while we're in session here in this courtroom, don't allow yourself to be exposed to any outside information or people in this case. So I'm going to ask that when we're on break, anytime that we have a little recess and we're going to be in and out to talk, you'll be in the jury room. But at lunch, you're going to be off on your own into the world, and then you're going to come back. And I'm going to say, do not stay in this building unless you're in the jury room. You can stay there and have your lunch, but don't hang out in the public areas or close to security or anything, because then you're putting yourself in a spot that you may overhear things that are not the evidence or the law. So best just to clear out and then come back. if in fact something happens out in the parking lot, on your way, something innocently happens, and you see something that you think you shouldn't have seen, or you hear something that you shouldn't have seen, don't discuss it among yourselves. Let Ms. Garza know. We'll figure it out. We'll see if anything really needs to be done about it. So I'm going to ask you for now, if you can, this trial, I don't believe is going to go on a long time. It's done. You know, you decide when we're done with the deliberations, but I think the evidence is going to be into you by tomorrow, certainly. Until you're dismissed at the end of this trial, I'm going to ask you to kind of avoid things like the movie that was mentioned, things about, you know, newspaper, magazines, blogs, social media, internet, radio, television, broadcast, anything. I'm not saying that this is any more newsworthy than any other case that I preside on, but don't seek out information about the people involved in this. Don't seek out information about the issues, the definitions, the law. You know, keep yourself, maybe you watch some nature shows for the next 2 nights, you know, not Law and Order, not CSI, that sort of thing. And don't try to determine what the law is. Don't look up anything in any research, any kind of research, old-fashioned, internet, anything. Don't do any research about people, issues, law, definitions, none of it. Just leave it be. We'll give you all that. You're going to be told in opening where this is likely to have occurred. And you will not go there to investigate. If in your travels home tonight or through lunch tomorrow, that's somewhere that you naturally pass through, you'll keep passing through and give it no more attention than you would have on Monday. Right? So we can't have you have any electronic devices, laptops, you know. And now we all sort of forgot, but we all have, well, I don't, but we all have smart watches.
She doesn't.
Those are a problem. So those can't be in the jury room with you and can't be in court during session. We can't have you have the ability to look things up outside of the evidence and law.
And there's one more big one.
So maybe you go to the old analog, your grandma's watch that you have still. Put that on for tomorrow. Your grandfather's pocket watch. Who knows if you need a watch? But we're going to take your phone, any pads, laptops, anything you bring that allows internet access. We're going to take that away from you while we're in session. You get it back at lunchtime, and then you give it back once you come back. And during deliberation, you don't get to have it. Now, that's our only way to communicate with the world, and we all have people we need to let know what's going on and when we're going to be available or not. So if you need to be in touch with someone, we're going to make that happen. So just let Ms. Garza know, I got to call my partner, I got to check on the kid, I got to call my boss, something. Give you the phone, take a break, and you can give them a call and figure that out, and we'll take it back, put it in safekeeping. Not going to keep it overnight, not going to keep it during lunch, but while you're in session, while you're in the deliberations. So if you don't want us to have your watch, find another way to tell the time. And there's a clock in there. Right. And again, after all this is over and I release it from this, you can do and talk all the research you want, all the talking, all the investigation you want. So you'll be able to do that if you want. So we're just asking you to keep an open mind. Don't form any firm or fixed opinion about any of the issues in this case until the entire case has been submitted to you and I say you're in deliberation. That's the time to start forming those opinions. Again, your officers are my court, and thank you very much for doing this job. We can't give you nothing. And I appreciate that we're taking you out of your day-to-day life and expecting something kind of unusual and kind of big for you to do. And I really appreciate the broad shoulders that you're bringing to do this hard work. So we're asking you to reach your decision based on the facts proved to you, the law that I give you, not on sympathy, not on prejudice, not on personal preference. We ask that each party, both sides, to get a fair trial We're asking to act impartially with that earnest desire to reach that proper verdict in this case. So a couple of just things as we be clear, there's no smoking. That's a really old instruction, but there's no smoking. If you're a smoker, we're not going to make you go cold turkey. That would be horrible and mean. We're not doing that. If you're a smoker, we're going to make sure you get those breaks. So don't panic. Again, no electronic devices. You'll get, do they get another number, another juror badge? Okay, you'll get something that says you're a juror, and that helps you get kind of more smoothly through security, and everybody knows who you are, and also kind of blazon says you're a jury, so people peel away from you. This is a public forum. Doors are unlocked. Front doors are unlocked. We have in America public trials for purpose. So people will be coming in. People will stay. People will leave. You will also see uniformed folks, whether they're law enforcement or security, and they do it all the time. Nothing's wrong. They'll let us know if there's something wrong, but there's nothing wrong. They rove around and make sure everything's going okay. Try not to let all that distract you from anything. And again, if you need anything, if you want a break, I am not going to ask you, why do you want a break? I'm just going to say, okay, we're taking a break. So you don't have to tell me if you need a drink of water, you need a snack, you need a potty break, you just need a break. Had enough. Need 5 minutes to collect yourself.
Hey, Stephanie, I'll give you a link to it. Just 1 second.
So just raise a hand and let me know. I want to take good care of you. All right. So at this stage, we're going to turn to the attorneys. We're going to hear opening statements. First, Ms. Mann.
Hey, Stephanie, here's a link in chat for that game. Right there. That's the Amazon affiliate. Opening statements from the prosecution right here. We're almost done. We got about 20 minutes.
Hello again, everyone. Thank you for so patiently sitting through all of this. As Judge Wilcox said, this is going to be my opening statement where I explain the story and the evidence that I think you'll hear as this trial continues tomorrow and what you can expect. You're going to hear testimony from Deputy Dustin Leishman with the Thurston County Sheriff's Office that on September 12th, 2023, he observed a vehicle being driven in a way that immediately grabbed his attention in Thurston County by the defendant, Russell Wakeman. Deputy Leishman will tell you that while he was on patrol in Thurston County, he observed a vehicle speeding, that he observed the vehicle fishtailing and swerving, and that he then watched the vehicle run a stop sign and continue speeding onto a residential road through a residential neighborhood. That in that neighborhood, the vehicle sped by structures where children and other pedestrians often gather, like playgrounds, baseball fields, and a basketball court. Deputy Leishman will tell you that after seeing this, he attempted to catch up with the vehicle. But the vehicle was traveling fast enough that even when the deputy was traveling 40 miles per hour, which was 15 over the limit, the vehicle was still pulling away from the deputy's car. He'll tell you that before he could catch up with the vehicle, it made a hard right turn into a field and performed a maneuver that is commonly called a donut, where the car spins around in a circle, before once again leaving the field and speeding off. Deputy Leishman will tell you that the vehicle was driving so fast that he was only able to catch up to it several blocks later at a nearby intersection, where the vehicle finally stopped and Deputy Leishman was able to make contact with the driver, who was identified as Russell Wakeman. You will see a map of the neighborhood that Mr. Wakeman sped through, and you'll be able to see where the playground and the sports fields are on that map. You will see a video of Deputy Leishman's dash cam, and you'll have Deputy Leishman to explain what's on that dash cam video and what's not on and why. And in that video and in a picture that the state will present, you'll see a picture of the road that Mr. Wakeman sped through and how close that road was to houses and playgrounds. At the conclusion of this trial, I'm going to come back and ask you that you find that the evidence of Mr. Wakeman speeding, swerving, running a stop sign, doing donuts, adds up to Mr. Wakeman being guilty of the crime of reckless driving. Thank you.
Mr. Stowell, would you like to give an opening now?
Yes, Your Honor. Thank you.
Okay, go ahead.
Okay, I would be guilty of this crime, I'm pretty sure.
Good afternoon, members of our final jury. Again, my name is Jake Stowell, and I'm Russell Wakeman's attorney. A little bit about Russell. He's a 16-year-old at Rainier High School. And on the afternoon of Tuesday, September 12th, he was driving home in his mom's 2008 Toyota Prius. And you're here to decide whether or not he committed a crime. And in deciding whether or not Russell committed a crime, you get to watch the dash cam video from the police officer in this case. And that footage is important for 3 reasons. Number 1, officer perspective. Right? You get to see for yourselves the incident from the police officer's point of view. And that for the less than a minute that this incident took place, he was on a different block, on the other side of a busy city thoroughfare, and with his view obstructed during important moments. Number 2, Russell's driving behavior. You'll get to see for yourself Russell driving in a straight line down a straight road on a clear afternoon. And number 3, the absence of people or property. You'll see for yourselves a clear view of the empty roads, empty sidewalks, empty gravel parking lot, an empty field next to that empty gravel parking lot where Russell was driving. In short, you're going to see for yourselves from the officer's dash cam video the lack of evidence that Russell committed a crime here. And after reviewing those 3 things, the officer's perspective, Russell's driving behavior, and the absence of people or property in harm's way, I'm confident you'll return a verdict of not guilty. Thank you.
All right, so we're going to.
I was not
take a
expecting
break
Prius.
until tomorrow morning. We're going to come back at 8:30. I want to go back at 8:30 so we can get going. I know I just harped on you, but I get to harp on you again just about this recess. So this is a recess, and we're in session. Even though you're going home, you're still in session. You're still officers of this court. You're still on this jury. You're still on jury duty. So everything I said, remember all that, but just have to underline, don't discuss the case among yourselves, don't discuss this case with anyone else. Remember, when people ask you,
as the judge is going
tell you all
on,
about it later under court order.
let me just say,
and remember, don't go report to the world on social media that you got picked for jury, because all of a sudden,
this case needs an epic thumbnail for tomorrow.
We're going to have to.
We
What
need an
happens
epic
then
thumbnail.
is ugly. You may, certainly a kind heart.
I'm open to
No malice,
submissions
but all of a
for the
sudden,
thumbnail.
You violated your oath, all of a sudden you have a mistrial, all of a sudden everybody has to go through this all over again, other jurors, and this is a very stressful situation to be in for everybody, and let's just do a one. So, all right. So don't go to social media. If anybody asks you about it, you know what to say. Don't allow anyone to give you information about this case, come to you with information about this case. Remember that the parties, their witnesses, all of that, they're going to ignore you. They're going to be rude to you. They're not allowed to be in touch with you. And don't put them in that spot. Don't ask them questions, all that. If you start to overhear any discussion about this case or the people in this case or the issues in this case, pull yourself away from that. Don't discuss it among yourselves. Come to Ms. Garza, tell her what happened, and figure out what to do, if anything. And then just try for now to keep yourself away from the issues that we're talking about, reckless driving, things like that. Like I said, nature shows are great. I love them. But, something other than, if you're buying shoes online, that's great. If you come across something online about this, maybe pull yourself away, or something associated with this. Pull yourself away. Don't conduct any research. Don't go to where this is alleged to have occurred. Don't look up any words, any law, anything. And just
don't look up the top speed of a Prius or its acceleration rate.
Information so that everything comes to you here while we're in session and you can understand my instructions. So, all right, 8:30. Ms. Garza, how do you like to do it tomorrow morning? But what will they expect? They'll come through security and you'll be there? Okay. And then you'll get them into the jury room, and then just kind of look through Ms. Garza. She'll get you in there, and then we'll get started soon thereafter. Any questions logistically from anyone of you today? Okay, I put you in Ms. Garza's hands. Thanks. We'll see you tomorrow at 8:30.
All right, guys. There we have it. We have a Prius. I want to rewind just a little bit because we need to do this. Let's see if there's anything to address really quickly before everyone leaves. But yeah, I was expecting something more than
Sit down. down. So,
Prius.
8:30, so we can get going. And anything to take up now, Mr. Stilwell?
I'll just be marking defense exhibit. Oh, although it looks like it's already been marked. No, Your Honor.
Okay. Ms. Van, anything? Getting things marked, is that really just what we need to do?
No, Your Honor.
Okay.
That's the
All right, just
43-second
trading
video.
information. Great.
Thank you.
Dash
All
cam
right.
video.
You don't need a copy.
Okay.
You already.
Yeah.
So don't have to do this.
Okay, so we'll see y'all at 8:30.
Thank you, Your Honor.
Thank you, Your Honor.
Folks.
Okay, so hold tight. We need to back up to Prius.
I want to take good care of you.
Let's see. Where was
Right,
this?
so it's
We've got people up right here. Okay, let's see. Was this the one?
Ms. Van?
Okay, we're going to listen one more time as we hear these charges, as this horrendous crime is spelled out in graphic detail before this jury. Jury of 6
Hello again,
plus 1.
everyone. Thank you for so patiently sitting through all of this. As Judge Wilcox said, this is going to be my opening statement where I explain the story and the evidence that I think you'll hear as this trial continues tomorrow and what you can expect. You're going to hear testimony from Deputy Dustin Leishman with the Thurston County Sheriff's Office that on September 12th, 2023, he observed a vehicle being driven in a way that immediately grabbed his attention in Thurston County by the defendant, Russell Wakeman. Deputy Leishman will tell you that while he was on patrol in Thurston County, he observed a vehicle speeding, that he observed the vehicle fishtailing and swerving, and that he then watched the vehicle run a stop sign and continue speeding onto a residential road through a residential neighborhood. That in that neighborhood, the vehicle sped by structures where children and other pedestrians often gather, like playgrounds, baseball fields, and a basketball court. Deputy Leishman will tell you that after seeing this, he attempted to catch up with the vehicle. But the vehicle was traveling fast enough that even when the deputy was traveling 40 miles per hour, which was 15 over the limit, the vehicle was still pulling away from the deputy's car. He'll tell you that before he could catch up with the vehicle, it made a hard right turn into a field and performed a maneuver that is commonly called a donut, where the car spins around in a circle, before once again leaving the field and speeding off. Deputy Leishman will tell you that the vehicle was driving so fast that he was only able to catch up to it several blocks later at a nearby intersection, where the vehicle finally stopped and Deputy Leishman was able to make contact with the driver, who was identified as Russell Wakeman.
Okay, so we're going to skip ahead.
You will see a map of the neighborhood that Mr. Wakeman sped through.
We're going to see all that. That's going to be great. But now we're going to get the defense turning up because this is just incredible. Okay, where's he at? Right here. Is this it?
Effective. Russell's driving behavior.
Okay, let's jump back a little bit.
Toyota Prius.
Oh yeah, here it is. Here we go. A few seconds back.
A stop sign, doing donuts, adds up to Mr. Wakeman being guilty of the crime of reckless driving. Thank you.
Okay, hold on, guys.
Would you like to give an opening now?
Yes, Your Honor. Thank you.
Okay, go ahead.
Let's pay attention to the key facts in this case. First, the age. I love how he hits them first.
Good afternoon, members of our final jury. Again, my name is Jake Stillwell, and I'm Russell Wakeman's attorney. A little bit about Russell. He's a 16-year-old at Rainier High School. And on the afternoon of Tuesday, September 12th, he was driving home in his mom's 2008 Toyota Prius. And you're here to decide whether or not he committed a crime. And in deciding whether or not Russell committed a crime, you get to watch the dash cam video from the police officer in this case.
Sorry.
And that footage is important for 3 reasons. Number 1, officer perspective.
All right.
You get to see for yourselves the incident from the police officer's point of view.
Okay, so we're going to stop right there. We have a 2008 Toyota Prius. I wish we had a model we could do some tests on. I would love to see a 2008 Toyota Prius fishtail down a road in a neighborhood. Even though we're going to hear he was driving in a straight line and then perform a donut after taking a hard right turn and then back on racing again. Imagine the wheels. I mean, the wheels on a Prius, I believe they're the same ones that most wheelbarrows come with. It's a little tiny skinny wheel. There's not much to it. Wow. This is going to be good. I hope we get to see the video. I'm really hoping that they play this and we get to see the whole thing, because this is bad. His mom's 2008 Prius. This kid is literally, he's missing his algebra class to be here, right? He's missing algebra. He's probably going to be behind in English as well. He's in high school. He's driving home in his mom's 2008 Prius. How long do those Priuses, do the batteries, I mean, don't they like after several years doesn't sort of lose a lot of its oomph? It's like the battery just doesn't hold much of a charge anymore. Red Pen says, check the burner phone. I found the car. Found the car. We're going to do a quick check here. Let's see. Burner phone is going nuts. Ooh. I cannot show this, Red Pen. I cannot show that. Let me just make sure. I can't show this one. Red Pen, there's no way. This has content that have you read all these? She's got a picture of the back of a Prius that is completely plastered in bumper stickers. One of them is you just got passed by a girl. I love not turning on red. Sorry. I'm already taken by a super talented graphic artist. Huge financial burden on board. I eat sand, like just a little, sometimes as a treat. I pledge allegiance to the swag. Honk if you honk. There are some I can't read. My snake is better than your human child. Death before decaf. It's got a picture of a possum, a raccoon, and a skunk, and it says, support your local street cats. Caution, bad at math. Another one, I'm speeding. This is a Prius. This is the back of a Prius. Follow me to Dunkin' Donuts. Those are the ones I could read, Red Pen. I'm going to need a different picture. We're going to make an epic thumbnail, I think, for this, because tomorrow the case is going to continue 8:30 in the morning. But it's going to continue. Oh, no National Hot Rod Association sticker, apparently. They didn't have room. That must be on the hood. I'm thinking next to the racing stripes. Here's the one question I have to ask. We know one witness is going to be on the stand. That's going to be the officer who pulled him over. And I just want the defense to say, what kind of car were you driving? Officer, what vehicle were you in? And he's going to say something like, well, I was in a Dodge Challenger, or a what vehicle do the cops drive up there in Thurston? What's their go-to police vehicle that can't catch up to a 2008 Prius in 4 blocks? A Mustang? I don't know. It's wow. Oh, man. The case is going to be a blast. It's going to be quick tomorrow, I think, but it'll probably take most of the afternoon with verdict watch and everything. So we'll get the verdict music in tomorrow. That'll be exciting. He was in a horse and buggy. He was on horseback. He was on foot. He was driving a Segway. There's lots of great answers in here. Officer was in a Hellcat. Oh, man. A Chevelle with a big block. Whatever he was driving, there's like this is the worst vehicle to try to outrun the police in. And this officer couldn't catch up to him for like 4 blocks. He was pedal to the metal, 15 over the speed limit, and the Prius is still pulling away. He's losing him. He's like, can you go send the chopper? I think we're going to lose this guy if we don't get some eyes on him. Yeah, this is like a high-speed chase that never happened because he was in a Prius. My mom had a 2008-ish Prius Robin's Egg Blue. Oh, my goodness. I was so glad they got rid of that car. It looked like a giant blue egg. Yeah, this guy's already got all sorts of cool points driving this to and from school. Oh, man. A Segway with the flasher. The cop was in a 2005 Prius. Let's see. I think this officer might not like dreads. Apparently, it's really easy to swap out engine to a normal Toyota engine since it's basically just a copy. So they can put a real engine. They take out the gerbil wheel and put a real engine in that Prius. Carolina L says, the other guys, Mark Wahlberg and Will Ferris, Will drove a Prius. Mark made fun of him so bad in the movie for his Prius. I haven't seen the other guys, but that sounds hilarious. Let's see. My husband's a mechanic for Dodge, which most of the cops drive. I am embarrassed for the company right now. Seriously, they need to ask him, what was your police vehicle? What vehicle were you in? Yeah, this is going to be good. Cynthia says Thurston Sheriff vehicles are SUVs. So that's going to be most likely an 8-cylinder. You're looking at 6 or 8. Either way, you've got a Prius beat. Man, the only way that would be worse would be a Kia Soul. Oh man, it's going to be great tomorrow. Here's my prediction. Let's put this all out on the table. Because of the motion in limines which we got to hear this morning, specifically the statements made by the defendant to officers on the scene when he was arrested, when he was pulled over. I'm not sure if he was arrested, when he was ticketed, when he was stopped. Because of the statements he made on the scene, I think he can't testify in his own defense. Really, all he needs to say is Prius. I mean, for the defense, all they need to do is just throw the fob on the witness stand and say Prius, and then say we rest our case. But I think that in this case it would not be wise for him to get up and say anything because there are statements he made to the police. Currently, they're not eligible. But if he gets up and testifies in his defense, then on a rebuttal, the state's going to get up and say, we would like to rebut because he has made a prior inconsistent statement regarding what happened. And his story today is not the same as the story when we stopped him. And you tell me which one was the truth. Oh, man. All right. Cop cars have enforcer chips. They all fly. Cops taking 4 blocks to catch up with him is embarrassing enough. Yeah, this officer is going to have to testify on the stand about that. This is going to be good. I trust that defense attorney to keep him off the stand. I believe he will. With the knowledge that testimony is only going to come in if, I mean, that was a huge win. That's a huge win to keep his admissions of guilt out of the trial. There's no way he can testify in his own defense. So we have watched the motions in limine. We got to watch the voir dire, as some people like to say. We got to watch all the jury selection. We got to hear the elimination of juror members, which we've never been able to hear on our live stream before. That was amazing to hear the different jurors got excused either for cause or for hardship, or for the strikes from either side. We got to see all that. So a jury's now impaneled. There's 7 people total, 6 deliberating, one extra, 1 alternate, and trial is going to be back tomorrow. So it's late. You guys stayed late with me tonight. I appreciate you guys doing that. We're going to start at the regular time, about 9:15 tomorrow. We're going to have a little bit of fun together on Thursday morning as we wait. This will be our main trial for tomorrow, although there is another big trial starting. So I realize we're starting to get to the other big trials, and we're going to have a big trial here soon, probably next week. But we're getting there. You guys hang in there. I appreciate your patience during this New Year lull period. Someone put a Hellcat in a Prius for drag racing. That's just not that's not right. Okay. I think that's it. I think we're good. This is going to be a fun case. Where's the Prius in front of the cop car? The Prius in the cop car. All right. Either way. Let's go ahead and wrap things up tonight. I think we've covered everything we need to. If I didn't, we'll cover it again tomorrow. Always got tomorrow. Oh, man. Alicia says, thanks for the belly laughs. Horses are laughing, too. Gail Pet, peace out. Thank you very much. Thanks to all the amazing mods. Thanks to the great people here. We had a bunch of new people join today. Thank you. Great to have you here. Hope you enjoyed what you saw. We'd love for you to come back and enjoy court with us tomorrow. Sometimes we follow small cases like this. Sometimes we follow big cases. But we've always got something fun going on. And it's usually a really fun and friendly place to talk about whatever is happening. So it's late. Get some rest tonight. It's going to be a doozy tomorrow. We get the verdict music tomorrow. Do you guys want a taste of the verdict music? Hang on. This is the verdict music. Ready? Yeah, we'll get to hear this tomorrow because I think this jury is going to be really quick in deciding what's happening. But we'll go back to our regular outro right now. Just wanted to give you a little taste. Gilly Davis, thanks for clicking on the subscribe button. I appreciate that. If you like what you see here, click that subscribe button. Ring the bell so you get notified every time we go live. As always, first person in chat every time we go live wins the internet. Where else can you win the internet? Nowhere, I would say. Nowhere. This is the only place. So it's going to be fun tomorrow. Thank you very much. Tonight, when you go home, please hug the people you love. Smile at someone, make their day just a little bit better, and please stay safe till we go live again. It will be, I'd say 9:15. I think 9:15. Let's do that. 9:15 tomorrow. So, and then we'll have a little bit of fun. We might have some little catch up on some cases, some document work or something like that until we bring this case in at 11:30, which is when it starts in Washington, because we're on a West Coast trial now, and they're delayed. The sun sets later than it does here, so a little bit of a delay. Bring it with the verdict. I'm ready. I apologize. I didn't say it was going to be a one-day trial. I think all in all, it would have fit in one day had we started earlier. But we'll stretch it over 2 days just for the court. I think that's everything. Checking my notes. Oh, I've got this. Oh, I need to say this one more time. I've got this thumbnail we need to make. If you want to design a thumbnail or make a suggestion, go ahead and send that to me in a text. It has to be in a special format. It has to be 1920 pixels by 1080 pixels, less than 2 megabytes if I'm able to use it. Otherwise, I'll have to recreate it or my version of it. So meme type thumbnails are also welcome. Let's see your best creativity. Have a good night, you guys. We'll see you tomorrow. Be good to each other. Bye-bye.
Have them send someone with more experience.